whole of the province will be governed over the next 4 years by an irregularly appointed provincial leadership. And then it went on to deal with this. I just want to stress the analogy to say two things. One is that we know that when we're dealing with the preliminary issues, the court has to assume that we're correct on the merits. And that's why the court articulated it like this. If it turns out that what is true, it didn't mean that it was true, but it had to be assumed. And secondly, it said for the whole time, the province would be governed by an illegal government, as it were. Same thing here. We're saying if it turns out that we're correct, then the rest of the commission will proceed on the basis of an illegality and a patent bias, if we're correct. And it said that paragraph 18, the appellants were denied the opportunity to have the merits of their application heard on the basis of technical procedural grounds. We have come to the conclusion that these grounds were incorrectly relied upon by the High Court, and then it went on to evaluate all of them. Then at paragraph 33, the court said that this would mean that this court would be the court of first and last instance as far as the merits are concerned. Although this consequence is unfortunate, it was, in my view, necessary to go through this route. And I might punctuate that by saying that the court in Ramakatsa, what it did to circumvent this problem was to ask both parties to supplement their papers so that this court would be able to deal with the merits more fully. In this case, that's not necessary because we have a full set of papers and the matters were fully canvassed in the previous court. Lastly, on that score, why I say this case is better than Ramakatsa with respect is that in that case, that was a single judge. Here we had a full court. In that case, we only had the views of the court on the technicalities per se. Here we do have, albeit in a minority judgment, the wisdom of the lower court on the merits. And on those bases, we say that the cases are similar, but this case has got much more commending itself for the procedural issues to be ruled in our favor. Then I move to what I call part 2, which is the legal issues that have been raised. I will race through quickly the other 3 so that we can then come to the main issue of Section 47. The one issue is that has been raised is that the application has been brought in medias res. In our respectful submission, there's no merit in this submission for the reasons that have been very well articulated by Mudiba J in her judgment, namely that this matter is not so much about the outcome than it is about the illegality of the process itself. In other words, irrespective of the outcome, whether it's good or bad or indifferent, the process itself would have been tainted by illegality, and therefore it's an exception to the rule. Secondly, in our respectful submission, this case, and this is linked to the exceptional circumstances around direct access and so on. This is a case where the exceptional circumstances, the serious nature and the legal implications of the matter, for both sides for that matter, speak for themselves. And therefore, even if one were to approach it from the test of grave injustice that was developed in cases such as Wallau's, in our respectful submission, both the test of exceptional circumstances and grave injustice, which would otherwise result, have been met. And therefore, this is a case where the court, with the greatest respect, would be enjoined to hear the matter. Again, on the basis that if we are correct, if the merits are correct, then we're dealing with quite an egregious kind of illegality. Then there's another issue of undue delay which has been raised. That issue should not detain the court much longer. Firstly, in respect of former President Zuma, in our respectful submission, there is no valid case to suggest that there was undue delay in the first place. Because on the facts, it's very clear that what had happened is that it's common cause that he was appraised of the rule, the notice, 3.3 notice at the beginning of October of the year, and he wrote a letter or caused his attorneys to write a letter to ask for an extension because he was out of the country, and that extension was thankfully granted by the commission. And once he was then able to consult with his attorneys, then he set the matter in motion in a nutshell. So there's no question of undue delay. But in the unlikely event that it can be found that that period of the couple of weeks until he instituted the recusal application was undue delay, we would say that this is again a matter that falls under that category of cases which were covered in the so-called Gijima principle, which was also confirmed in ASLA, where undue delay ought not to be allowed to shall we say, to cure an illegality, as it were. So, and that's what we say. Well, as far as President Mbeki is concerned, he obviously made suggestions that he was supporting our recusal application, and therefore, if our recusal application, excuse me, was not tainted by undue delay, then it is doubtful that his could be. But Mr. Maneche will speak to that. Then I will then go to the issue of the Rule 53(1)B application. This is a very important point, particularly for my applicant, because the court will remember this is where we insist, to put it mildly, that the allegations around the misconduct, alleged misconduct, or the the coaching allegations of the evidence leader, we submit very strongly that those allegations have not been properly met or denied by the commission. And if necessary, I'll go into that by using Plascon-Evans, various rules of evidence, including the fact that there's a duty to speak whenever there are serious allegations against you, which are peculiarly within your own knowledge. Those types of authorities from the rule of evidence, I'm sure the court is familiar with, is what we rely on for this proposition that there has not, in fact, it goes further than saying that there's not been a denial. We go as far as to say, in certain respects, there's actually been an admission of those facts. Now, why is that important? It's important because, as we all know, as lawyers, you can't effectively, the only way you can compel someone to discover something is that you must show that it exists in the first place. So if the existence, as it is in our version, is admitted or at best not denied, then the duty springs up immediately, the duty to disclose it. Lastly, on that point, we know that the only reason that the majority did not adjudicate that interlocutory application was on their version of the majority mootness. And that mootness, so that becomes it begs the question. The mootness, according to the majority, only arises because the Section 47 point is good. So we turn that argument around. If the Section 47 argument is not good, which we will submit it isn't, then the mootness reason for not adjudicating the Section 53(1)(b) falls away. And therefore that it will have to be confronted. That then leaves us with the again, I won't go through all the authorities. The court is familiar with the authorities, Helen Suzman Foundation, and those kinds of authorities about the fact that there's a duty on a party in a review application to discover every scrap of paper that may have any relevance to the topic. It's a very wide duty. I'm quite sure the court will not question that proposition. The question, of course, is whether we have passed that threshold here. But as to the width of the duty, it is well accepted. I'm sure my learned friends will also accept it as such. That then takes us to the issue of the Section 47, which is the main issue that indisputably we're here about. On that issue, Justices, Deputy Chief Justice and Justices, we say the following. Again, the broad brush is that we obviously, unsurprisingly, align ourselves with the reasoning that is in the minority judgment. So that goes without saying. So I don't have to repeat what is in the minority judgment. But let me just break it down into a few constituent parts. In our respectful submission, that issue is an issue of interpretation. There's no doubt about that. It is, broadly speaking, deals with interpretation of the section, obviously, and interpretation of the plethora of high court cases that have dealt with that matter, and even in the interpretation, quote unquote, of the judgment, of the minority judgment, to the extent that we support that minority judgment. So let me break that into those constituent parts. Regarding the interpretation of the statute itself, the submissions we make are the following. Firstly, that that section, the purpose of that section has been mischaracterized both by the majority as well as those high court judgments on which it relies. In some instances, it has been a misreading of those authorities with respect. And I say that with specific reference to the Mutata judgment, FUL versus Mutata, which I will deal with, which was the judgment of Mlambo JP, as it then was, in this division. And we juxtapose that particular judgment with the judgment of Benenge JP in the case of NP versus LP, that was in the Eastern Cape. And then, of course, there's the so-called Mantashe-Memela debate, which we have to deal with, but we say that that debate, contrary to what is posed by the other side, is not decisive of the issues. It deals only with one of the issues that we raise. The main issues that we raise on interpretation come from the text of the section itself. One is the interpretation of the word judge in that matter, or if you like, the phrase judge of a superior court. Then there is the interpretation of civil proceedings. Are the civil proceedings that are referred to in that matter, do they fit these particular civil proceedings? And that is linked with the main reason why Mudiba J found in our favor on this point, in the sense that the court will remember that what she essentially said was that these were essentially recusal proceedings, or akin to normal recusal proceedings, and that in those types of proceedings, then the judge is not even required to be cited in the first place. But secondly, that judge could not escape or be insulated, to use her word, insulated from scrutiny against bias by by Section 47. So that's the second phrase. The third phrase whose interpretation is important in the section is the head of that court. And in our respectful submission, that the head of that court indicates clearly that the section was not intended to deal with retired judges who perform non-judicial functions. And that issue of non-judicial functions is going to be important, so I'd like to underline that. And that is the purpose of all of this is to make the following points. One, that this section does not apply in this situation. Around the issue of retirement, which I've mentioned, but around the following also a very important issue. If a judge, retired or not retired, doesn't matter for the purposes of the second point, is cited in their non-judicial capacity, nomine officio, as was done in this case, then again, in our respectful submission, that the section doesn't apply. And I would say, speaking for the first applicant, because as the court knows, the second applicant joined our case, as it were, that if you go to paragraph 4 of the founding affidavit, you will see that there was a conscious decision to cite the chairperson of the commission in a particular way. And that citation, I'm paraphrasing, goes something like this. The third respondent, I think she is cited, no, it's the first one. She is cited is a retired judge and a former justice of the High Court. She is cited in her non-judicial capacity as the chairperson of the commission. And then it goes further. And we will strongly submit that that citation alone is a major differentiator. And that's why we say the Memela Bantashe debate doesn't deal with all the issues, because it really deals with the first part, but not with the retirement issue. So those are two separate issues. Now, before I move away from this, I want to say the following. Apropos why, in our respectful submission, the judgments that were relied upon by the majority either A, were wrongly decided or misinterpreted. And this is something that really occupied our minds as to where is the actual nub of the problem. And we've come with this formulation with respect. There is a conflation on the meaning of the terms service, active service, or judicial service, rendering a service, and performing a judicial function. This is very crucial to this differentiation. How does this manifest itself, that conflation? In the cases where the two things are conflated, there are two cardinal mistakes that are made. One is very cardinal because it manifests itself in the transplantation, cut and paste, to use colloquial language, of a definition of something in one statute whose purpose is one thing, and literally transplanting that into another statute with a completely different purpose. You cannot do that. In the modern interpretation, whether you're talking about endumeni, cool ideas, and all those kinds of cases, the purpose is all important. So the purpose, the context, and the constitutional alignment, so to speak, are crucial in the interpretational exercise. So one of the worst things you can do in breach of that interpretation exercise is to go and mine a definition from something that was meant for something else and then put it, just plonk it and put it into something else that was meant for another thing. That's what we regard as the cardinal sin. And that seems to be at the base of this conflation. How does that do? Because what those cases do is to take the word service as used in the Remuneration of Charges Act and put it in the Superior Courts Act, Section 47, and then say, well, because in that act it says that service, a judicial service, refers to, includes commissions of inquiry, therefore, ipso facto, in Section 47, it means the same thing. There are two problems with that. Firstly, Section 47 doesn't say anything about judicial service. It refers to, it relates at least to judicial functions, which is a completely different matter altogether. Now, what is wrong with this transportation exercise is that it takes what is really a remuneration statute, something to do with the payment, and elevates it into a constitutional principle. What do we mean by that? The section to do with judicial functions is a matter that deals with what are the core functions of judges. And the court will be familiar with cases such as Heath, the South African personal injury lawyers versus Heath, where the issue of judicial functions was spelled out, and which in our respectful submission deals with sections of the Constitution such as Section 165, Section 176, which talks about active service and when such active service terminates. Contrary to Section 2195 of the Constitution, which really deals with remuneration of judges, public protectors, auditors general, and those kinds of people. So what we're saying is that a remuneration statute is now being used to interpret a statute that deals with the protection of judges to the extent that that is. Secondly...
So, Advocate Mpofu, yes, the gong is gone.
I understand. I heard it. May I just wrap up this point, or unless if there are questions, which maybe the point will come through this, because I just wanted to highlight something as far as Part 3 is concerned.
In 1 minute.
In 1 minute, yes. Now, when it comes to the third part, thank you, Deputy Chief Justice. When it comes to the third part, we'll make 3 quick points. The first one is that what we've termed the ultra-virus point. There is no world in which it can be justified that a decision taken by, or rather a matter that was heard by a panel of judges, of commissioners, whatever, is then decided by one of them. Whether you're talking about a full court or 3 commissioners, and as in this case. And the justifications that have been offered here, quite frankly, do not even withstand the first scrutiny. So the decision would be reviewable on that basis alone, that it was taken by one person when it was heard by the commission itself. One. Two, when it comes to the issue of actual bias, we have two grounds. One is the issue of the misconduct, alleged misconduct that I referred to, and the second one is the issue of what we call the media campaign. The media campaign that was conducted by the former justice regarding, in particular, Mr. Zuma, where she went and had interviews on the media, more than one at least, about why she found this way or that way in a case where she was sitting. That's not done. There's not even a debate. Everybody knows that that is not done. Doesn't matter how strongly you feel about the judgment. You can't just go to ENCA or whatever and say, no, you know why I found that way was because one of the reasons why we protect judges so much against unfair criticism is exactly because they are helpless. They can't, I can go and say all sorts of things about the judge, but the judge is not in a position to say, okay, well, I want my own interview, and that is for a particular reason.
Yeah. I will stop you there.
Yes. In fact, the last point, which is the reasonable apprehension of bias, I'm not going to deal with because Mr. Manage is going to do it. Okay. Thank you. Thank you so much, TCJ, for the indulgence.
Thank you very much, Advocate Mpofu.
Mr. Mpofu, I'm interested in the interpretation of Section 47. In particular, if you look at the section, it's broad. It does not make a distinction between an active judge and a retired judge.
Yes.
So why should we then narrow it to only deal with active and exclude a retired judge? Why should it be the case?
Yes. Yes. Thank you, Justice Mhlanhla. As a separate point from the citation point, specifically the retirement issue. Yes. In our respectful submission, Justice Mhlanhla, it is as follows. If you analyze the reasoning of Mbenenga JP, he makes it very clear. Firstly, purpose, we all know, purpose is important. And that's where we say the disconnect happens. The purpose of the section is not, as the other side would suggest, the primary purpose, at least, is not to protect the independence of the judiciary and all those lofty ideals. It might well be that that's one of the purposes. But the primary purpose of this section is to ensure, as was articulated by the DCJ in his previous incarnation. The primary purpose is to ensure the smooth running of the courts. It is to ensure that there's not chaos, where a judge is allocated by the head of court, and then it turns out that he has to go or she has to go and appear in some matter. So that's in our respectful submission, the primary purpose is less ambitious than all these other issues. That is not to say those issues are not important. Remember, the issues of the independence of the judiciary are sufficiently protected by contempt laws, by immunity laws, and so on. The narrow purpose of this particular section is to ensure that the judiciary runs smoothly. Now, if you accept that for a minute, Justice Mhlanhla, then it will follow that unless, and this was a very important point made by Justice Mlambo in the Mutata case, that of course retired judges may sometimes be called upon to perform judicial functions. In that case, they are definitely covered. We accept that. But that must be distinguished from retired judges who are performing non-judicial functions. Because when they are performing non-judicial functions, Section 47 is not intended to protect them. And this formulation was made very clear by Justice Mlambo in the Mutata case. Sorry. That's case number, oh, sorry, we didn't upload these cases, so we'll for my colleagues in the bundle, it's page 761 onwards. But this is what Judge Mlambo said at paragraph 23 of Mutata, apropos this distinction I'm making. And what he was saying, he was commenting on the Mbenenge JP formulation, basically to say it's not a blanket thing of are you retired or not retired. It's a question of what are you actually doing, which we agree with. And he said at paragraph 22, at the outset I point out that the absence of both the old and new sections of a distinction between judges still in active service and retired judges is not insignificant. Perhaps the most obvious reason is that judges' appointment is a lifetime appointment. It subsists even during the time when the judge has retired. However, for a more fundamental reason of the statement, that retired judges no longer feature in the running of the courts, which is the important thing, must be qualified as I do below. He went on to say, we know that there are judges who retire, but who continue to feature in judicial functions and activities. Very, very important. In other words, the judges who might retire, but are not just sitting in farming somewhere, but are called upon to continue to perform judicial functions. And this is to finalize the part-head matters seized with by importantly retired judges appointed to undertake judicial activities despite being retired. And then he goes on. And then he said, retired judges who are called to act from time to time or to finalize part-head matters fall within the ambit of the above-mentioned administration in that the head of the court retains supervisory authority over retired judges. This is the most crucial point. Those judges, retired or whatever, once they are called back, the head of the court retains supervisory authority, and therefore they are obviously hit by the section. And then I'll jump to paragraph 24, and where the learned judge said, judges who are retired but who continue to either perform judicial functions when called upon to do so by the minister, in line with D, have been appointed to perform the other function as provided by the section. So we agree with that formulation. Where we part ways with the Mlambo JP as it then was, is when he then, from that point, he then commits what we call the cardinal mistake of conflating judicial functions with service, as in the Remuneration Act. That we, in our respectful submission, actually counteracts the excellent distinction that he made between a retired judge who is called upon to do a judicial function and then any other retired judge. And then to bring it home to this case, what we're saying is that the judge, the retired judge in this case, was not called upon to perform a judicial function. In fact, she was called upon to discharge an administrative function, advisory to the president, an executive function for that matter, which is certainly not a judicial function. Thank you. The
commission, is it not called a judicial commission?
Yeah.
So,
yes.
And the judge, what is the judge supposed to be doing?
Yes. No, yes, no, thank you. No, there's no such thing. You see, the thing about judicial commission is just talk. There's no such thing as a judicial commission of inquiry. If you go to section 84(2)(f) of the Constitution, it says that the president is empowered to appoint commissions of inquiry. So just because in our everyday language we say it's a judicial Commission of Inquiry does not make it such. It doesn't make this Commission of Inquiry, Judicial Commission, more than the TRC was a religious Commission of Inquiry because it was chaired by a priest. So those adjectives that are used in qualifying the Commission of Inquiry are merely, as I say, just everyday language. But strictly speaking, Justice Mhlahla, a Commission of Inquiry is a Commission of Inquiry. And therefore, and to illustrate that point, Justice Mhlahla, let's take three commissions. Some of the well-known ones. I've already mentioned the TRC, and then there was the all-important Muarane Commission, which brought us the PKTT and all the things that have subsequently happened. And then there's this commission, or let's take either the so-called Zondo Commission or this one. Those three commissions, Justice Mhlahla, are commissions of inquiry in the same way. They were appointed by the President in terms of Section 84. And it cannot be that simply because one of them is chaired by a judge, then there are certain protections which would not apply to Archbishop Tutu or to Muarane SC when they are doing exactly the same thing, appointed by exactly the same person to do exactly the same job. So that's a distinction that is just artificial with respect. Thank you.
Still on this provision,
Yes.
it says no civil proceedings by way of summons or notice of motion may be instituted against a judge.
Yes.
A review, what is a review? Is it not a civil proceeding?
Yes, it is. Of course it is.
So why would it be excluded from this provision?
Yes. Now, that's a separate point. Firstly, we deal with the issue of the judge. Is the person a judge or not, which you and I have just exchanged with. So if we're good on that, then it falls away. But if we're not, then on the point of civil proceedings, we align ourselves fully, as I've indicated, with the reasoning of Justice Mudiba, who says, in a nutshell, Justice Mhlanga, that form cannot prevail over substance. In substance, what we have here is nothing different from a recusal application. The only difference really is this. If it was in court and I wanted Justice Mhlahla to recuse herself, I would make that application to yourself with respect, Justice Mhlahla, sitting in court. If you found against me, I would then appeal. At no point am I required to cite the judge that is being recused. What happens here is that for technical reasons which are not important, the recusal application is now brought in the administrative body. And when you can't appeal, there's no appeal in that. So if you are aggrieved by that, your remedy is to review, which is what we have done. So why would, she argues, Justice Mudiba, why would that in substance then be different? And suddenly the one is regarded as falling under Section 47, but the other situation, which is exactly the same, is not. So that's the first argument. The second is that she says that the difference between the appeal and review in this particular context is neither here nor there. The point of the matter is that the requirement, this is now me speaking, the requirement to cite a chairperson of an administrative body, as you know, Justice Mhlahla, comes from Rule 53. Remember, Rule 53 says when you are citing a body, whatever body, it could be the transport board or whatever, you cite the chairperson of that body. So as a representative of that body, here it happens to be the chairperson of this commission who is cited in that capacity. Very important. That's the nomine officio argument. Not being cited as a judge, not being cited even as the decision maker, not even being cited as the person who's supposed to recuse herself and all that, but purely on the basis that a decision of the body that she is chairing is being challenged in court. So why would you now suddenly say that, to go back to my previous example, if I was challenging the decision of Moerane SC as chairperson, I could just do it. But when I'm challenging the decision of another chairperson in terms of Rule 53, I must suddenly have to do something different. So that's another distinction. Thank you, Justice.
At this stage, my last one, I just want to, it's an observation. If one looks at the section, as I said initially, it's broad.
Yes,
and you seem to be seeking to narrow the provision. And I'm not sure whether we can do that on our own, or aren't we now going to be moving to the realm of legislating if we do that? That's my last one for now.
Yes, thank you. Well, in my respectful submission, you'll be doing that if you do the opposite. You'll be actually widening the section much wider. Remember what I said about this primary purpose. It should never be widened beyond its primary purpose to now suddenly become the one big protection mechanism for the judiciary outside of contempt proceedings, outside of all these. Its purpose in that context, Justice Mhlahla, is indeed narrower. And for an example, if you go to section 176, I think, of the Constitution, that section, 176.2, it makes a clear distinction between, we all know, and again, this is another colloquialism, that the appointment to a judge is a judge for life. No quibble with that. And that is why, for the purposes of remuneration, that has to be made clear in the Remuneration of Judges Act. So what the Remuneration of Judges Act does, Justice Mhlahla, is to say, let's call it, it's a deeming provision. So if a judge, retired, is appointed to chair a commission, that act basically says they're not going to get any extra pay or remuneration like I or my other learned friends sitting here would, because that's deemed for the purposes of that act to be still a service, continuing with the service. That's fine. We all know that's what happens. But that doesn't mean that the judicial office itself survives retirement. It doesn't. And the proof of that is it's 176.2, which says a constitutional court judge, sorry, I'm starting from 1. A constitutional court judge holds the office for a non-renewable term of 12 years or until she attains the age of 70, whichever occurs first, and so on. And then 2, which is the important one. Other judges hold office until they are discharged from active service in terms of an act of parliament. In fact, so what that means is that other judges hold the office in the broader sense until the date of their retirement. Right? Now, that makes it very clear. We're now dealing here with the question of the judicial office itself. If you go to 2195, it says something else. It says the remuneration of these offices, and then it lists them, will be dealt with. 2195, you'll find, it says, Justice Mhlahla, quickly. National legislation must establish frameworks for determining the salaries, allowances, and benefits of judges, the public protector, the auditor general, and members of any commission provided for in this constitution. And I dare say that the commission, much as I would have wanted to take advantage of that, but I don't think that, I don't submit that that was meant, this type of commission. I think they meant like a commission for gender equality and so on. Including the Broadcasting Authority, that's ICASA, referred to in section 192. So all I'm saying is that we can have the same constitution, we mustn't conflate the remuneration matters a statute that is meant to regulate remuneration matters with a statute that is meant to regulate something else. And that's the danger, with the greatest respect, with this, what I've called the cardinal sin. The definition section of a statute is not a dictionary. So you can't just say, okay, well, it's defined here as this, and therefore all forever, amen, it will mean that. Because that definition section was meant for that particular purpose and that particular context, all the issues set in Cool Ideas and in paragraph 18 of Ndomain in particular, says that when you're doing this, the modern form of interpretation, you must emphasize the purpose, context, text, and all the things that we talk about. Thank you.
Thank you, CJ.
Thank you. Advocate Mpofu, just a quick one.
Yes, thank you.
To clarify, you're saying chairing a commission does not come under the ambit of Section 47.
Yes.
So a judge who is in active service, who has not retired, who chairs a commission, also does not enjoy Section 47.
Is not performing a judicial function, 100%. That's why I said...
Who does the same thing?
Absolutely.
Okay.
Yes, absolutely, Justice.
No, I wanted that. I don't want you to explain. I
No,
just wanted
thank
to
you.
clarify that
Thank
part.
you. No, that's why you remember when I said this, I said when I would deal with this, whether the judge is retired or not retired, the point is that they are not performing a judicial function.
Yes.
And that you will find in Heath in particular. In Heath, they make the specific example. They say when a judge is chairing a commission of inquiry, they are doing an executive job. I'm putting it in my own language broadly. But they are certainly not performing a judicial function. That's one thing. Otherwise, separation of powers, all the issues that were raised in Heath would go away. In Amabungane, in all those kinds of cases, the same thing, where there was a so-called designated judge. There's no doubt that that judge is a judge, but whether retired or not retired, but they are not performing a judicial function, because a judicial function and an executive function are two different kettles of fish.
So the same judge who is still in active service, who chairs a commission, and you ask for that judge's recusal, and the judge refuses, that decision will be subject to review, not appeal.
Absolutely.
Which is what you argued earlier, to say in an ordinary matter,
yes,
where you ask a judge to recuse himself or herself, and he says, no, you appeal it. You appeal.
No,
when he's hearing a matter, not a commission.
Understand the question, Justice.
That's what you said, isn't it?
That's what I said, but what I said earlier must not be forgotten. Remember, when I was talking about the definitions, I said the first definition we must go for is judge. Is somebody sitting in the chairing a commission of inquiry or some investigation?
I don't want you to go.
No,
I just want to explain what my question is.
No, but it's very important, Justice, please.
Okay.
It's important to make this distinction. Because the mistake, with the greatest respect, that you make is to say, well, it's a judge. A judge is but I've already said that that person is not a judge for the purposes of chairing that. That could be Mr. Morane or someone else. But they're not performing a judicial function. The fact that they have a security of tenure for the rest of their lives as judges is known. But at that point, you are not citing them as a judge within the meaning of Section 47. That's really the point. Thank you.
Good morning, Mr. Mpofu. I have a question that follows on Justice Mklanhla's question on Section 47.
Yes, Justice Machi.
But also my primary difficulty is with an antecedent process of direct appeal to this court. So to make things flow smoothly, I'm starting with Section 47. That's backwards, but you understand why I'm doing that. I'm going to give you a hypothesis, and it's a hypothesis which is not too far from actually happening. Let's say I'm on long leave now until the end of the year, and then I retire.
Right.
So you got a period from now until, say, December 31, long leave, active service and then retirement. I'm also on the Judicial Conduct Committee. Now I sit in a matter, let's say a Section 17 matter where the judge may be cautioned or not discharged, that's impeachment, cautioned or fined or so on. I sit as a member of the Judicial Conduct Committee. You accept that if a matter arises in the course of those proceedings in the JCC, where there's some suggestion of impropriety, let's call it bias, whether actual or perceived, some things get that happen that get one of the parties thinking this may be a ground for recusal, but they're not sure yet. Then I retire, and that matter is parted, and I continue as a matter of the as a member of the Judicial Conduct Committee. But I'm now retired, and then more evidence comes to the fore, and the party is now absolutely convinced that there are grounds for a recusal application. Does that mean, on your argument, that up until December 31, if you bring a recusal application, with enough facts at your disposal, you would need the consent of the head of the court, of the Chief Justice, because I'm a member of this court, and after that you don't need it?
No. That argument actually shows the absurdity of the counter-argument. Thank you, Justice Machit. Let me answer it like this. If that were the case, really imagine that. If exactly you're doing the very same thing, but merely by the fact that at a certain point you have retired, suddenly you now require a permission. That would actually be an absurdity, because it would, in one way, mean that when you were a judge, in the proper sense of the word, one did not need, and you are sitting, and I know I'm adjusting your example, but let's say if you're a judge sitting doing a proper judicial function, then I don't need to do anything. But once you retire, I suddenly have to get permission. But to come back to your specific example, the answer is still no, and it is no for the following reasons. Whether you are retired or not retired at a particular point, it's not about that. It's about the function that you are performing. That's really the issue. And that's where the nub of the confusion really arises. Are you performing a judicial function, yes or no? Retired or not retired? If you are, then the section applies, as was eloquently distinguished by Justice Mlambo in the previous matter. But Judge Mbenenge says that this provision is for the smooth running of the courts, and that is why the head of the court is the one who must give the consent. It is not it's not even a jurisdiction provision, as was wrongly suggested by the majority. It is because the jurisdiction of the High Court, with respect, is spelled out in Section 169 of the Constitution. And that jurisdiction is either there or it's not there. And so the jurisdiction of the High Court is there. What Section 47 does is something less majestic than confer a jurisdiction or otherwise. It simply regulates the functioning of the court. Which is not an unimportant thing. We're not trivializing that function, but we're saying it must not be conflated with the broader protections of the judiciary, which we all support as a court.
Thank you. Now, can I just say that, I mean, sorry, were you finished, Mr. Mpopo?
No, I was, no, it's my fault, but I just wanted to make a certain point, if you allow me, Justice. This distinction, ironically, is made by Justice Khampepe herself. If I may just find the note, please, Justice. At 001-274, Justice Khampepe, who now comes, before the clever lawyers came to bring this Section 47 point, she herself stated in January, this point was brought in March this year. In January, this is what she said, to show that she understood the distinction. Look at paragraph 38 and 39. She says, in giving her, Mpofu SC, who appeared for the former President Zuma, sought to downplay the judicial presumption of impartiality by arguing that I'm simply the chairperson of a tribunal and not sitting as a judge. I disagree. I've been appointed by the President through Section 82F presidential powers to chair a judicial commission of inquiry. We've addressed that with Justice Mkhandla, but the word judicial really doesn't add anything to that. I've been appointed precisely because of my oath of office and because I'm a judge, albeit presently retired. It is my considered view that Mpofu's contention is devoid of substance. The presumption of judicial impartiality remains in my present role as chairperson of this commission, as I've said, as the one not easy to dislodge. Now, she may be right or wrong about the presumption of impartiality. I'm just addressing your question. Now, here's the kicker. Paragraph 39. She says, this is not to say that I fulfill judicial functions in my present position. Commissions of inquiry are not courts of law. This commission is an investigatory body tasked with investigating the matters set out in these terms of reference. Commissions will ultimately report to the President, which means they are executive instruments, not judicial ones. On the outcome of those investigations, the Commission may make a recommendation to the President, but it will be up to the President on whether to implement such recommendations and so on. Now, here she's explaining our case, that although I may have been appointed because of my oath of office and the judicial impartiality, but I'm not performing a judicial function. Why? Because this is not a court. There's no Section 47 which can transform a commission of inquiry into a court. That would be a travesty of justice if the pun is excused. Because what she's saying there in paragraph 39 is exactly what's correct, as I say, until such time. Or paragraph, I'm asked to read paragraph 40 as well. She says at 40, this commission does not function as an adversarial body, and the proceedings before it must not be confused with litigious court-based proceedings with winners and losers. Correct. All I can say is we agree. We agree that she's not performing a judicial function, and if she's not performing a judicial function, whether she's paid or not is another matter, but she's not performing a judicial function. And if she's not performing a judicial function, Section 47 cannot apply. And as I say, subsequently, some clever lawyering came into the picture, and now the position was that no, she was now performing a judicial function of Section 47.
Yes, thank you.
Thank you.
With great respect to my colleague, she's a formidable judge, but that's just an opinion.
Of course.
It's this court to decide. It's no different than the President coming here and saying, if I had known now what I had known then, I wouldn't have appointed her because of X, Y, Z. It's just an opinion.
Yeah, well,
I say that with respect. But let me move on. You see, Mr. Mpofu, I must say that there are strong arguments, and you've presented some of them very ably.
Thank you.
As to why this section could be interpreted both ways. But I've got an anterior problem.
Yes.
Antecedent problem. It's this. There is an appeal now pending in the Mantashe case, which is directly relied on by the majority in this case,
yes,
before the SCA. It will be heard this year. You filed conditional applications for leave to appeal. You filed an application for leave to appeal in this court. You filed conditional applications for leave to appeal in the SCA. Now, why should the SCA not on an expedited basis hear those cases and you join the other case because they're the same principles?
Yes.
And I'll tell you why I ask this. If, as I think the Kalata group, the sixth respondent makes the point, if you're going to ask for a case management meeting in the SCA before the President or whoever judge is designated to expedite this hearing because of the urgency of it, then this matter could conceivably still come before this court before the end of the year from the SCA. You see, in this court, I see you look skeptical, but you see in this court, we've got to be careful because, as you know, litigants come here in future and say, but you know, you did it in the Zuma matter, you heard a direct appeal, while there are appeal pending on the very, very same issues.
Yes.
So it does concern us. We, as you know, prefer to hear the views of not only the High Court, but also of the SA.
Thank you. Thank you, Justice Machit. Forgive me for the skepticism is very well justified and based on experience. That the chances of the matter coming here within and the commission being finalized in December on the extended are very narrow indeed. But
No faith in us or in the SCA?
well, it depends where I'm standing. Right now, I'll say the SCA. On a serious note, Justice Machit, to take that route, firstly, let me say this. The only reason why we do the conditional application, as the court knows, is because it's just a question of time. Because if you don't do the conditional application and this court rejects the application, then you have missed your 15 days for application for leave in the High Court. So it's really purely a practical reason. That's number one. Number two, the burden, let me put it that way, on us to make an intervention application in another matter where that intervention application may or may not succeed in the first place, as opposed to dealing with this concrete matter that is here now before us, is a risk that no party should be asked to assume easily. Thirdly, as matters currently stand, the main Mantasha matter, if I may call it that, is not being pursued on an expedited basis. And therefore, we cannot very well enforce or put down the throat of those parties expedition. Now, and I accept, Justice Machit, the reluctance of this court, which we all support, to hear matters as matters of first instance. And that is why I referred this court to paragraph 33 of Ramakasa, where that was done reluctantly as it was because of the other factors that we have relied on, and in other subsequent cases. Because, as I read out those extracts, I think it's paragraph 16, 17, and 33 of Ramakasa. And we, with the greatest respect, we say those considerations apply with equal force, if not more, in this particular case.
Well, lastly then, and relatedly, if you come to us to decide the merits of the review, then you're really coming on a direct access basis.
Yes, thank you. That is why both applicants have specifically asked not just for direct appeal, but also for direct access. Because you're right, in these kinds of situations, as was done in Ramakata, the direct access and the direct appeal was really on both legs, so to speak. And that is why I referred to what was then done in Ramakata, was to say, because the matter is urgent and it can't wait, it can't go through the whole route of SCA and so on, we are giving you parties, and I remember this because we were given like a week, to supplement your papers if you wish to, and then we'll hear the merits as well. And my response was that in this particular matter, that would not be necessary because the matter was extensively pleaded, extensively argued, and in the previous court. And more than that, we now have a bonus of the minority judgment, which has dealt with the merits. So to the extent that one wants wisdom of other courts, the wisdom is everywhere. We have the wisdom of the Eastern Cape, the wisdom of the Limpopo court, the wisdom of the Gauteng, the many Gauteng judgments that have been referred to, the wisdom of the Mantashe and Memela. So there's no shortage of wisdom. Even Erasmus says that on the question of retirement, I made a note of this. Erasmus says that it says there's differences of opinion on this question of retirement, and it cites the FUL case and then the Mbenenge JP case. So in our respectful submission, this is a case which commends itself for decision by this court. For an extra reason, Justice Majid, that these commissions, as we all know, are now proliferate. And these kinds of matters are brought in, day out, because of the Zondo Commission, the Matlanga Commission, and other commissions like that. And this point is being taken left, right, and center. And it is important that on our submission, what is purely a legal point, which is the interpretation of Section 47, should now be decisively, once and for all, put out there as the court places.
And do you accept that, lastly, on this point, that direct access is really a higher threshold to cross than direct appeal?
We accept that implicitly, that it is a high threshold, but again, we say exceptional circumstances, interest of justice, and the urgency of the matter necessitate, in the same way or even more, with bigger magnitude than in the Ramakatsa instance, that this case, this type of matter must now be put to bed. Because with the greatest respect, Justice Majid, to expect these parties who were the, shall we say, it would be almost like condoning the breach of the rule against piecemeal litigation. Because as we all know, and we've cited the authorities, courts, it is exactly because of the question you're posing to me, Justice Majid, that courts are told day in and day out that even if you find on a technical basis, on jurisdiction or whatever, you must still deal with the merits. Why? So that when we come here, we wouldn't be faced with a situation, imagine if there was no minority judgment. All we would be, this court, it would be unfair on this court, to be honest. All this court would be armed with would have been this interpretation of Section 47. And let's assume the court would then agree with us. It would then have to remit the matter, even worse than the SCA, remit it to the High Court, go to the SCA, and then come back here in 3 or 4 years' time. On these facts, there's simply no...
Ms. Peterson-Jones and Mr. Butlander will argue that you started all of this by bringing an application for review in midstream.
Yes, well, no, we didn't start all of this. The person who started this was the chairperson who remember, for this leg, we are assuming that our allegations are true. So we had a chairperson who, knowing that she had taken part in the decisions in the TRC and in the NPA, persisted unreasonably and illegally, if I may put it that strongly, to sit. She started it. We have a chairperson who was told by the president, who appointed her, that if I had known this, I wouldn't have appointed you, please go. She didn't go. She started it. We have a chairperson who has insisted on sitting in a position where she is, quite frankly, unwelcome, and her findings are bound to be found illegal. Because anybody, whether she finds for or against a person, is going to simply say, well, the person who appointed you said they don't want your advice. Remember, commissions of inquiry are advisors. They're in the same position as a DG. So you can't force yourself, just like me. If I go to a client and I say, the client says, please advise me on this, Mr. Mpofu, and then I give the advice, and one day they say, I no longer want your advice. But I can't say, no, you want my advice. I'm going to give it to you whether you like it or not.
Yeah, I just want to say on this, this is the merits, I'll leave it for my colleagues who want to pursue it, but it just seems to me that when you are asked to do a commission of inquiry on one aspect, and one aspect only, is to investigate whether these allegations of political interference in the work of the commission is true or not. I fail to see, prima facie, you can persuade me otherwise, of course, how that links to your work in the TRC Amnesty Committee and in the NPA.
Yes.
That will be my last question.
Thank you, Justice Majid. Let me assist then very quickly. If Justice Majid, let me put it this way. On the facts of this case, you have a person who sat in the amnesty committee of the TRC to decide who should be prosecuted and who should not be prosecuted. That person, and my learned friend Mr. Manager will refer you to the specific findings which are signed, Justice Khampepe. They have to do with the PEP Kotri and a gentleman, family of Mutasi. Those people are members of the Kalata group. So you have the same person who denied the amnesty to make those people prosecutable. After that, she then moves to the NPA. In the NPA, what does she do? She works for something called the HRIU, whose function, according to Justice Saldanha, is to investigate the prosecution or non-prosecution of those people that she denied investigation. That alone was illegal, if you ask me. But then it doesn't stop there. Now, this is triple bias, if there's such a thing. She now sits to judge whether the NPA and the Amnesty Commission, that chain, was suffering from political interference. And that political interference would have been, if it was there, meted out to her, because she was the Deputy National Director of Public Prosecutions. How on earth can that person, of all the judges in this country, be the one to investigate this? I can tell you now, Justice Majid, that there are maybe let's say two for argument's sake. Two people who should not be chairing that commission. One of them is Justice Saldanha, and the other one is Justice Khampepe. Why? Because Justice Saldanha was called recently as a witness in this commission to deal with exactly this point of when he was sitting with Justice Khampepe in the HRIU, whether they influenced or not. Mr. Nguka, who was their boss, both of them, has been called as a witness. So that means that Justice Khampepe is a competent and compellable witness in the commission that she's chairing. What is that? That can never be countenanced in a democracy.
Deputy Chief.
Thank you.
Thank you, Mr. Mpofu.
Sorry, Justice Khampepe.
Mr. Mpofu, it's common cause that we're not dealing with a constitutional challenge to Section 47.
Absolutely. No.
But rather its proper interpretation.
Correct.
You point out that both the majority and the minority judgments in the High Court did not address the interpretation of Section 47. Well, your heads of argument say that. But anyway, that's not the heart of my question. What you're really saying is that we should properly interpret Section 47.
Yes, the minority did on our version. Yes.
Based on that, we need to start with the plain language of the section and have regard to both the context and the purpose.
Correct.
You point out that the purpose of Section 47 is to ensure the smooth functioning of the courts. Is that right?
Correct.
And
what I call the primary purpose.
Sorry?
What I call the primary purpose.
The primary purpose.
Yes.
And we have to then interpret it in accordance with that purpose.
Correct.
Now, if one has regard to the structure of 47, it's broken up into two parts.
Yes.
The first part provides for the consent of the head of court, correct?
Yes.
The second part deals with ensuring that this consultation with the head of court when a judge's attendance might be required in proceedings.
Yes.
It says so expressly.
47.2, yes.
47.2.
Correct.
It must be determined in consultation with the relevant head of court. That is when a judge is required to attend court.
Yes.
It would seem to me that 47.2 is primarily concerned about the smooth functioning of the court, because you would need to consult with the head of the court in order to ensure that the court is not disrupted when that judge is required to attend proceedings.
Correct.
So having regard to the basic canons of interpretation that we all agree upon, why was there a need to have 47.1 when the primary purpose of Section 47 was to ensure the smooth functioning of the court, and 47.2 does that? All that the legislature would have been required to do was simply say, when a judge is sued, then the head of court must be consulted when that judge is required to attend court. If we read 47 on the consent part, in accordance with your understanding of purpose, then we give it a meaning that's wholly different from the purpose you say, and therefore it must raise in the sharpest terms whether the purpose you ascribe to the section is consistent with the terms of the section.
Yes, thank you, Justice Khampepe. Yes, I understand the question. The first answer is this. The purpose of Section 47 is the purpose of Section 47. It doesn't have one purpose in subsection 1 and another purpose in subsection 2 as such. I accept that, as you correctly point out, that the two subsections deal with two separate situations. But that's not a question of purpose and context. The purpose, the context, the constitutional architecture of the section remains what it is. And with the greatest respect, that purpose is even traceable to the, I think it's Section 8 of the Superior Courts Act, which deals with this thing about judicial functions and so on. Now, we say, in a direct answer to your question, Justice Khampepe, that those two purposes or those two subsections serve effectively the same purpose, which is the smooth running of the courts. And we agree in that respect with Justice Mbenenge, and we agree in that respect with Justice Mlambo, up to the point that I said we agree. If you put away this thing about the service coming from another act and so on, that section applies to retired judges who are called upon to perform judicial functions from time to time, whether it's acting and so on. Why? Why does it apply to them when they do that and not when they are farming somewhere? It is because the purpose is the regulation of the courts. The minute they get involved in that business of the smooth running of the courts.
I understand that, and sorry to interrupt you, but my difficulty is that if that's the purpose, then a reframed 47.2 would achieve that purpose. There is no need to obtain the consent of the judge president if the mere issuing of a summons is not going to disrupt the functioning of the court. Surely a summons that's issued today in the High Court will only get to trial in 3 years' time. The issuing of that summons can't disrupt the functioning of the court. Why is the consent of the head of court necessary if, according to you, it's to avoid the disruption of the court's functioning?
Yes. Thank you, Justice Khampepe. The point I'm making is that both sections deal with the permission of the head of the court. The other one really is...
They don't deal with permission. The first one deals with permission. The other one is really a consultation so that you negotiate a time.
Well...
Yeah. But I mean, the first one is a condition precedent, not so.
Fair enough. Yeah. Fair enough. But the point I'm saying is that both, I'm not saying consultation and consent are the same thing. I'm saying both deal with the smooth running of the court. Both the consent requirement and the consultation requirement in 47.2. I accept that they deal with two different topics, but I'm saying both topics have to do with the smooth running of the courts. And if you look at, it says whether issuing of a summons or subpoena against a judge to appear in civil action has been consented to. In other words, when one has been dealt with, the date upon which such judge must attend must be determined in consultation. So this is just about now the date, the practical arrangement of whether having received this consent to protect, to further protect, if you like, the smooth running of the court. You can't simply say, oh, well, the head of court gave me permission, so I'm now going to just somewhere call that judge on any day that I like. You must still, to protect the smooth running of the court, do the consultation. Thank you.
Thanks, Mr. Mpofu. I take a different view because I see them doing different things, but
No, they
we-
certainly do.
we need not exhaust them because, as I point out, I fail to see how the issuing of a summons can affect the smooth running of a court. It may potentially affect that when you have to come to court. But let's move on to the second concern I have, and it's this: the capacity in which the question of capacity, according to you, is whether you were a judge in active service or you were acting at the time, having been discharged, where consent is required. Correct? I mean, if you were
yes,
discharged,
yes,
and
yes,
if you're
yes.
discharged and you're
Yes.
asked to come back and act, then
Yes, that's part of it, Justice Khampepe. And the citation, the capacity in which you were cited. But I'll go along with that.
okay.
Yeah.
But can I just get the capacity in which you're cited?
Yes.
Are you saying that a judge who's in active service and who's sued for defamation, let's say, in respect of a private matter that has nothing to do with judicial proceedings in which that judge presided, Section 47 would kick in, not so? I mean, if today you want to sue a High Court judge for having defamed you in a public place,
Yes.
you would need to comply with 47, not so?
An active judge.
Yeah.
Judge in active service.
Judges,
Yes.
you would need to.
Yes, because,
So your
that's for a different reason.
yeah, but your capacity in which, in relation to the lawsuit, doesn't really matter, because you were acting in your private capacity when you defamed somebody, but you are being sued, and the person who's being sued is a judge. You're not being sued in your capacity as a judge, correct?
Yes, no, that's correct.
So you agree. So my question is this: does it not create an anomaly that if I'm discharged from active service and I do something like that, on your interpretation, Section 47 does not apply? If I'm asked to come and act for 6 months, but I did this last year, for example, but they decide this is the time to issue summons, then they need to get the permission of the head of court.
Yes.
But they wouldn't need to get it if I'm a judge, but not acting. Doesn't that create sort of an absurdity that
Absolutely
you're
not.
dealing with someone who's no longer a judge, but is only a judge temporarily for a limited purpose, but then you need to get the permission of the head of court, even when it might not disrupt, because the head of court might say, well, the person's acting for 3 months. There's no way this case is going to come to court within 3 months, and if the purpose is not to disrupt, well, what's the point? What's the purpose then of 47 if it's only that?
Thank you.
Yeah.
Thank you very much for that question, Justice Khampepe. Here's the distinction. When you defame me somewhere in the village, then there are two distinctions. One is that you are not performing a judicial function in that context. When you are acting, the minute you come from that village to go and act, you are performing a judicial function. So that's the crucial difference. Secondly,
Understanding what the difference is, because the lawsuit relates to when you were in the village, not so.
yes,
And when you were in the village, you were a judge.
yes,
You were not performing your duties as a judge, but you were a judge in active service.
yes.
And 47, we agreed, applies there.
But it applies for a completely unrelated reason. I'll explain. That's what I was coming to. The second reason is this, and Mlambo JP made this point in Sola, which is the original case of Ngada JP. The point was made that Section 47 does not only apply when you are performing judicial function. It also applied when you are being sued personally. So in your example of the village, I would be suing that judge personally. Here, none of those two gateway provisions apply, because the judge, the former judge that is being cited here, is neither being sued for judicial functions, nor is she being sued personally. She's being sued in her capacity in a third category called the chairperson of an administrative body, NO, nomine officio. When I'm suing your judge in the village, I will not say NO, because that is a different category altogether. And that's where part of the confusion actually is caused by this of saying, well, if it can go, which is really the nub of your question, if it can go beyond judicial functions, then what's your problem? But the question is, in which direction is it going? If it's going in the direction of personal suit, yes. But if it's in the direction of a non-judicial function and a non-personal function, let me put it that way, which is where we are, then the section doesn't apply. Thank you. Oh, yes. I've already apologized to the DCJ. We had promised to upload the finding of the JCC, which we did this morning, that we referred to in our heads. And we accept, before anybody says, that this is not binding precedent. It's being presented just as much as we would have presented an academic, albeit it was done by Justice Jafta and so on, but they were not performing judicial function, so to speak. But this is what they say at paragraph 29. A careful reading of the language, or the case lines is 006.1-122. They say, a careful reading of the language of section 177 of the Constitution in the context of section 174 and 176, that's a point I made earlier to Justice Mklatla, reveals that the President appoints judges to the judicial office in all superior courts. And it goes with 176 and puts an emphasis on 176.2, which is the one that I did put. And then it says, judges of other courts, including the SCA, hold office until discharged from acting service in terms of legislation. Upon this discharge, the judges vacate office and retire. Very important. This is how Section 176 of the Constitution was interpreted in Seriti. The fact that a judge who vacates office in this manner retains the status of a judge does not mean that he or she continues to hold office. There is a clear distinction between that status and judicial office. This distinction was also clarified in Seriti. The status attached to the incumbent of judicial office, and when he or she vacates the office, he or she retains that status even while in retirement. But that status does not mean that the judge continues to hold office. On the contrary, he or she becomes a judge without office from the moment he or she vacates the office in terms of Section 176. As a result, he or she cannot exercise judicial power or function, if I may add, or perform judicial functions, or well, they've added themselves, unless reappointed back into office for a temporary period. But if he or she is guilty of gross misconduct or suffers from incapacity or is grossly incompetent, he or she would not qualify for reappointment, even if he or she would otherwise have been eligible. That second part obviously related to the facts. But the crux of what these justices were saying, albeit in a non-judicial capacity, was that that distinction has to be respected. As I say, again, in everyday language, a judge is a judge for life. We all know that. But they make the crucial distinction between that, for the purposes of payment and all that, and for the purposes of holding judicial office.
Good. Then finally, Mr. Mpofu, you're saying that we must interpret 47 to read that no civil proceedings by way of summons or notice of motion may be instituted against any judge of a superior court who holds office at the time, something to that effect, because we both agree that a judge who is retired is still a judge.
Of course.
And would, on a plain language, plain meaning plain reading of this section, fit into it. And one would have to qualify it then by saying any judge who holds office at the time, either permanently or in an acting capacity, something like that.
Well, Justice Kolapen, I'm not asking for a miracle. I'm asking for you to do exactly what Justice Mlambo did in Mutata, which is to say, when he said, once retired judges are called back, then the section applies. That's really all we're asking for. And that, in simple legal language, simply means that it's not any old retired judge who's doing whatever, who's caught by the section. And Justice J.P. Mbenenge said exactly the same thing. And with the greatest respect, Justice Mlambo, in that case, did not differ with the formulation of Justice Mbenenge. He merely qualified it, and with respect, correctly, to say that to the extent that it doesn't apply, in other words, he was turning even the Mbenenge JP formulation to say you can't simply say, well, if you're retired, you're out. No, that can't be true. And that's not what we're arguing. Even if you are retired, if you're called back to perform a judicial function, then you are hit by the section. So we agree with the qualification made by Lambo JP, as it then was, of the Mbenenge JP formulation.
Me? Mr. Mpofu, if we look at section 47.1, it seems to have broad application. And there's a specific exclusion of domestic violence matters.
Yes.
Now, leaving aside for a moment the purpose of the provision, on what textual basis can we exclude from its application any other proceedings against the judge, and where those proceedings originate from a commission of inquiry?
Yes. Okay. Firstly, the textual basis is on the use of the word against. The reason why the crafters of that section use the word against must have been, at least, or one of the purposes, to distinguish from situations where you are citing the judge, but the proceedings are not really against that judge. Remember again, and we go back to the Modiba J analogy. When you are applying for a recusal of a judge now, I'm talking in a normal court, you are not exactly bringing anything against that judge. You are bringing an application for fairness, for lack of bias, for impartiality. It's not against that judge. That is why in the High Court you don't have to cite that judge. And even if the judge refuses to give my recusal, when I go to the SCA to then challenge that, I still don't have to cite the judge, because the matter has never been against that judge. It has been for the protection of impartiality. That's the first textual base. The second textual base, Justice Teron, is that the phrase, the head of that court, it would be an absurdity to the head of that court. What court? For a retired judge sitting in his farm somewhere there and doing their own thing, and then say the head of that court. As Justice Mlambo said, once that person is retired, excluding the situation of being called to act, they are no longer within the supervisory, I can't remember the actual phraseology, the supervisory jurisdiction or ambit of the head of the court. So who would be the head of that court? It would be an absurdity. Actually, that absurdity is playing itself in another case, but I don't want to let the cat out of the bag. But it comes this way, Justice Teron. If the person you are suing was a Chief Justice, for example, or a Chief Justice, then who's the head of that court? As I say, it's for the current case, it's not. So that's the second textual base. The third one is the one that Modiba J pointed to, which is that recusal, for the purposes of this section, recusal applications, broadly speaking, are not civil proceedings. And she asked the rhetorical question. Again, this is the thing of applying after legal advice, so to speak. She says, if that was the case, then why was it not necessary to do a Section 47 application in the recusal application itself? And the last point which I want to make is this. In the case, again, today I'm seems to be supporting Mlambo JP's judgments. That's not for opportunistic purposes. But here's an example, Justice. If you go to the case of Corruption Watch and another versus Arms Procurement Commission and others, you will find in that case that the very same Justice Mlambo who would have been, who had made the other decisions, did not insist on a Section 47, which he could have done Meremoto. Let's assume it was not raised, but let me explain the reason. The reason is found in paragraph 4 of that judgment. This is what Mlambo JP said. The first applicant is Corruption Watch, a non-profit company registered in accordance with the company laws of South Africa. Second applicant is Right to Know campaign, and so on. And here's the part. The first respondent is the Commission. The second respondent is Justice Willie Lehwabe Seriti, N.O., nomine officio, who is cited in his capacity as the chairperson of the Commission. That's exactly why we cited this respondent here in the same way. And then he says, the third respondent is former Judge President Hendrik Tekiso Musi, N.O., who is cited in his capacity as a member of the Commission. The fourth respondent is the Minister of Justice, and so on. And then it goes on. I admit that the issue was not squarely raised in that matter, but I venture to say that the reason why this citation, which is a mirror image of the citation that is used in this case, was not subjected to a Section 47 permission requirement, is exactly the fact that those judges were cited A, nomina officio, and B, in their capacity as chairpersons of a commission, which is the same as this one.
Mr. Mpofu, apart from the minority judgment of Justice Modiba,
yes,
what other authority do you have that these are not civil proceedings for the recusal? Civil proceedings as used, as that phrase is used in Section 47(1).
Well, the authority is, firstly, even Justice Modiba, who makes this proposition, accepts that in form it is. All she says is that form should not be elevated over substance. So that qualification is very important. So nobody, neither me or Justice Modiba, even worse, would come and say, and that's why I answered the question candidly to Justice Mhlanhla. Are review proceedings civil proceedings without more? Yes, of course they are. Everyone knows that. But the point is, in the context of this, are these proceedings in substance, not recusal proceedings like any other recusal proceedings. That's the point that really Justice Mutiba is making. I'm quite sure she's not making the absurd point that putting a notice of motion and going into court to do review application is suddenly not a civil process. But if it is it against? And that's the point I'm making. And we venture to say, no, it's not against anyone. And,
So we can accept that there are the civil proceedings as envisaged in Section 47?
No.
We can't?
No. We can accept that there are
I'm confused, Mr. Mpofu.
Well,
Either the argument is that they are not civil proceedings as envisaged in 47, or they are.
No. Okay, let me put it out. There is such a thing
Of course, against comes afterwards.
Yes. But
So they could be civil proceedings, but on your argument, they are not against the judge, if I follow you.
no, that's not what I'm saying.
Or
I'm
are you saying they're not civil proceedings and they're not against the judge?
I'm not saying that either. I'm saying they are not civil proceedings for the purposes of Section 47. That's all that Mutiba J found. That recusal proceedings.
Now, this is my question.
Yes.
If your submission is that they are not civil proceedings as envisaged in Section 47,
yes.
apart from the judgment of Modiba J, where is your authority for that proposition?
Well, the authority, as I've said earlier, is based on the common knowledge that all the judges sitting here have, that in recusal proceedings, you do not have to cite the judge. And that's the point that she makes, number one. Number two, that she says the technicality, and you may or may not agree that it's a technicality, but she says that the technicality that if you are aggrieved by that decision, excuse me, in the case of a judge sitting in court, you would appeal in the SCA, and in this case you would review them. Is neither here nor there. That's what she says, and we agree with that formulation. So she's not saying, as I say, it would be absurd for her to hear, and I'm sure she's not saying that bringing review proceedings is not simpliciter civil proceedings. But that's not the question you are required to ask. The question you are required to ask is like saying a judge. Is she a judge? Yes, she's a judge. But is she a judge for the purposes of Section 47 as envisaged in Section 47 with the purpose? Because we can't put aside the purpose with respect, with the purpose and all that. And it might well be that for a particular purpose, as explained by the JCC, the person is a judge for life. We all accept that. But the question is whether once they are retired and they are doing something unrelated to judicial functions, they are hit by this section. Thank you.
Now, this is something you didn't address in your argument, Mr. Mpofu. Did the chairperson have to decide the recusal application with other commissioners, or does the rules of the commission, or the commission's rules, allow her to have decided that by herself?
Thank you. I did address this in my 30 minutes. Well, I called it the ultra-virus point, but maybe I should just call it the improperly constituted body, which is the same thing. Thank you, Justice Teron. The chairperson cannot have it both ways, with the greatest respect. The chairperson, as I said, is cited as the chairperson of the commission, right? In other words, she's the symbolic representation of the commission, number one. That can never mean that she is now isolated as a human being. And proof of that, Justice Teron, is the fact that when on the 16th of January this year, we went to argue the recusal application, she sat in a panel with the other two commissioners. If she thought this was just about her, what were they doing there? They were...
No, I don't want to interrupt you, Mr. Mpofu, but can you answer my question legally, please? Like with reference to the rules, with reference to the law, was she entitled to make the ruling by herself? We really don't want to know what perhaps was in her mind. Can you contend and refer us to this rule or this case to say she had the power to make that ruling by herself? And it seems to be common cause, and please correct me if I'm wrong, that she decided the application alone. Is that common cause between the parties?
Yes, it is. But unfortunately, the question has to be answered in the manner that we have presented the problem. And it is the following, Justice. Let me start with the rules so that we get that out of the way. The reliance is put on Rule 3 when the application was brought in terms of Rule 11. And the application is made to the Commission, right? And how do we know that? Because, sorry. I'm sorry, Judge. We know that because sorry, Justice. If you go to 011672, okay, well, let's take it a step before. You remember that the affidavit of Semenya SC, which we say should be read as pronoun scripto, is purportedly done as an affidavit of the Commission in the first place. And so it says sorry, I just want to go to, let's start at 746, or 746. Sorry, Justice. 746. Yes, I think this makes it much easier because this is on the pen of Justice of Khampepe herself. These are the directives that she gave us in terms of Rule 3.3. No, she says notice in terms of Rule 3.3, Jacob Zuma. That was just a heading because that's what application. Then she says, in response to your letter, 3rd December, requesting that I be recused for reasons outlined in your letter, the Commission deems it fit in the interest of time available for the Commission to discharge its work to consider your client's request through the following directives. So it's the Commission. And then just run to 1.1. Your client is directed to file his application for my recusal to the Commission.
Mr. Mpofu, once again, I don't want to understand the attitude of the chairperson or the Commission. I want to understand what the rules say and what the law says.
The law. Okay, let's start there. Maybe that will make it easier. The SARFU, the case of SARFU, makes it clear, which we've cited in our heads, that when the recusal of a member of a panel is called for, that panel collectively, individually first, and collectively must make that decision. Why is that so? It is so for a very important reason, Justice Theron. Because we can never be in a situation which we are in now, where neither ourselves nor your esteemed selves know whether the other two commissioners agreed or disagreed with the finding. SARFU says it's not only our rights that are violated, but the rights of the other two commissioners. Because those commissioners have a right themselves to say, if these are the facts, we do not want to sit with you. And that's what SARFU says. SARFU says, so it's not just a question of just sitting there as a collective and taking collective decision. No, it is because the majority of the commission could possibly have upheld our application. So we don't know. The majority is excluded. What kind of procedure how can that in any law, anywhere, be a situation where, let's say it's a panel of 3 judges in a full court, and then you just hear one person, and you don't know what the other 2 judges' view is on the matter. Simply because, even though they said in the recusal application, let's say it was this panel, and one is asking for a recusal of one of the judges. The rest of the panel, even though the recusal is not directed at them, according to the SARFU, the Constitutional Court precedent in SARFU, is entitled A, to sit for obvious reasons, but B, to decide. And it may decide against that one. That one judge who's the target of my recusal application might think that I don't agree with Mr. Mpofu. But if the panel agrees, then they will succeed. In this case, the process was illegal in the sense that the body or the person who took the decision, the commission was improperly constituted, to put it in normal language.
The respondents point to a number of rules of the commission that allows a chair to decide interlocutory applications on her own.
Yes.
Why is this different? It is an interlocutory application, isn't it?
No, it's not an interlocutory application, with the greatest respect. This application goes to the root of the very existence and composition of this whole business. The terms of reference, remember the terms of reference of the president says, I, President Ramaphosa, hereby constitute something called the commission. That commission is made up of Commissioner A, Commissioner B, and Commissioner C. So the thing called the commission is a collective of those persons. That's the first point. The second, so it's not an interlocutory application with respect. But surely, if that was the case, then why is it that in the other recusal application of Seminya SC, the commission gave a ruling? It did. And all of a sudden, in this recusal application, it says I. And you can read it through. It no longer says the commission finds this or that. It's now I.
I'm still trying to understand why it's not an interlocutory application. What application would you then refer to it as? And let me ask 2 questions together.
Yes.
Do you agree that there are interlocutory applications that the chair can decide on her own?
Of course, in terms of the rules, yes.
Why was this not an interlocutory application?
Okay.
It's brought during the life of the commission as an application.
No. Yes. Not every application that is brought during the life of proceedings is an interlocutory application. Interlocutory in this sense is in the okay, that's another statute, section 18. I won't go there. This application is fatal and abortive to the very existence of the foundation of the commission as presently constituted, or as will ever be constituted.
That on its own wouldn't make it that it doesn't qualify as interlocutory. How many other interlocutory applications are not fatal to main proceedings, but they still in their nature are interlocutory proceedings?
Yes, interlocutory proceedings, as said in Rule 611, if we want to go to the specifics. Rule 611 of the Rules of Court tells us what interlocutory proceedings are, and those are the proceedings that are brought in the short form, not in the normal long form application. And because they are ancillary to the in other words, they're not totally defeating to the cause. Remember, the cause, the causa of the actual proceedings stands. But to bring interlocutory application, like our Rule 53(1)(b) application, that's an interlocutory application. Why? Because it simply says you must discover in the main cause. But if we were bringing an application that says you are in the wrong court, you should have sued me in Durban, you are now suing me in Cape Town. That cannot be described as an interlocutory application. That's an application that goes to the root of the very existence of that causa. So, but if I'm saying, okay, you're suing me in Durban, but you did not serve me after the 10 days or whatever, that's an interlocutory application. So in the context of proceedings such as these, to say that proceedings which basically abolish the entire body are interlocutory to that very body is with the greatest respect.
Can an interlocutory application have a substantive outcome?
Of course, it can, but it doesn't mean
that what would happen here?
No, Justice Theron, the fact that an interlocutory application can have logic doesn't work like that. The fact that an interlocutory application can have a substantive application doesn't mean every application that has a substantive application is therefore an interlocutory application. It can be.
I'm asking you to break it down for me, Mr.
Yes,
Mpofu.
okay, let me break it down. If A is equal to B, in other words, it's possible, as you say, can. That means possible. Is it possible for an interlocutory application to serve substantive outcomes? Yes. But does that mean every time there's something that has a substantive outcome, it therefore is an interlocutory application? No. So that's in logic, it's a syllogism. So it doesn't, the one thing doesn't apply both ways. So if I say a car is a vehicle, it doesn't mean every vehicle is a car.
I'd be putting it mildly if I didn't say I was confused. My last question. Why should this court be a court of first and last instance on the merits of the recusal application? Right. This court is very, very reluctant to do so. We do so in rare and exceptional circumstances.
Yes, thank you, Justice. Yes, that's the question I think Justice Majid had posed. Well, the shorthand is really what I presented in my 30 minutes, which is that this case is, for the reasons I articulated already, a much better case than the Ramakatsa case, which was heard by this court as a court of first instance. And the reason is that that case was heard is what is articulated, I think, in paragraph 16 of that case, which was that to do otherwise would have been to allow a devastating illegality to visit South Africa. So here, ironically, the respondents themselves make our case. What do they say? Court, this matter involves the most egregious matter of the non-prosecution of apartheid atrocities of people who committed heinous crimes. It involves victims, sorely so, who have waited for decades for justice. And it is not in the interest of justice to make them to wait any longer. And we say we agree, because to prolong the pain of the victims, let alone the potential implicated persons who might face all these other calamities, like going to jail, as we know, if they don't honor the subpoenas. In the case of Mr. Mainecha, he will tell you the risk, what we have posed as a risk, has actually materialized in their case, because they've now been served with a subpoena for President Mbeki to appear, and they had to go to Asian court and all that. We have not, but that's proof of the enormity of this matter. So, in which world would a court allow down the road a patent illegality of a commission, so-called, that is going to investigate to nowhere, which is plainly illegal, chaired by a person that we should not be chairing it, millions of rands later, after we've traveled all these roads, back to the High Court of SCA and so on, while the millions are rolling. And then one day, in 2 years' time, it's found that, no, that was a nullity. So that's even worse, as we say, than the possible calamity which would have befallen the citizenry in Ramakatsa. Because the Truth and Reconciliation Commission cases is something that affects this, it's the foundation, as they say themselves, the foundation of this very democracy was based on this granting of amnesty or the refusal thereof. So this is a case that it would be a travesty, with the greatest respect, or let me put it positively, it is in the interest of justice, blatantly, that the merits should be dealt with. Secondly, as I've said, there's already the wisdom of so many other courts, and the merits have been dealt with by the minority judgment, unlike in Ramakatsa.
Thank you, Mr. Mpofu. Thank you, Deputy Chief Justice.
Advocate Mpofu, we've long gone past our break time, but we insist on taking it now. The court is going to adjourn for 20 minutes.
Thank you. Oh, yes. Yes. Oh, these are the rules. What is this submission? Also not. Oh, so this is, yeah. Actually, I wanted to ask you.
So let me assist you.
Of Ramakatsa, the court, and I will not read. So which political right you are under really doesn't matter. The issue is that, as you correctly point out, there must be that political right, or that fundamental right, and more. And now, so to answer your question specifically, the more is not whether is this right or that right. The more is what was articulated by this court in. When we come to the merits, the court might differ with that. So that's why the court said, if saying is true, if indeed there are these misconducts, if there is this egregious breach of the rule against bias, if there's all the breaches of Section 34 and NEMO-UDEX and all that, if all that is true, what?
If I were to ask, the other two members of the panel, did they contribute anything or nothing at all, or they were just sitting there hearing the recusal application?
No, they contributed a lot, especially...
What exactly happened? They asked questions?
Yes. Oh, very much, especially Justice Homo. I remember there was...
So they brought themselves into the line of SARF?
Absolutely.
Of SARF?
Yes, they did. They did. And on the basis, yes, the answer is yes. They participated fully, and as would any panel, as like this panel, and they were not just sitting there as passengers.
So now why do you say it's a judgment of one person, not a collective?
Because it says so. It's common cause, as Justice Theron said. It's common cause, fortunately. If there was a debate about it, it would be. This, fortunately, is common cause. And the reason it's common cause is because they are constrained to agree. It says, in so many words, you'll see the word I appears about 6 times in that ruling. I think this, I think that, I. And then at the end, it's then signed by one person. But as I say, mercifully, when we raised that point, the other side agreed that it was done by one person. They then tried the gymnastics of saying no, she was entitled to, in other words, it was a confession and avoidance. They said, yes, she only took it herself, but she was entitled to because of interlocutory rules and which is wrong, because that cannot be the case. Rule 3 specifies
but couldn't it be interpreted or understood that she addressed it, obviously with the concurrence of the 2 other members, by using singularly because the allegations were leveled against her only?
No, Justice Khampepe, with a great...
Is it a bridge too far?
That's a bridge it doesn't even exist. The point is that she would have then said, as all judges do, I'm now talking for the court, let's say, for example, and this is our finding, and the others would have signed. The others would have associated themselves. As I say, Justice Khampepe, this is a serious matter.
And they did not concur?
No, they didn't concur or dissent. That's why I'm saying, in all seriousness, as we're sitting here, neither yourselves, with respect, nor me, or all of us sitting here, know whether they agreed or disagreed. It may well be, for example, why we've asked this question and nobody has ever answered it. Why is this Section 47 point only raised in relation to the chairperson? Why is it not raised in relation to Justice Homo? Why? Because he's a judge, he's a retired judge. Why?
Sorry, just come again.
Yes, let me say this.
Yeah, no, I heard you.
Yes. I understand. I'm saying, Justice Khampepe, and I must say this.
So the 47 point
yes,
was only raised against the chairperson?
One person, yes. And we've raised this in
But wasn't it raised against the chairperson because she is the one who was asked to recuse herself?
No, that's not it. It's raised against the chairperson because we cited her as the first respondent. But we also cited Justice Homo as the fourth respondent. So that's why it was raised. So why? And I'm venturing to say, and we raised this question under oath. Nobody has ever answered it. That's been dodged. And we venture to say it might well be that Justice Homo wanted nothing to do with this award or ruling. And, and he could have equally agreed or concurred. The issue, as I say, we don't know. Neither do you nor us. But that question lingers as to why nobody is saying you should have asked the Judge President of the Northern Cape for consent with Judge Homo. He's left alone, and that's because this is a one-person show, which it shouldn't be, because the entire panel, as you correctly pointed out, Justice Matopo, heard the matter, participated in the matter, as it did in the other recusal application of Advocate Semenya SC. And the panel, in that case, issued the ruling. Out of the blue, this one is different. It's a one-person show. That, as Justice Modiba says, alone shows you the egregious nature and the unsustainability of allowing this to continue, which goes back to your earlier question about direct access. Why would you allow something that is so patently illegal on any interpretation to continue simply because you must go to the High Court, you must go to the SCA and all that? When it's clear in front of all of us that this is an illegality, on that basis, on the basis of the reasonable apprehension of harm, which Mr. Manager is going to talk about, or at the very least on the basis of the actual bias that we plead, and also say in the alternative. So if it's true that she advised Advocate Semenya to say, you must argue this, you must argue that, and I'm putting it broadly, deliberately. If that is true, assume for a minute that is true, then we all know that we're dealing with the worst form.
No, but whatever allegations you may have asserted against Semenya, let's see, was there any evidence except whistleblower?
No, Justice Matopo.
When I read the record, I did not find any interaction between
Yes.
the chairperson and Advocate Semenya SC.
Well, that's because the lack of candor that goes
No,
with...
but was it there?
Yes, let me assist you, Justice Matopo. That's why we say that not only were there bare denials, which should count for zero, quite frankly, but there was corroboration of our version. We accept, as we must, that we did not bring a confirmatory affidavit of the whistleblower. I mean, that would be absurd.
But what must this court do
Yes,
then?
sorry. Pardon?
What must this court do if you don't have any confirmatory affidavit? It's an allegation that has been made. It's not supported by any confirmatory affidavit.
Okay.
What is the status of that allegation?
Yes. The status is the following. I think the chairperson uses the word smidgen. She says there is not a smidgen of evidence. Firstly, that is not true. The allegation is made under oath by a human being. That's evidence. The allegation starts firstly. The reason why people testify in court in the witness box and swear to God that they're going to say the truth is so that that statement that they make is evidence. That's number one. Number two, when, as we all know, Plascon, Evans, Whitman, all those cases, when an allegation is then made and it is met with a bare denial or nothing, then the court is entitled to assume that that has been admitted. Thirdly, if there is information which is in the exclusive knowledge of a particular party, that's Rules of Evidence 101, and that party is not forthcoming with that evidence, then the court is entitled to assume that there is a prima facie case of that. You won't quibble with all those three. But here's the fourth one. If you go to 011836, because they want evidence. Here's evidence which they provide themselves. we show them that there's corroboration, or there's non-denial and all that, but we then say, to make matters worse, I'm reading at paragraph 37, Justice Matope. In the course of preparing this affidavit, on whatever date, I observed a television interview on Newsroom Channel had the official spokesperson of the commission, Mr. Lionel Adendorf, while being questioned by the host, Mr. Xolem Ngambi, on whether the chairperson was perturbed by these allegations. These were the allegations of misconduct and all that. Replying as follows, quote, "She is an amazing person. I spoke to her earlier, and I just want to make reference to where she advised the chief evidence leader on a matter. She does that to me often. She does that in the normal course of our work where we talk regularly about things, and there is nothing wrong with that. She's not concerned at all. She's not concerned at all." Now, what is he saying? He's saying...
Mr. Mpofu, doesn't it happen in the normal course of events that the chairperson of a commission would interact with the evidence leader or leaders?
Of course, it does.
It does.
It does, but please, Justice Matope, bear with me here. There is a big difference between the chairperson. I've been in many commissions, and those interactions happen. One of them, the evidence leader, was my learned friend, Mr. Badlender. The chairperson interacts with the evidence leaders. No problem. Nobody can have a problem with that. But to want to surreptitiously equate that, as the other side does here, with a situation where there is a recusal application of the evidence leader, let's say in this case it was Mr. Badlander, which is in itself an adversarial proceeding on its own. That adversarial proceedings, if you work with me, has got the evidence leader who is being accused and the accusers. Now, a person who's trained in law says, with these two adversaries, I'm going to advise only one in the absence of the other. In S versus Roberts, which we cite in our heads, if you bear with me, Justice Matopo.
But am I not taking you away from the...
No, this is crucial. Actually, I welcome it, because remember when I was doing my summary, I just brushed through what I call the actual bias allegations. No. You're not taking me away at all. This is actually the heart of the complaint. Remember, I said, to the extent that we have overlapping complaints with Mr. Maineche around NPA and so on, I won't address those. But these, which are not overlapping and are unique to President Zuma, need to be addressed. Sorry, Justice Matopo, if you just allow me one. It's quoted in our heads. I'm so sorry. Page 44, which will be 006.1-44. No. The SCA said in S versus Roberts, in fact, if you look at paragraph 116, it starts where we started now, Justice Matopo. It is common cause that commissioners and evidence leaders communicate frequently. We don't quibble with that. The issue was not about the frequent communication between the chairperson and Advocate Siminya SC as the chief evidence leader. The issue was about communication between the chairperson and Advocate Siminya as a litigant in his recusal application before the chairperson. The rule against bias prevented the chairperson from communicating with Advocate Siminya SC as a litigant in the recusal application without the presence of the Minister of Justice and the National Prosecuting Authority. If I may pause there, that's why the NPA is here today, to say we want the answers. because if this has happened, it has a direct bearing on our application. Then the SCA in S versus Roberts makes it plain that, quote, justice must publicly be seen to be done necessitates as an elementary requirement to avoid the appearance that justice is being administered in secret, that the presiding judicial officer should have no communication whatever with either party except in the presence of the other. That is so fundamentally important that the discussion between the magistrate and the prosecutor in the instant case warranted on its own, without anything more, the setting aside of the sentence. Had such a discussion occurred before conviction in this matter, there can be no question but that the conviction would also be fatally irregular. So what the SCA was saying there is that merely, forget about what was discussed and the evidence, whistleblowers and whatever, merely the breach of that rule in an adversarial setting. I don't have to explain that to this court. That's why sometimes, even if we're going to say the most innocuous thing to the judge, we have to bring the opponent to be there in chambers. And the opponent sometimes is just there and grudgingly. But you can't, everyone knows this. That's the biggest breach of the rule on
Thank you.
It's a pleasure.
Mr. Mpofu, I thought one of my colleagues would ask this, but I'm concerned about this prayer for punitive costs against the chairperson.
Yes.
Are you persisting with it?
Yes, we are.
Now, I find that quite disturbing, and can you please illuminate it? I know you've dealt with it in the written submissions. Why?
Yes. The prayer for personal costs, thank you so much for that, Justice, because again, it's a matter because of the truncated nature of my initial address, which I didn't dwell into. The prayer for personal costs starts as follows. Remember where we come from. By the time we get to that, we would have now accepted that we're dealing with a chairperson of a commission. Could have been a judge, it could have been any chairperson of a commission. Now, a chairperson of a commission of inquiry, any commission of inquiry, has got what one would call, Justice Majid, a heightened duty to fairness. Again, if everything, because costs would come at the end, if the alleged misconduct, take this, Justice Majid, if you allow me. One of the reasons on which we rely for the actual misconduct charge is that this chairperson, I mentioned this in the morning, went out, and this is now specifically for President Zuma, went and did what we call a media campaign, vilifying President Zuma by name. Now, if that has happened, and there's no, all these things about there's no evidence. Here, there's evidence, hard evidence in front of you of those interviews having taken place and mentioning President Zuma by name. And sorry, Justice Majid. If you go to 011 255, I'm looking at my letter from Mr. Manager because he likes this part. It says, no, I was glancing at Mr. Manager because he told me that this is his favorite part of the case. If 011-255, look at that, Justice Machit. The heading, it's a News 24 report by a certain Karen Mon. Says, we could not pander to Mr. Zuma, it's not general. We could not pander to Mr. Zuma. Khampepe on why Concord had to send him to jail. It says, and then it says, it has now been a year since the Constitutional Court, whatever. And then the next paragraph. Now, in the first part of an exclusive interview, recently retired Justice Sisi Khampepe explains why that judgment, which she wrote, was essential to protecting the rule of law in South Africa, and so on. And then she goes on to say, Mr. Zuma believed he could test the limits of the judiciary, and I believe the judiciary demonstrated that nobody is above the law. We're all equal before it, and so on. Now, this person knows that the judicial code of conduct of this country says that a judge may not do an interview about a case where they sat. It's not even debatable. Sorry, Justice Machit, if you allow me. In our, I'm sorry, Justices, I know that the time, yeah. You'll find that at 011-44 to 45. The Judicial Code provides that a judge must, quote, save in the discharge of judicial office, not comment publicly on the merits of any case pending before or determined by that judge or any other court. Rule 13.
Sorry, has a complaint been laid with the JSCC against this?
I'm coming to that. The Rule 13 says, which provides further that a judge must not enter into a public debate about a case irrespective of criticism, because that's what she seemed to have been responding to. Irrespective of criticism leveled against that judge, the judgment or any other aspect of the case. So it's as clear, nobody in this country would say this rule has not been breached. Now, in the face of that clear breach concerning President Zuma, I ask this rhetorical question of any one of us. Would a reasonable person in the shoes of Mr. Zuma, which is what you judges are expected to do, put yourself empathetically into the shoes of the person? Would you, in spite of these breaches, still think you are going to get fairness in front of this person? To come to your question about the Judicial Service Commission, we say in these papers, in no uncertain terms, and fortunately my learned friends seem to have understood this because they didn't quibble. We know, we're not asking this court to now be some pseudo JSC. All we're saying is that President Zuma has said he is going, as soon as these proceedings are finalized, because there's no time limit, he's going to present to the JSC these two complaints, the one about the collusion and the coaching of Advocate Semenya, allegedly, and this one. And he says, I'm merely presenting it to this court, not for the purposes of this court finding misconduct, but for this court to answer the question that I just posed, whether a reasonable person in that position, whether there isn't the clearest case under the sun of a reasonable apprehension of bias.
Can you ask your juniors to direct us on the case lines to that portion?
Where that portion
is. But in the meantime, you can carry on, just to save time.
It can be far from here, from what I've just read. Please.
Probably towards the end of the affidavit, right?
Yes. Yes, it might be, yes, because you're right, Justice. It probably, that's where it does the disclaimer, yes.
Let them earn their fees, Mr. Mpofu, let them look for it. And
Well,
carry
it's
on in the
about time
meantime.
that they end their fees, yeah.
Carry on in the meantime.
I'll
just
give
to
them a
save
clue. It's in the funding affidavit.
They will direct us on this.
Yes, they'll direct the court. But to paraphrase it, Justice Machit, we say this twice. We say the JSC issue will be raised with the JSC as it should, but here we want this court to look at it only on the basis. And that is why, if you remember, in our supplementary affidavit in the review, after the record had been given, we said we abandon the complaints to do with the finding of the Constitutional Court in the Zuma matter. But we said what we specifically do not abandon is this complaint about the media campaign. Which
Can I just say that, and I'd like us to move on. I'm very pleased that you've abandoned those
yes,
other
so am I,
grounds.
if I may say so myself.
That was very troublesome. But
Yeah,
can
no,
we move
it
on?
was.
Are there other grounds apart from the media interviews? I mean, I saw at paragraphs 131 onwards in your written submission that you, why you say there's a punitive personal cost orders justified.
Oh, yes.
Yeah.
Sorry, I forgot actually
Part K.
the reason why I'm saying, again, I'm saying assume all this is true. So I'll put that aside. Now, that being the case, in the case of the public protector versus South African Reserve Bank, which we quote, which we rely on in our heads. Sorry, Justice.
I've got it, it's paragraph 129. But while you're there, can I ask you, I mean, we all know that case.
Yes.
In that case, the public protector was found by this court to have misled the court on a pertinent issue. So how is that case comparable to this one?
Okay. That case, which was given by none other than the judgment by Khampepe J, said the following. One, when there is an allegation made against you and you become cagey, as we say here, about Rule 53, and you don't disclose a Rule 53 material, number one, that is a reason for you to be mulcted with punitive and personal costs. B, Khampepe J said, if there is a higher threshold, I'm paraphrasing again, I think it was paragraph 153, but I stand corrected. There is a higher threshold for people who hold public office, and we say that applies equally to a public protector and the chairperson of a commission of inquiry. What's sauce for the goose is sauce for the gander. And if she, Justice Khampepe, was prepared to lay down a rule that says, if you hold that important office, what? Okay, well, they're still not ending their keep because it is 153, so I was right. But paragraph 153 says, the public protector falls into that category of public litigant. Sorry, it's the...
Mr. Mpofu, paragraph 153 talk about when their public officials,
Yes,
when their defiance of their constitutional obligations is egregious, it is they who should pay the costs of the litigation brought against them and not the taxpayers. What constitutional obligations were egregiously breached here?
Okay, if I may just start with, it says a higher duty is imposed on public litigants as the Constitution's principal agents to respect the law, to fulfill procedural requirements, and to tread respectfully when dealing with rights. The need to hold government to the pain and duty of proper courts process is sourced in the Constitution itself. This is because the Constitution regulates all powers, said Justice Khampepe. And the same considerations of a public litigant who, for lack of a better word, and excuse me for being general on this, whose conduct really amounts to the wastage of the taxpayers' money. Whether that is because of an investigation that is ill-founded by a public protector, or a so-called commission of inquiry that is doomed to nothingness, such as this one, where the actual person who appointed the person says, I don't want you anymore. So a public litigant who digs her heels with the greatest respect against this flurry of evidence. I've already said the thing about the NPA, I won't repeat it. I've said the things about the HRIU. I've said the things about the Amnesty Commission. I've said the connection with the subject matter and the competent witness of Justice Saldana and Mr. Ngada. I've said all of those things. Faced with this overwhelming evidence, forget about actual bias for now. Just say, faced with this at the level of the perception of bias, and the person says, no, I'm stubbornly going to stay here, whether the president likes it or not, whether these litigants have given interviews all over the show about them, whether I'm alleged to have given advice to Mr. Smenya, and the spokesperson has confirmed that that advice was given. All of that. In which world can such a person be entitled to get all of us sitting here, waste the time of this court as I say, pursuing a commission that is 1,000% doomed to not to produce any outcome for the victims or for the alleged implicated persons. This commission will never, I can say that, put my head on the block. Its outcome is going to go to the dustbin of history because of these very egregious
we must just tone down the language a bit, Mr. Mpofu, please. Well, let me end there because I think the language is now increasing in tone, so I won't ask anything further. You've answered the question, thank you.
Well, okay, well, if I may then comment on that, because I don't, this is an expression that is used all the time as to when something is destined to fail. Maybe that's what I should say. I don't understand why that is. If that kind of language, which is used in the SARB case against the public protector who was allegedly wasting taxpayers' money, was good enough for that public protector, it's good enough for any public official. Doesn't matter who he or she is.
Talking about this expression of it will be confined to the dustbin.
Yes, that's the expression which I'm saying is an English expression which simply means that something is doomed to, it will never see the light of day. Maybe I should put it like that. It will come to naught, zero, zilch.
Okay. Thank you, Advocate Mpofu.
I'm indebted to the court. Thank you. Thank you very much. If the court can just bear with us while we do musical chairs.
Yes.
Mr. Manager, thank you.
Are you ready, Advocate Manager?
Yes, DCJ, I would say tomorrow, but it is today that I must be ready to address the court. Yes, I'm ready, ma'am.
Thank you. Please go ahead.
Thank you, DCJ and Justices of the Court. I will address 3 topics and then conclude. First is to deal with the Section 47 and why we say direct appeal should succeed. And 2, I'll deal with the review of the ruling and direct access. Sorry, the first part was direct appeal. The second one is review of the ruling and direct access. And I will focus on the review ground relating to prior institutional roles or activities of Justice Khampepe. Then 1.3, I'll deal with substitution in the event that the court were to accept our submission that direct access should be granted and the court enters the review, the merits of the review, and then I'll conclude and remedy. You will have seen that there are certain aspects between the case for President Zuma and our client which overlap, but there are very specific, distinct aspects which differ. One of them is what my learned friend said was my favorite part of the case. I have no favorite part of the case. I'm simply presenting the case for my client, Mr. Mbeki. Can I foreground the submission we're about to make with President Mbeki is not avoiding accountability. Like all citizens in this country, what President Mbeki is asking for is simply to assert his right, constitutional right, and the rule of law. And that is the context in which he raises the recusal issue. If this court were to enter the merits and decide that there is no unlawfulness and the commission is properly constituted, my client stands ready to account before that commission. But he will do so subject to this court determining whether his complaints are valid in terms of the Constitution and our law. And I turn to Section 47. The proper interpretation of Section 47 implicates the right of access to court in Section 34, especially in this case which concerns recusal, because Section 34 is front and center to the questions of impartiality before any proceeding, whether that proceeding is investigative or adjudicative. And this engages the obligation on courts to adopt an interpretation under Section 39(2) of the Constitution, which promotes the spirit, purport, and objects of the Bill of Rights, even where the issue is not raised by litigants. And this court has repeated that obligation on numerous occasions in its judgments. I don't need to cite authority for that. So the point here is that there is a constitutional point directly raised because the majority did not even refer to Section 39(2) of the Constitution in interpreting Section 47, even though it was made, the submissions were clear that there is an implication on the right of access to court. The matter also raises an arguable point of law of general public importance to be considered by this court within the meaning of Section 167(3)(b) Roman 2. And the point of law has prospects of success, which is evident from the dissenting judgment of Modiba J. And that this court too has emphasized in de Klerk, one of the cases, that where there are dissenting judgment, that's evidence of prospect of success. The second point, which is observed by Modiba J in her dissenting judgment at paragraph 30, is that indeed this case raises a novel point not previously determined by this court in relation to Section 47 of the Superior Courts Act. First, you're dealing with a retired judge sitting as a chairperson of a commission of inquiry where the proceedings that is said to require Section 47 arise in the context of a recusal application. So that is not an issue that has faced this court before. We submit that the majority's approach in interpreting and applying Section 47 was wrong, and in our analysis of that judgment, it rests on 3 core but wrong propositions of law. The first is that it borrowed from the definition of service in the Judges Remuneration Act, and it did so in upholding the reasoning in Mantashe at paragraphs 34 to 46 of the majority judgment, and that is the reason at paragraph 45 of that judgment it says a retired judge performing a public service is covered. And the second is that the judgment seems to suggest that the second basis, that the application targets Justice Khampepe in her person because the relief sought includes that her conduct must be declared unconstitutional. And you will find that at paragraph 39 of the majority judgment. The third proposition is, it says, and this we accept is not always clear, it seems to suggest that chairing commissions of inquiry involves the performance of judicial functions or that the judge does so in the capacity of a judge. And you'll find that at paragraph 54 of the majority judgment. We say both three propositions are wrong for the following reasons. First, it is not permissible to borrow from the definition of service in the Remuneration of Judges Act to interpret the breadth of section 47(1) of the Constitution. This court has emphasized in Independent Institute of Education, Pty Limited, at paragraphs 18 and following, 6 core principles, or perhaps there are 6, which guide when you can borrow or why you shouldn't borrow from a different statute. The first, and I'm just going to highlight 2 of them, and the court is well aware of them. The first is that, first, a special meaning ascribed to a word or phrase in a statute ordinarily applies to that statute alone. And the last one that I highlight is identified as the 4th, is that a definition of a word in one statute does not automatically or compulsorily apply to the same word in another statute. You interpret the statute in its context, having regard to its purpose and the language used. You will see that the Superior Courts Act does not even contain the definition of the word service to justify borrowing from another statute to give it meaning. And the 2 statutes are not in pari materia because the Superior Courts Act deals more with the administration and functioning of courts, whereas the Judges Remuneration Act provides for the remuneration and conditions of employment of judges. So there is no principled reason why one borrows from the one definition to interpret the provision in the Superior Courts Act. The second proposition that President Mbeki seeks relief against Justice Khampepe in her person is wrong because he seeks no relief against Justice Khampepe in her personal capacity. She's only cited in her official capacity as chair of the Commission of Inquiry. To the extent that any liability is established, that attaches to the office that she occupies and not her person. The third is that chairing a Commission of Inquiry does not at all involve the performance of judicial functions. My learned friend, Mr. Mpofu, referred to the ruling by Justice Khampepe at paragraphs 39 to 40, which makes that very point. And Justice Majid correctly pointed out that that's the opinion of Justice Khampepe, but it happens to be consistent with principle established by this court, because in President of the Republic of South Africa, Sarfu, at paragraph 147, this court says that a commission of inquiry is an adjunct to the policy formulation responsibility of the president. It is a mechanism whereby he or she can obtain information and advice. It doesn't determine rights and wrongs, doesn't issue binding decisions or orders as courts do under 165(5) of the Constitution. So, we criticize the judgment of the majority, but then what do we offer as the proper interpretation of the section? We say, as the start, one must read section 47(1) in the context of the entire provision, including section 47(2) and the Act as a whole, with proper regard to its language and purpose, as well as the obligation in section 39(2) of the Constitution. And you will see the dissenting judgment does pay regard to the broader purpose and the context in interpreting the provision, which the majority fails to do. Why do we highlight 39(2)? We say it implicates access to court because if we are required in challenging the lawfulness of the recusal ruling to get consent from the Chief Justice in this case, when the Chief Justice says no, consent is given, then my client must submit themselves to a process where they have, in their view, rightly raised an issue about impartiality without having that issue properly determined by a court. And it is not readily apparent from Section 47(1) and the entirety of the Superior Courts Act what remedy my client would have in the event that the Chief Justice says no. Do you appeal? Where do you appeal to? Do you review the Chief Justice's decision? If you review or appeal, do you cite the Chief Justice? If you want to cite the Chief Justice, you need consent. Is it not a vicious cycle in which rights are undermined? So when you interpret the breadth of that section, one has to bear those into account, that you want to adopt an interpretation which promotes the rights of access to court, not simply limits them as less as possible, but promotes them, because that's what the law says. Now, let's look at purpose. The minority judgment with which we agree identifies two purposes, and you will see that at paragraph 33 of that judgment. The first, it says, is to protect judges against frivolous and vexatious litigation in which they are targeted due to their work on the bench. And the second is to ensure that appearance by a judge in court does not disrupt court proceedings. Those are purposes which have been identified in the many judgments which the high courts have given. And most of those judgments were by judge presidents of those divisions. So they carry some weight, we would submit, because those are the people charged with the responsibility of properly administering courts under the Superior Courts Act. We say that this identification of the purposes of the Act is supported by the long title. You'll see the long title refers to the the provision for the administration of the judicial functions of all courts, including governance issues over which the Chief Justice exercises responsibility. And then Section 94C, which we emphasize, access to courts, recess periods, and attendance at courts. It says in subsection 4, subject to subsection 1 and 2, the head of each superior court is responsible to ensure that sufficient judges of that court are available to conduct the business of the court at all times that the court is open for business, issue directions to the judges of that court with respect to their attendance at the court and absences from the court during recess periods, approve extraordinary absence of judges and keep registers, etc. So that's about ensuring that the court can function. And that's reinforced by Section 47(2). And to Justice Kolapen's question about the relationship between 47(1) and 47(2), we accept that 47(1) governs the consent requirement, but 47(2) operationalizes. Once that consent is given, you'll see there's consent to issuing notices of motion and consent to subpoenas and summonses. And then 47(2) speaks specifically to the summonses and subpoenas, that the attendance must be arranged with the head of court to avoid disruption to the court functioning. That, we submit, emphasizes the purpose of the provision read in the statute as a whole, to ensure the proper functioning of courts and to protect courts, judges against vexatious litigation arising from their judicial functions, because their judicial functions, where wrong or right, must be appealed if you are aggrieved, not you must sue them. So that's the immunity. And we accept also that those two together, the purposes, help achieve and protect judicial independence. So they are linked to judicial independence. Our first submission is that these purposes, properly construed, are applicable to active judges and retired judges called upon to perform judicial functions. And so in that regard, we would submit that Justice Benenge, JP, was correct, and as he then was, Justice Mlambo was correct. We differ only with Justice Mlambo with the reference to service, which is borrowed from the Judges Remuneration Act. But we agree with both to that extent. And we submit that there is no contextual, purposive, or textual support to extending the provisions to retired judges serving as commissioners in commissions of inquiry and cited in those capacities nomine offici, other than by borrowing from the definition of service in the Judges Remuneration Act. Because judicial commissions of inquiry do not perform judicial functions, and suing a judge in that context does not relate to suing them in respect of matters arising from their performance of the judicial functions.
So that's our principal submission, is that it doesn't extend to the nominee officer position where you're performing other than a judicial function. Even if you are there chosen because you're a judge, an accountant could have been chosen. The second, and that's the alternative to the first, we submit that even if we're wrong with this first submission, the provision ought not to apply to review proceedings against a refusal to recuse. And we say this because recusal applications are internal to the proceedings in which they are brought and are determined by the presiding judge or officer or commissioner. And where you have recusal proceedings brought in court proceedings before a judge, there is no debate that Section 47 is not triggered. Even the appeal against a refusal is not triggered. We don't see any, I hesitate to use doctrinal because I'm not sure I quite understand what it means, but there's no principal basis on which one can distinguish between a challenge to a refusal to recuse by way of appeal and a challenge to a refusal to recuse by way of review. The only difference is the threshold for getting the relief, in that in appeal is correctness, in reviews you're looking at lawfulness. But the end result is to secure a recusal. And that purpose never changes because you started off with a recusal application but ended up with an appeal or a review. And we submit that the essence of the proceedings remain the same, whether you're challenging a refusal to recuse by way of appeal or you're challenging a refusal to recuse by way of a review. And it's very important in the context of recusal because recusals, as we understand them, are sui generis. I think it's State versus Baswan. They're sui generis. As Safu says, in the first instance, a recusal application calls upon the judge to make a decision based on their personal conscience. It's very difficult for a head of court to second guess whether the refusal was lawful or not. Often when you don't know the full facts on which the recusal was brought, which the judge or the commissioner knows but may not have been placed on paper. For example, in this case, where there isn't really a full disclosure. So what we agree with the minority, that recusal proceedings are defensive in character. You are forced to appear before a panel, and in asserting your rights, you say, but this panel is not properly constituted because I apprehend a bias on part of a panel member or the whole panel. They cannot classically be construed as being proceedings against a judge. You don't obtain relief against the judge against whom a recusal is sought. All you're asking, you don't ask that liability be attached to that judge. All you're asking is for the judge to step aside in order for the proceedings to run without the attendant apprehension of bias. So our submission tracks what our learned friend Mr. Mpofu says, that we accept, Justice Teron, that it's looking at the provision, it's difficult to submit to the court that review proceedings in the High Court against a refusal to recuse are not civil proceedings. They are classically civil proceedings, and I haven't looked at whether sui generis means they are neither, but it might be that they are of a different form, but for present purposes, I'm not pressing that point. I'm pressing the point that the provision requires that the civil proceedings be against a judge. And often in that case, the judge will be a party and another judge will determine right or wrong. Whereas in a recusal proceedings, the very judge who's asked to recuse themselves is in the first instance by law required to be the determiner of the application. And the challenge to that determination, where it's a refusal, is simply to say it wasn't lawfully determined. It doesn't change into a kind of an application to fix liability on a judge, against a judge. And so we submit that when that recusal succeeds, the obligation then rests on the appointing authority to replace if there is a vacancy that must be replaced. It is that appointing authority which bears the consequences of the recusal being approved. In the case of a court, the head of court will appoint a new judge. In the case of the commission, the president might appoint a new judge or a commissioner, or might say the current commission continues as constituted. And a prayer for cost doesn't change that point, because except for the arguments the court had with my learned friend about personal costs and liability for personal costs, ordinarily costs where you're acting in an official capacity, the liability to pay those costs will be on the public body that appointed you. It wouldn't be on the commissioner or the judge in this case. And the question, of course, is entirely within the discretion of the court. So to protect the presiding commissioner, to avoid attacks, you could refuse personal costs. So it doesn't change the nature, we submit, but of the proceeding. And that's the basis, the two bases on which we say the majority was wrong and we say the minority was correct. Now, we ask for direct access if the court is with us that we are right on the section 47. We must satisfy the court first that there is a case for direct access. We say there is. Firstly, this case was brought on an urgent basis in the High Court. There was no dispute in the High Court that the matter was urgent, because the constitutional validity of the composition of the commission is a matter of huge public importance, given the task that it is required to perform. And so the matter proceeded on an urgent basis. Nothing has changed, other than that the lifespan of the commission has changed, been increased to December. But in the meantime, my client has been issued with a subpoena, was meant to have appeared before the commission in May, but having approached the High Court on an urgent basis to await the outcome of this court, that subpoena was suspended by a court order to the 1st of September. So come the 1st of September, and this court has not dealt with the merits of the review, my client is compelled by that subpoena to either appear or to go again to court, to ask that awaits the decision of this court. There is no time to obtain a final decision from the SCA on both the Section 47 point and the merits. To correct the point, we have not yet been given leave to approach the SCA. We only have a conditional application in the High Court for leave to appeal. The majority in the High Court may still refuse leave, in which case we'll have to petition the SCA. The petition may or may not succeed, and then we may or may not be heard by the SCA. The outcome of the SCA may be subject to an appeal to this court. By that time, either my client would have been forced to appear before that commission, despite the rights that he is asserting, or that commission would have ended without my client's contribution being heard by a properly constituted commission. And we submit, and we have all the faith in the courts. We have great respect in the judiciary and the huge function that the judiciary carries in our constitutional democracy. We have no doubt about that. But it is simply humanly unlikely that we would have a final judgment by the SCA on the 1st of September for purposes of my client and the subpoena that is awaiting. Finality in respect of recusal disputes is required, and certainty is required. This court emphasized this point in Bennett. I accept that Bennett dealt with the recusal of the SCA judges, and this court said it is the only court that can make the determination, and it must make that determination. But it says very, very important point about recusal, paragraph 22 of Bennett. These are important. First, at 18 it says, the question whether a judicial officer should recuse himself or herself is a constitutional matter. So too is the issue whether there was actual or a reasonable apprehension of bias, and legal and factual issues that need to be decided in order to determine the question of recusal or bias are themselves issues connected with the decision on a constitutional matter. The question whether the two judges of the Supreme Court of Appeal should have recused themselves, as well as whether the applicant has a reasonable apprehension of bias, therefore unquestionably raised a constitutional matter. And then it says, but what about the interests of justice? At paragraph 22, the court says this: these are important constitutional issues that go beyond the interests of the parties to the dispute. For an independent and impartial judiciary is crucial to our constitutional democracy. It is therefore in the public interest that these issues be resolved. As these allegations are made against the Supreme Court of Appeal, there is no court that can investigate these issues other than this court. This court, as the ultimate guardian of the Constitution, has the duty to express the applicable law in order to enhance dignity among judicial officers, litigants, and legal representatives, and thereby to contribute to public confidence in the administration of justice. You will have seen that post-Safu and Bennett, there is a debate between us and the Kalata group about whether the standard on previous associations is applicable here, and this court must say whether it does or doesn't. This is not about justices of the Supreme Court of Appeal, but it is about a very senior judge, former judge of this court. And it concerns a commission of inquiry at the heart of our democracy, because it is how we manage to heal the wounds attempted to heal the wounds of the past so we can proceed. And one needs that commission to continue with all the public confidence that there is. And this court's pronouncement on whether there is or there isn't a case for recusal will enforce that confidence and not undermine it. There is minimal necessity for this court to benefit from judgments of the lower courts. Why do I say this? You have the benefit of the three-bench court, where the minority has expressed itself on the prospects, and we submit that their prospects of success raise a constitutional matter, and the legal standard to apply on recusal applications is well established. And so the court doesn't need to hear what the SCA has to say about those. So we submit that this is an exceptional case to warrant this court's granting direct access. Now we must demonstrate a review ground, even if you agree with us. The first ground of review is the one my learned friend dealt with, which is the composition of the decision maker. And the proposition of law we make, and Justice Teron asked of us to say this, the proposition of law is a simple one, is that the Commission and the Chairperson are all creatures of statute. They only have the powers conferred upon them by law. They don't have power because the law doesn't say they don't have it. They have the power when the law says they have those powers. And the court will look at Rule 3 at page 011-662. I hope I gave the right citation, otherwise I'll be correct. Maybe 001, 662. Yeah, it's 001, not 011. 001, 662. That rule gives the chairperson to issue directives and make decisions on specific matters, for instance, about cross-examination of witnesses, the leading of witnesses. Those are powers specifically given to the chairperson. But substantive applications such as recusal are governed by Rule 11. That rule is very clear that you bring the application on notice of motion, supported by affidavit. The chairperson can issue directives on the conduct of the application, but the decision on the application is of the Commission. And so the ultra-virus point we submit is made out. Then the second ground of appeal relates to the recusal point. And here the ground of appeal, of review that we've raised is that the chairperson failed to apply the correct legal standard for a reasonable apprehension of bias on the chairperson's prior institutional roles and activities, or misapplied that test, resulting in an irrational outcome. Now, it's important I make this point. So the standard for recusal is a double reasonableness standard. But the court has recognized that there are circumstances in which, depending on where allegations of apprehension of bias are based on the judge's prior activities before they are appointed to the bench, that in those particular circumstances, an apprehension of bias may exist if it meets a certain standard. And that standard is set out in Safu and was confirmed in Bennett. And it is that standard we submit that the chairperson failed to apply, and in consequence committed a material error of law, or in effect failed to determine the matter. And that is a classic review ground, and it would very much equate to what this court said in the Louis Dawes case at paragraphs 26 to 27 of that judgment regarding the failure to apply a correct test or to apply it correctly. Here we say failure to apply the correct test and both to apply it correctly deal with, grants a review basis. And I'm running out of time to deal with the why we say so here. But I can say it is very clear, perhaps I can just round up that point. It's very clear in the founding affidavit, in the recusal application, in volume 22, at pages 011 to 891, 891 and 011 to 896, paragraphs 16 to 34, that the President Beki relied specifically on the chairperson's prior institutional roles as a basis to grant the apprehension of bias, and his roles she performed prior to being appointed chairperson of the Commission of Inquiry. I shall stop here in line with the bail. and
Thank you, Advocate Manager.
Sorry, Mr. Manager, just one question from my side. You raised the question as to why your client should have to get consent from the head of court to proceed with litigation, and arising from that, what would the consequence be when consent was refused, given that on the face of it there may not be a remedy and the refusal might be final, whether one could take that decision on review, I suppose, is an open question. And you urge for a more restricted interpretation, if I could put it that way, in relation to 47. But that concern that you raise would apply to any potential litigant vis-a-vis any judge, whether sitting or retired, not so. The procedural hurdle of obtaining consent. And if we should take what you say on board, then there's no way we cannot accept it in its fullness and say, well, this should apply in respect of retired judges who are not called into active services, but it should not apply in respect of other judges, because what we're called upon is to give an interpretation to the section. It's not an interpretation that will differ from case to case, as it were. So it may seem that the argument you make is an attractive one, but its attraction might be closer or closely aligned to a challenge to Section 47 rather than an interpretation of Section 47. And my concern is that we may get to where you want us to get by avoiding the challenge to 47, and I'm not sure if it's permissible to do that, to achieve an outcome that may be properly achieved through a challenge, but do it through interpretation. The court could then be accused of simply going too far in the interpretive exercise, when essentially the heart of the complaint is that this provision is oppressive. It's oppressive because it places an unjustifiable procedural hurdle to any litigant, irrespective of the status of the judge, in order to advance a case that Section 34 guarantees. What would you say to that difficulty?
Yes. So our submission is that one can achieve the outcome we submit by way of an interpretation that is faithful to the apparent purposes of the provision and 39(2) of the Constitution. And this is to say, where you have an active judge, I deal with a judge in service, the purposes, the two purposes we identify are directly implicated. Firstly, that when they are sued and have to appear in court, there may be an adverse impact on the proper administration of the court function. So that purpose is served in the case of an active judge. The second also is when they are now sued in respect of where they have faced frivolous suits arising from their judicial functions, when he's an active judge, that will readily be met. So it's in line with the immunity which judges must enjoy in order to secure judicial independence. It makes perfect sense that purposively the head of court would scrutinize whether the suit should persist against an active judge or not. And that concern would equally apply to a retired judge called back into service, because it implicates the same two purposes. But where you have a retired judge who is not in active service at all and is instead appointed by the minister or the president, firstly to chair a commission of inquiry, which is non-judicial, and therefore they are being sued, has no implications to the proper functioning of the court, or indeed judicial functions which they performed, then it makes sense to say the reach of the section doesn't extend to that. And you're still faithful to the architecture of the provision in the context of the Act as a whole. So we submit there's a ready distinction to be made, and even before getting to the nature of the proceedings, which was my alternative argument, on the principal argument, and that's how Judge President Benenge resolved what Justice Khampepe is raising. And it's important, there's another error that is committed, is that judgment is unhelpful because it contained maintenance and domestic issues are already excluded by that section. That judgment gave rise to that exclusion in section 47.1. That judgment preceded the exclusion and highlighted the necessity for it, because even a judge who's accused of domestic violence would need permission first, if it's a civil proceeding. So we submit that this court has done it many, many times, looking at the... Chesuse very, very well sets out the very steps for interpretation up to section 39.2, and preferring a constitutional interpretation. And it's possible within this act. What the majority failed to do was to even to engage with this, the consequence of what they said, because to the extent that they say that it applies to a retired judge sued in their personal capacity, it would apply to judges sitting as arbitrators, because those are sued every time when they make rulings that litigants are unhappy with. They're cited nominal offici in their capacity as arbitrators, but that's private, it's not public. And you would also extend it if you take if you're borrowing it from the Remunerations Act, it's much wider, because even chairpersons of inquiries appointed by ministers who happen to be judges would also fall within 47. Sometimes with the court-appointed mediators, these retired judges act as mediators. We have, and facilitators under the Intergovernmental Framework Act. They act as facilitators between disputing organs of state. So the implications of this interpretation to access to court is huge, especially if one concludes that non-compliance or failure to get consent means that the proceedings are a nullity. You can't even condone. And that, we submit, is also another wrong approach by the majority, because if you look at section 47, it is really regulating the timing for coming to court, that you must jump a hurdle before you come to court. And it regulates access to court. And there are authorities like the Toyota judgment of the SCA that we've cited, which say where statutory provision regulates access to court, courts have inherent powers to condone non-compliance. So in the case of a provision instituted without obtaining consent, it should be possible for the court to say, we're going to stay the proceedings, go and obtain consent. And it is eminently more reliable for the head of court, given pleaded facts, to decide whether that's a frivolous challenge or not. But where you have a recusal, where you have a consent by letter, no pleadings, so you've only got one version of one party, because the Chief Justice or the head of court is not performing an adjudicative function. is really expressing what is really a prima facie view, that these proceedings are frivolous and consent is refused. But once all the body of evidence is put together and those who must disclose are fully disclosed, the picture might change, but the door would be closed. If you say it's a nullity, that's the end of the story. So it does call for a restrictive, constitutionally compliant interpretation, and we submit that there's nothing on the language that is against the submission we make, because the language is very broadly stated and the court can read it down, so to speak. It is not a remedy issue, it is an interpretation issue. When one reads down, it's not reading in. We're not asking for reading in, we're saying read it so that it stays within constitutional bounds and doesn't unjustifiably limit rights.
Mr. Meneche, it seems you have two issues of concern with reading it literally, and that would be the width of what would fall under civil proceedings. You argue that recusal are really proceedings within proceedings and they relate to access to court, but also to the unqualified reference to any judge. So if we are to read it in the way in which you suggest we should, how would you suggest it should read?
Yes.
Without us legislating.
Yes, I do remember once I said to Justice Majid, that's an easy question, but the answer is very difficult. And he said, that's why he's sitting on that side. Today I wish I was sitting there, but
it's a difficult question. That's why I ask it to an intelligent part of the court.
Justice Khampepe, what's the word? Well, I think I've lost my English. If it was my mother tongue, I would have the right word to express the gratitude. But the point I make is that Justice Benenge, as sitting as a JP, found the conciliation. And that reconciliation was agreed to by just JP Mlambo, as he then was, save for, and I must say, when Justice Mlambo went further to talk about service, that was obiter, because in that case, Justice Motata was cited as in his capacity as a judge, so there was no question about commission of inquiry. So in effect, the ratio of the LP judgment by Justice Benenge and by Justice Mlambo is reconcilable 100%. And that is the reading. It is this, that provision applies to active judges in either acting in their capacity as judges and performing judicial functions. I'm careful not to just say capacity because it seems it would implicate both. So it's a capacity of a judge where you can be allocated to perform judicial functions, or when you have performed judicial functions, or the suit arises from the performance of your judicial functions. If it's a retired judge, it must be when they are called to perform judicial functions, or a suit arising from what they did when they were judges, not what they did when they were sitting as a commission of inquiry. And we submit that's yes, and sometimes as lawyers we tend to get more ambitious about what we ask the court to achieve, but always remembering that we're dealing with the facts of this case. Ultimately, even if you disagree with what we say should be the meaning of the provision, the second alternative point which Justice Khampepe raised about the nature of the proceedings, are these proceedings against the judge, may justify a conclusion that even if you disagree on the main interpretation, you agree with us on the application to this particular fact. And that's where the fact that similar cases are pending in the SCA may not be a definitive response to our direct appeal, because this case could be decided on a narrow point as the minority did, and not on the bigger point which those cases pending in the SCA are forced to grapple with. In other words, it is open to this court to not be definitive on the full interpretation, the primary interpretation we submit, but nevertheless find that this is not, even on the interpretation of that section properly, these are not civil proceedings against a judge. These are sui generis proceedings akin to an appeal proceeding against the refusal to recuse, and a constitutional interpretation of the provision does not allow for this extension. Otherwise, you produce upset results, and our law is clear that where an ordinary interpretation of a statute may result in upset results, that ordinary interpretation may be departed from, and also that the 39.2. And I must also highlight about Mantashe. The utility of Mantashe must also be factored, because that court related to Chief Justice Zondo at a time when he was still the serving Chief Justice. So it is very likely, it's very possible, I don't know the facts, that when the Chief Justice regarded whether permission should, that permission may be required in that case if the suit might have affected the allocation of cases for the Chief Justice in this court, because he was still a serving judge. So all of these judgments which have been referred to and adopted whole as borders were all dealing with peculiar facts which are wholly different from the present. And that's why the minority is correct at those paragraphs that I referred to, that this case raises a novel point, which has not been decided by any of the cases that the majority said they were bound to follow, or they thought it was correct to follow.
Good, Mr. Manager. I think, just finally, that what you contend for is an attractive approach, and that it's one that may lean strongly towards it being constitutionally compliant. I'm not sure if it simply requires the court to go a bridge too far in terms of what it has consistently said is its role and the line of separation. Yeah. But I think you've made the argument, and it's something we must consider.
Yes, Justice Golpan, that line about separation is very sharp where you're being asked to read into the provision, because then you're adding to the statute, which is what the legislature should do. But here all we're asking is what the court does all the time, is properly read the provision. If the provision is capable of a reading down that retains its constitutional compliance, that is the interpretation that this court has to adopt under Section 39(2) of the Constitution. And the authorities are legion in this court.
Could we take a short adjournment, not longer than 10 minutes, just short, to deal with something urgent? Thank you.
As the court pleases.
Thank you. We may look alert and strong, but we are octogenarians here.
We are also getting the
Thank
CJ.
you.
Mr. Manechi, just one question. The applicants appear to argue, and the respondents also appear to argue or conceive that if we approach the merits of the review, we will be exercising direct access. Now, as I understand it, the applicants in this case don't raise any grounds of review that weren't pleaded in the High Court. You treat it, or you call it, direct access because the majority in the High Court didn't reach these questions and decided the case on a preliminary basis. Of course. Now, when that happens and a case is brought on appeal, let's assume you get a leave to pursue a direct appeal. It is always open to the court on appeal to say, well, we disagree with the court ar quo's decision on this point, and we must now decide what order that court should have made. And on that basis to consider the issues which the court below left open. The AD and SCA has done it all the time, and they don't have a jurisdiction to entertain direct access. This court did it recently, for example, in APSA versus Commissioner for SARS, not perhaps altogether dissimilar, where the SCA had held against APSA on a point that they couldn't institute proceedings without the prior leave of a court.
Yes.
And this court held that they were wrong, the SCA was wrong to have done that, and then we proceeded to determine the merits, and we never conceived of that as direct access. It appears to me that if you get direct leave to appeal and we reach the merits, we will be doing so in the exercise of appellate jurisdiction. As an appellate court, we would have two options. We could say, well, we are going to remit the matter to the court below, or we are going to decide those issues and make the order which the court below should have made. Either of those are ordinary appellate functions. The very fact that we can remit tells us that we're not dealing with direct access because there's already a court where these matters should have been decided. In direct access, if we refuse it, we simply refuse it, and the party must institute proceedings at first instance in another court. I can readily accept that the sorts of circumstances which we take into account in deciding whether to grant direct access might be relevant to decide whether we should remit this case, if we are with you on Section 47, or entertain the points which the majority didn't decide. But unless I'm persuaded to the contrary, that doesn't require direct access.
Yes, Justice Rogers, thank you for that. It just shows which side is the clever side as opposed to Justice Colopin's earlier suggestion about our standing on this side. Justice Rogers is absolutely correct. I recall that we cited a case in our heads regarding the validity or recognition of Customary Marriages Act, which we cited the SCA judgment, but it came to the Court, and the Constitutional Court decided it on an issue which was not decided by the High Court nor by the SCA. And I was on the losing side because we lost on that very point. And this court even called for expert evidence on the existence of a customary rule in order to determine that issue. I just don't remember the case offhand now, but my juniors will ask. That is correct. So out of caution, we asked for direct access, but what we are really trying to persuade the court to do is not to remit after engaging the direct appeal. It is to determine the case as a whole. And I do accept that the same considerations for direct access would largely feature in determining whether to remit or not. And
with
that's
this
why
distinction which applicants in your client's position potentially have in their favor is that they didn't try to bypass a court of first instance. They brought their case there, but the majority in that court just didn't address them.
Yes, that is correct. That is correct. So we can ask the court not to remit, and for the same reasons we advance for direct access, ask that the court should determine the merits. And the merits are in two parts. The first is to exercise the review jurisdiction, whether we are right that the ruling must be reviewed and set aside. And then what must happen to that ruling once it's reviewed and set aside? We ask for substitution, which is which would be a discretionary remedy by this court, whether to remit the ruling back to the commission to decide afresh, or whether for the court to say, we've got all the facts before us, we are in as good a position as the commissioner, and under TRENCON, this is an exceptional case in which we can decide the merits, the merits as in the remedy that must follow a review. And that is the case we ask the court to do.
I did tell the Deputy Chief Justice I would ask only one question, but
Yes.
perhaps he will allow me to just follow it up with, on a slightly different but related point. In regard to the contention that the recusal ruling should have been made by all three commissioners, if you overcome Section 47 and the court should be with you on that point, do you say that we should, what do you say we should do about the other grounds of review? Should we then not decide them, send them back to send the recusal ruling back to the Commission for a decision to be made by all three? Because it's an interesting point to run, but unless you are seriously asking that we send back the matter to the Commission to be decided by all three, it's really an academic point. If it's a point you seriously persist with, it appears to me the proper course would then be for us not to consider any of the other recusal grounds or any of the other review grounds, and to just send it back to the Commission to decide as a collective. I must say I'm not particularly attracted by the view that that the collective has to make the decision. But it's a point that is raised, and it's maybe not straightforward. So what do you say should happen if the court is with you on that review ground?
So our first submission is, even if the court reaches the conclusion that the full commission should have determined the matter, and that the determination by the chair, by herself, is ultra vires, it still leaves the scope for the court to substitute along the lines of TRENCON. The considerations that are taken into account there is whether the outcome is a foregone conclusion, in other words, on recusal. And that requires the court to engage the other grounds of review and the merits on the review, on the recusal. And to do that, is a court in as good a position as the commissioners? Yes, it is. Everything is before the court. The third consideration that's also taken into account is a matter of delay.
If we are in as good a position, but we come to the opposite conclusion to the one you like, and say, well, there were no grounds for recusal on the merits, is there any point in remitting it?
There's no point. I must accept that. Then there's no point, because...
So where does the point go, the ultra vires point? Is it relevant only if we are left undecided as to what the outcome on recusal should be?
It's good if you are decided on the outcome of the recusal, because then you can substitute, because then it's a foregone conclusion. But if you're unsure, it's not a foregone conclusion.
Either way, then it seems to me remittal's a waste of time.
I beg.
If we are sure either way, if we
Yes.
are sure that there should have been recusal or sure that there shouldn't have been, then there's no point in remittal.
Justice Rogers is correct. If you're sure that there should have been a recusal, then on our submission, substitution is competent, because it's a foregone conclusion and there's a fairness, delay, all of those factors. But if you're sure that there shouldn't have been a recusal, there's no point sending. It's unfair to the commission, it's unfair to the public interest, even to us, for us to go back and argue something this court has already expressed its view on. So it would be the end of the road.
Sorry, let me follow up on this debate and just be clear. If you are good on the 47-1, that does not satisfy you, we need to go and consider the recusal.
Yes, you reach the recusal.
In other words, you can't leave this court with, say, success on 47-1 only, and the recusal is pending or nothing is said about the recusal. For you to be successful, both points have to be decided in your favor. Am I correct? I just want that formulation properly.
Yes. So there is a
Because the High Court said the proceedings absent consent are a nullity. But you would say now, if you're successful to say the High Court was wrong in all its interpretation and construction that this was a nullity. Having said it's not a nullity, you are now in the area of the recusal, and you would say, entertain my application for a recusal that is premised on the proposition that this would be akin to some direct access application, because the majority did not deal with it except for the minority. And then you would say, if you are correct on that point, you should be successful on 2 points. A success on 1 point would not be good enough. Or am I conflating them?
So I can answer to that. Yeah. So we see 2 options in relation to our application. 2 main options. So the first option is the court accepts the direct appeal in relation to section 47(1). Says leave to appeal is granted and you succeed that the High Court was wrong. Yes. If we succeed, this court has 2 options. It can either send that review back to the High Court for the majority to decide, for the court to decide the review afresh.
But then my point comes here.
Yes.
And if it's remitted back to the majority, if it's remitted to the High Court to decide it, is it the same panel that is going to decide it?
It probably would.
And if it's the same panel that is going to decide it, for which you would have expressed less confidence in that panel, and how can that panel then be in as good a position to decide the review application?
Is that is in part the reason why we say a remittal to the High Court should not be the preferred route for this court, because you're going to send it to the High Court to decide the merits again, where one of the judges has already said that there must be a recusal.
It falls within the Trencon
yes.
rationale of a foregone conclusion.
As we submit. So if we are with us on 47, we ask that the court must then do what the majority failed to do. In other words, do what the minority did, which is to decide whether the review must succeed and whether substitution must succeed. And we say that part benefits the public interest, it benefits the commission, it benefits the families, it benefits us, because this court will either say Section 47 was wrongly decided, the review grant is good, but you didn't make out a case for recusal, in which case the commission carries on with all public confidence. And my clients, having had the final word from this court, will then participate. The second possibility is you will say, as we urge the court to do, is the review succeed, you had a good case on recusal, on substitution, we say there should have been a recusal, in which case the president must act on how that commission carries on with its work without this complaint hanging on its...
Should it matter to us whether the commission has gone that far or not, or it's something that should not be of any concern to us?
If the court gets there, if the court gets to substitution but believes that there is a concern about what happens to what the commission has done so far, the court under Section 172 of the Constitution would be entitled to call on the parties to say what should happen. In other words, in exercising its just and equitable remedy. The parties will make their respective submissions. The ones might say that everything that was done is a nullity, but the other party might say, well, justice and equity gives you scope to save some of what has been done in one form or other. Or the court might say that must be resolved by the reconstituted commission, and the parties involved, they must decide how those proceedings will continue. But that is on the assumption that the court finds for us on 47, finds a grant of review, and upholds the recusal. Then the questions about what happens to the commission come into the fore. But the question about what happens to the commission don't feature in deciding whether a recusal case has been made, other than in the context of the argument about delay. But it doesn't enter because that's not the test for recusal will be determined on the standard and on the facts that have been pleaded regarding recusal. As to what happens to those proceedings, the law has expressed itself in relation to proceedings where a panel member or the whole panel was disqualified, that is a nullity, that's the state of the law. But whether that is automatic in every instance may be something that this court will have to debate if it reaches that point.
But it does not seem to me that there is a shortcut to this.
Yes, there isn't a shortcut.
If the tree happens to be poisoned, one can't have a bite.
No, you can't have a bite. That is what the law says. It's not just us saying so. All of the cases in the SCA say that because recusal goes to the jurisdiction of the panel or the tribunal, once that panel should never have said everything that they've done is a nullity and can't be saved. But we are not engaged in that debate at present. And if this court wanted to have that debate, once it is clear that it foresees that it might reach that point, then the court is very free to invite the parties to make submissions on that point.
No, but I just want to decline that invitation about
I understand,
inviting the parties to file submissions on the just and equitable remedy.
Yes, when the law is clear.
Yeah, but the law says if there is a problem with the constitution of the panel and how it conducted its affairs, and how can written submissions ex post facto breathe some new life into to use Mr. Mpofu's word, something that is dead in the dustbin. And I understood how he used the words.
Yes, Justice Matopo, I'm indebted to that clarification. It is consistent with the law, Justice Matopo, and that is the law, that's the rule of law.
But shouldn't we look at it in this way? Put aside everything that has happened and ask ourselves the question. We have a challenge to the Commission. The challenge is premised on the Section 47(1). If it's not good, right, it means the order of the High Court, the majority in particular, has to be set aside. And then we look at what brought or what necessitated the challenge. What necessitated the challenge were certain allegations which morphed into some submissions that the chairperson, as a result of her previous institutional role, may have been conflicted. And if that argument is good, there's nothing that we can do.
Yes, that is correct. That is the law, and that's what the Constitution requires, because Section 1C says the rule of law is a founding value, and the Constitution is paramount. If what has been done is inconsistent with the Constitution and the law says nullity, that is what it is.
We haven't tested today, maybe me, I haven't tested with any of you, the role that the chairperson played previously in her previous life, and also the terms of reference As I recall, the terms of reference starts from the year 2003.
Yes.
Right? Are we able to shut our eyes and say the starting period is 2003, and then we are going to consider what started from 2003 going forward? But if what transpired or what could have transpired prior to 2003 have a bearing on 2003, and I was part of, or whoever was part of or played a role in 2003, how do we separate the role to say 2002, whatever you did, it's not worthy of consideration. We will be looking at 2003, and are there no overlaps?
Yes. So that's a very important question, because it also goes not just to the facts, but to the test that the court will assess. Now, it's not possible to shut your eyes to 2003, to what happened before 2003, for two reasons. It is that, as you've seen, the genesis of the commission is the application by the Kalata Group in the High Court for constitutional damages and for the establishment of a commission of inquiry. And the basis of that application was there has been political interference, which starts in 1998 when the ANC leaders engaged in discussions with the apartheid generals to try to find a way to avoid prosecution of TRC cases. That's the first point. The second point, it is in 1998 that the Amnesty Committee sends a list of the cases where amnesty was not granted, where prosecutions by the NPA should take place. At that time, the chairperson was both in the Amnesty Committee sending the list to the NPA and in the NPA laying the groundwork for the prosecution of TRC cases. She was second in command to the NDPP. In terms of Section 5 of the NPA Act, she is part of the office of the NDPP. So that's what they were doing at that time. Now, the Rule 33 notice that was issued against my client wants him to account from 1998 dealing with those meetings with the apartheid generals, because they say those meetings happened because the ANC 37 were concerned, or for the ANC were concerned that they didn't get amnesty, they may be open to prosecution, and so they want to do a deal with the apartheid generals, and this informs the genesis. And the notice from the commission itself calls for the response from President Mbeki and the other executives, Minister Mabandla, former Minister Mabandla, and President Zuma, to account for all of that from that time.
Okay, let's just back it there.
Yes.
If President Mbeki, former Minister Mabandla, or would be summoned to account for the period from 1999, which period would include the terms of reference, and if the chairperson of the commission was present during that period, the period for which President Mbeki is called upon to account, how does she sit
Yes.
and bring an impartial mind to bear on the proceedings? Can it be reasonably accepted that the fact that she says, or the terms of reference talks about 2003, she is insulated from the happenings of the year 1999? One. Secondly, if the former head, Mr. Bulelani Ngcuka, who has already testified, he probably would have testified about the period before, and which would include the period 2003 to the extent where he was involved. He would have his own cut-off period to say, I was appointed on this day, and my term of office ended on this day. I can cover this entire period. If in the process of covering this entire period, the chairperson is there in that period, is it not something discomforting? And put it differently again, assuming Mr. Bulelani Ngcuka was indisposed, and we know that the chairperson was the deputy, could the deputy be lawfully compelled to go and give evidence there? And if she could, then what does it make of the process?
She can definitely be compelled because both her boss then at the time and the Advocate Ackerman SC and Judge Saldana, who was in the unit with her, are all in the NPA with her at the time, are all witnesses who are testifying about that period. And here's the important part about that period, Justice Matopo in the court, is that so she was in the TRC sending the list to the NPA. The NPA had to put in place processes to see to it that those that needed to be prosecuted are prosecuted. Now, there has been a failure to prosecute. That's the reason for the commission.
For this commission.
The commission has to basically unearth the reasons for the failure to prosecute. The reasons could either be, as the terms of reference ask, if and whether there was political interference which accounts for the failure to prosecute. So you could find that the reason for the failure to prosecute to be external interference, or you could find the failure to prosecute to be internal failures within the NPA. Now, and we've put the witness statements here, as between the NDPP Advocate Ngcuka at the time and Advocate Ackerman, there's a sharp dispute that Advocate Ackerman says the failure to prosecute was because of external interference. Advocate Ngcuka says, no, it wasn't. I'm not aware of any external interference. We were doing our work internally. So it is highly possible that after having heard all of this, the commission may have to make a determination whether the proximate cause, the real reason for the failure to prosecute, was internal to the NPA or external to the NPA.
But that is a problem.
Then she was in that NPA in 1998, 1999, when they were setting up in motion the prosecution. Now the test which we submit applies where one complains about prior roles or prior activities is set out in Southway at paragraph 76 and was confirmed in Burnett at paragraph 78. And it is this, that prior associations and activities of a judge would give rise to a reasonable apprehension of bias if the subject matter of the litigation, in this case the inquiry, the commission inquiry, arises from your prior roles and activities. So that's what you need to ask. Now, you will read the ruling. Justice Khampepe asked for a logical connection. When she says the logical connection, she looks for an overlap in the issue she must decide now with the issue she decided then, and then she looks for the temporal overlap, which is the 2003 versus 1998. And that is not the test which Burnett and Southwood says you apply. It's a broader test. You're looking at whether these matters now arise from there. Now they arise from there because it is the failure to prosecute by the NPA which has given rise to this inquiry. This inquiry must determine whether the failure was external interference or internal failures. She must inquire into that. And the families whose family members are the victims are before her in decisions she made to refuse amnesty. She was part of the panel of refusing amnesty. And she was also part of the panel which said the ANC 37, you don't qualify for amnesty because you haven't confessed to individual crimes. Now, those ANC 37 are the accused, so to speak, in the inquiry because they are the ones that are accused by the Kalata group as having interfered politically with prosecution of TRC cases and must be criminally charged. That's really what this thing is all about. Now, and we're talking about apprehension of bias, not is she going to be actually biased. It's just my client looking on and saying, and the bigger point also is that unlike in Safu and Bennett, Justice Khampepe has failed wholly to fully disclose what her role was in the NPA regarding TRC cases.
I was just about to get there, whether do we know prior to 2003, what is it that she did that would distance herself from the recusal application? In other words, on the Commission's pleaded case, when it was suggested or alleged that your prior institutional role precludes you from proceeding with this matter, is it set out in the answering affidavit to say, yes, I was involved with the NPA during this period, but my period was limited or included only this, and what is the Commission now investigating does not cover the period or include the period that I was with at the NPA?
No. What they say is, so firstly, in the recusal application, so the recusal application was a sequel to a letter sent by the Kalata group saying the chairperson and other people played this role in the NPA. If you want to object, you must object. The chairperson acknowledged receipt of that letter, made no disclosures at all. And then there was the recusal application which said, you gave advice to the NDPP in relation to TRC cases through the HRAU, which was the unit set up to deal with TRC cases. The answering affidavit in the recusal application was filed by our colleague Semenya SC on behalf of the Commission. He recounted the allegation at paragraph 35 of that affidavit and did not deny it, but argued why that was not a matter given rise to recusal on the basis that she wasn't involved in political interference. And this commission is about investigating political interference. So there's no overlap in the issues. Who must get amnesty or mustn't get amnesty is not before this commission. And anyway, the time period starts from 2003. That's the case that is made. And we said, but then everything is common cause. What we say is common cause. On the common cause facts, we apprehend bias. In the ruling at paragraph 20, the chairperson says, the facts regarding, the allegations regarding her prior roles are common cause. The only thing she disputed at paragraph 52 was she has no knowledge of any policy she shaped about TRC cases. She just said, because she says, I have no knowledge, you haven't told me which policy it was. So she never denies that she advised the NDPP on TRC cases. And then,
would you have been satisfied if she had gone on affidavit to say, as the NDPP, as the deputy NDPP, all that I did was, say for example, cash in transit trial in criminal cases. I did not do political cases that the commission is subject.
yes. Yes, that would have alleviated the
That would have
concern.
alleviated any apprehension.
Yes. And if you look at section 5 of the NPA Act, it says you have the NDPP, then you have the deputies who are all part of that office, but there are various functions that they can perform. So they might be, I think it's, So in her case, she was the second in command of the NPA nationally, right? But if she had said, my role in the NPA had nothing to do with TRC cases at all. I didn't know what was happening about putting together the prosecution of TRC cases in 98 and 99. That would have gone some way to alleviating the concern. And that is why the cases say non-disclosure fuels the smell as opposed to dealing away with the smell, because my client says, but why isn't she coming clean? It heightens the apprehension.
Does the fact that your client, in his previous role, may have some knowledge about the chairperson's role have any bearing at all in this application? That you knew back then you appointed me, or I was appointed by this person to perform this function, and you cannot come today and say there is some institutional bias. Does it play any role, if any, at all?
So my first answer is it doesn't, because he was appointed for specific roles, not to investigate failure to prosecute, which is what she's now doing, bearing in mind her prior roles. But even that is not a complete answer, because not all of the facts complained about are in the public domain. So it's in the public domain to the knowledge of my client that she was in the TRC and she was in the NDPP. She was NDPP. But he doesn't know what she was doing in the NPA regarding TRC cases. And he complains that, I understand you did advise on TRC cases, and she doesn't come and say you are wrong. And that will be stuff that's in her drawer. It's not something that's in the public domain. You're not going to find on the website of the NPA what she was doing but if you want to know what the unit that he says he understood she was working with was doing, you will find that in the statement of Justice Saldana, who was the chair of that unit, at 001-992. He says it was dealing with TRC cases, and it provided advice. It produced a memorandum or report to the NDPP regarding the prosecution of TRC cases. And some of it, in Advocate Nuka's case, he says some of them were not prosecuted because there wasn't sufficient evidence. They were not winnable cases. It might be that the investigation finds that that was a mistaken position to adopt, and that those should have been tested in the courts, as we know of another case which initially started off on that basis, and now my learned friend is busy fighting it in the courts. So it is very well to say, but I'm only looking at interference. But interference is not assumed. That's why the terms of reference say whether and if. Because if they were assumed, all that the commission would be about is who did it and when and for what reason. But it's possible that ultimately the real reason for the failure to prosecute is internal to the NPA. And there's an additional point which would worry my client. There is a judgment of the SCA in Rodriguez. That judgment says the executive interfered with prosecution of TRC cases and is based on confessions evidenced by NPA officials in which my client and the executive were not parties and didn't provide any evidence. When my client tried to do that in the Pretoria court, this Pretoria court where they won damages, to put his side of the story, they said he's got no interest and kept him out. So you're starting at a premise where there is already a perception upheld by a court that the executive interfered. And that's based on NPA evidence, and somebody who was in the NPA is investigating that very issue, whether the cause of the failure to prosecute is political interference or some other reason internal to the NPA. So we submit, and recusal calls for a normative inquiry. It's not an easy 1 + 1 = 2. It is a value judgment, and we submit that, and you must put my client in the position of a reasonable person, just knowing these facts and not having full disclosure and entertaining this apprehension. It is wrong, we submit, in that context to say that the apprehension is unreasonable, because you haven't proven facts about what exactly I was doing in the NPA regarding TRC cases, when that knowledge is only known to you.
So finally, you would contend that inasmuch as your client has been asked to appear before the commission sometime in September, following the subpoena, this is one of the factors that are in the interest of justice, demonstrate that you should obtain that relief. Because if your client does not appear before the commission on the date, consequences may flow from that.
Yes, we know the consequences.
I don't know the consequences.
My learned friend represents one who was
No.
victim to those consequences. If he doesn't appear, he breaks the law and there are consequences. So that's why clarity and certainty is required, both in the public interest, for the interest of the families and the public and my clients, that it's clear that that commission is properly constituted and my client must appear. If it is not properly constituted, it's not the end of the case or the matter. The president can constitute a proper inquiry and it can carry on and investigate this very important matter. And my client is ready and willing to account. He had wanted to be the first witness to this inquiry if it was properly constituted.
Would you criticize the president of the country for filing an explanatory affidavit and explaining what he said, to say, I did not know the facts. Had I known the facts, my position would have been different?
No, we can't, because my client too says, I didn't know the TRC bit in the NPA, and you're still not telling me. But what I understand is that you were involved in the early stages of TRC case prosecution. So what happened at the early stages could very well have contributed to the failure to prosecute, but you were part of that. Now, President Ramaphosa is very, and the majority in the High Court says he did the right thing to explain his position, that he would not have appointed her.
Well, they use the word commendable.
Commendable, absolutely. And we commend the use of that word. It is correct. And
Thank
it
you.
is worrying that even the appointing authority says, I'm worried about public confidence in the commission given this. So clarity is absolutely called for in all respects, we would submit.
Thank you.
As the court pleases. And of course, we rely on what we've said in the application for leave to appeal in this regard. If I can just give the court the references where we discuss the proper application of the tests. It is at paragraphs 237 of the founding affidavit in this court to 239, and is page 001-215, and to be read with 295-303, that's the page, 295-303, and is, sorry, 295-303 is the paragraphs, additional paragraphs, at page 001-233. And the test we submit is set out. If I can just complete that answer to that, the debate with our learned friends for the Kalata group is they say, but it is unclear that Sarfu at paragraph 76 and Bennett at 78 were setting a standard for assessing prior associations, and whether these prior associations here are similar to those, because they, in the case of Sarfu, we were dealing with political associations, prior political associations, and in APSA it was prior commercial associations. But what they overlook is that in both paragraphs, in 76, this is what I can read, is in our opinion, it follows that a reasonable apprehension of bias cannot be based upon political associations or activities of judges prior to their appointment to the bench, unless the subject matter of the litigation in question arises from such associations or activities. So it's not limited to associations, also activities. Institutional roles, activities, she was all involved, is activities, prior to appointment as a commission. It's the same is emphasized paragraph 28 of Bennett. Prior association with an institution cannot form the basis of a reasonable apprehension of bias unless the subject matter of the litigation in question arises from such associations or activities. So if I can just underline the point. So when Justice Khampepe says, show us a logical connection, what she needed to, the question she needed to ask, to answer that question, was this question in these paragraphs. not the question whether there's a clear identity of issues between what she did prior and what she's doing now. And that's where the mistake was made, and as regards the timing as well, that's where the mistake. She referred to the right judgment, but just did not rely on the correct paragraphs. The paragraphs she quotes when assessing logical connection are the paragraphs in Burnett which deals with financial interest arising from shareholding. And those are discussed in Burnett around paragraphs 53, 56, and the like. That's a different test than the test here. This is a test. This is the standard. You are saying as a start, prior associations per se do not give rise to a reasonable apprehension of bias. But if the subject matter of the litigation, in this case the inquiry, arises from the prior activities, then a reasonable apprehension of bias can arise. And that she didn't answer, and we submit if she had answered that question, she would have found in our client's favor. So Justice Majid, I just wanted to complete that question, but I am conscious that I thought you wanted to ask a question. I'm not inviting it, Justice Majid, I'm just saying, no, my mistaken observation.
No, I'm shocked because I think you can read minds, eh? Yes, I said to the DCJ, I only have one question, but based on the precedent set by my brother Rogers J, I have one extra one, but I'll ask them quickly. The first, on behalf of the Kalata group, Mr. Badende submits there should be a higher threshold for commissions of inquiry members or chairpersons. Let's say, just say members, because A, they don't perform on adjudicator functions, they are just merely make findings of fact, and secondly, they don't make binding recommendations. What do you say about that?
So, we don't understand our learned friends to be saying that fairness doesn't apply to commissions of inquiry, because that principle applies, and Corruption Watch establishes that. And commissions of inquiry also work within the principle, the confines of the principle of legality. So you can't say you can have an investigator who has a closed mind or brings not an impartial mind to bear on the issue. In fact, the main and guardian judgment of Justice Nugent makes it very clear that an investigation which is not approached with an open mind is not an investigation at all. Now, those principles implicate a bias, so you can't have a biased investigation. So that applies to commissions of inquiry. When our learned friend says a higher threshold, that threshold can't relate to the accumulation, the quality of the evidence you must present. Bias is clear, the standard says it must be double reasonableness standard based on proven facts. The facts here are common cause, the only difference is the implications of those facts. If by that they say you must be more permissive of a potential apprehension of bias existing in a commission, and even when a complainant raises the complaint, you must allow the commission to continue, would say that's wrong. That's wrong because that's wrong. It strikes at the very heart of our, whether one looks at under Section 33 of the Constitution about fair administrative action, or whether one looks under Section 34 of the Constitution, one of the fundamental values of our Constitution, and that we emphasize, is fairness. So you can never attenuate that the application of that principle against bias, given the nature of the proceedings. What that might enter the fray is when you are asked to review the final findings. There, the appreciation of the nature of the role that commissions play would be important, and that's why in Corruption Watch you don't apply the higher standard of administrative of parture, you apply the lower standard of legality and rationality. That strikes the appropriate balance about appreciating the role with respect. That would be our submission.
That's my second and last one quickly. You rely heavily on SARFU for this, you and Mr. Mpofu, for this question about whether the collective should have made the decision and not just the chairperson. Now in SARFU, remember there it was not only against specific judges, it was against Shaskelson P, Langa DP, Sachs J, Yakub J, and Krichle J, but also the court as a whole. And that's made clear in paragraphs 15, 34, and 65 of the judgment. Now, the applicants make the point that in the first paragraph of the judgment, the recusal application judgment of the three SARFU judgments, in paragraph 2 of the order, the court holds, the applicant has failed to establish that objectively regarded there are grounds for any of the 4 judges to recuse themselves. I said 5, but it's 4. And then each of the 4 judges concerned agrees with this conclusion as far as it applies to himself and declines to recuse himself. And the application for recusal is dismissed. But that was done in the individual judge's case, but also for the collective. So isn't SARFU on that basis then distinguishable? Because you have there an allegation directed at certain justices of the court, but also the court as a whole.
Yes, I readily accept that the facts are distinguishable, but our reading of SARFU is that there is an underlying principle which informs why the court, and I also accept the utility of the precedents in that regard set by SARFU, because the parties seem to have made submissions to the same point, supporting the collective decision-making. But there is an underlying principle which we think informs why it is probably constitutionally proper that it must be made by the collective, is that there is a duty on the other panelists not to sit with that panel member if that panel member refuses to recuse themselves where they should. So it does mean that the other panel members must apply themselves to where the recusal was indicated. They can only do so if they know what the person knows. So if you take our present case, we complain that the chairperson, maybe the chairperson didn't have to file an answering affidavit, but could have put a statement of fact saying, as Justice Matopo said, my role in the NPA in that time was X, not what you complain about. That would inform the others to form a view whether she ought to recuse herself or not, and whether they have a duty not to sit in that panel going forward. And we think that underlying principle is important to inform the need for that collective determination. Because the deficiencies suffered by one member vitiate the whole panel, and that was made clear in State versus Basson. Sorry, the HPCA, I can't recall whether, it's not the HPCA one, the one in the SCA, that if one member ought not to sit, the whole panel is not properly constituted.
Is the Basson matter.
That is
thanks, I think you've answered my question.
Can I just give, and then the second answer to that, Justice Majid, is that here, unlike a court, we're dealing with a creature statute. So she can only decide if the empowering provisions say she can decide alone. And neither the Commissions Act, the regulations and the rules were issued by her as empowered by the regulations and the Commissions Act. Those rules don't give her that power, and she can't take it for herself. So that answers the distinction with SARFU, the last one, the creature statute, because it stands on its own.
Mr. Manech, can I take you back to the Section 47 interpretation, and specifically the distinction between judges in active service and retired judges? If we accept the threat of vexatious litigation or abuse as a threat to the independence of the judiciary, what is the reason, or how does that purpose come to an end or becomes inapplicable in relation to retired judges?
Is that vexatious litigation related to your judicial functions as a retired judge on our submission is protected. So if you call back to, is protected by Section 47. If you're called back as a retired judge to perform judicial functions, and there's litigation arising from there, the control mechanism in Section 47 would be operative, so it would protect you. But if the vexatious litigation is in relation to you chairing a disciplinary inquiry, or being an arbitrator, or a commission of inquiry.
Before we get to, I will go to the distinction between judicial and non-judicial duties. I just want now the distinction between judges in active service and those that are retired. Why are we saying that the judges who are in retirement, or just generally, that the specter of vexatious litigation doesn't affect the judiciary or judges in general, to the extent that retired judges should also be protected?
So our submission is the specter of vexatious litigation as regards judges is important under the statute when that might impact your judicial functions, because then it impacts judicial independence. If vexatious litigation is against me as a judge, but I'm retired and farming elsewhere, and that's where I'm facing vexatious litigation, that has nothing, that doesn't threaten the independence of the judiciary.
So why doesn't the specter of vexatious litigation after I retire not threaten me now whilst I'm doing my duties, knowing that what I'm doing now may have repercussions later when I'm retired?
Because you know that if that vexatious litigation relates to your judicial functions now, then you have the protection. Because it's a judicial function that...
I'm not sure, perhaps I'm not sure what we mean by vexatious litigation. Does it necessarily relate to a particular case that you did, or it may be just vexatious litigation that, drums up something out of, nothing that you may have been seen doing at a country club or whatever, but because a litigant is aggrieved by a decision that you took, then that is the manner in which they act out their revenge.
Yes. So the way we understand the Act and the Constitution is it is concerned to protect judicial independence. And it wants to ensure that judges function without threat that what they do, which makes other people unhappy, might result in litigation. And Justice Mlambo expresses that very well in the judgment in Mutata J, concerning Mutata J. That's the primary concern. It's not simply because you were once a judge, we are concerned to protect you in all respects in relation to litigation. If you're retired, you've been retired for 10 years, you've never been called back to do any service, but you've knocked my car and I sue, and that's vexatious. With respect, it would be extending the purpose in our submission of the provision to say, even in that case, you require judicial consent before a judge can be sued, which is completely outside the concerns of the legislation.
It's just that I can imagine litigation that's vexatious, that may not, on the face of it, relate to a particular case that one did when they are in active service.
Yes, and you would need some evidence to show that there's a linkage between that case and the judicial
Well, perhaps
function.
that's why the legislature then says, I'm going to protect all judges. And that's why Section 47 is couched in the terms of any judge. Because it may be difficult to make that distinction and work out which cases are, related to specific decisions that a judge makes whilst in active service, but now is retired.
Yes. So in that paragraph 3 of Justice Mlambo's judgment in Mutata is the court will have regard to. What it says is that really the need to protect judges from unwarranted litigation is not difficult to fathom. The core function of judges is the adjudication of disputes involving competing interests daily. The judgments they hand down, as well as the statements they make in court, and their judgments invariably displeases some litigants and sometimes their legal representatives.
Yeah,
It
but
is-
that's in relation to the administration duties.
Well,
I'm talking about just which I thought you do accept. That's why I'm asking this question of
Yes.
you. The independence of judges and their impartiality, as to why does the purpose not, as I understand your argument, and persist even after retirement in order to protect even those that are still in active service.
Yes.
And it seems to me that the language chosen by the Parliament to make the section wide seems to resonate more with a deliberate intention to protect all judges so as not to have to, leave gaps for threats onto the independence of the judiciary.
Yes. I understand the question put. Our submission is that the protection of judges against vexatious litigation is not provided for in vacuum. It is provided for as a mechanism to achieve, to ensure that judges are able to discharge their judicial functions. That is the purpose. So if the vexatious litigation arises from your performance of your judicial function, there is a clear likelihood that it would impact your ability to perform your functions. You'll be afraid to be frank in judgments and hand down justice as a judge sees it. But it must always link back. It can't be just in a vacuum that judges, if you want to see a judge for anything, for any reason related to any function unrelated to their judicial duties, it must be sifted through, and the head of court must tell you whether you can or not. The office is protected. It is the office and the function that is protected, not necessarily just the title, if I can put it like that. And I'm not saying it with disrespect. I'm trying as best as I can to respond to the question.
No, I understand. I accept that. I accept that. But I'm glad that you raised the idea of the office of a judge, because a related principle is that that office is not really separable from the persona of a judge. That's how in this country we've chosen to approach the office of a judge, because in order for that same independence to exist or to be enhanced or not to be threatened, general members of the public have to have confidence in the judiciary, and therefore that is why judges carry with them into all spheres of their lives, including the chairmanship of commissions, their ethical principles, and the impartiality duties that they hold. So flowing from that interpretation, now we're getting to the office of a judge. Now we're getting to the non-judiciary duties of a judge, that they may not be as separable as you make them out to be.
But there are certain functions when a judge agrees to their appointment, like if you're sitting as a private arbitrator, you're not there sitting qua judge. You are chosen for the training and skill and the fact that you can be impartial, you can be dispassionate, and you have forensic skills to sift through facts. So you're chosen for your qualities as a judge, given the experience. But when you sit in there, you're not a judge.
You're not performing judicial duties.
Not only that, but even when you determine the case, the extent of your powers and what you can determine are determined, limited by what the parties agree. Their judgments where judges were reviewed and set aside in arbitration awards because they carried into that sphere the inherent power that the office gave them. So there is a vacation of office when you choose to be appointed in certain positions where you're performing non-judicial functions. The office doesn't go with you into those functions. Your training and your qualities go with you, but not the office.
So you would disagree with that approach, that the office of a judge is not really separable from the persona of a judge?
My learned friend read from a constitutional provisions that says when you retire, you vacate the office of a judge. You retain the title and all that goes with it, including remuneration, training and qualities, which private parties very much like to use, and the state likes to use, to deal with matters which require an assessment of facts and evidence.
No, I'm not talking about retirement now. I'm talking about active service and doing other duties like chairing, such as chairing a commission, as we're talking about now, yes, in active service. Because what we decide here will be of general application. So, judges in active service, and actually there usually isn't a distinction, but let's say I accept your distinction between retired judges and judges in active service. My question is whether you disagree with that principle that judges really carry the office of the judge with them in their persona wherever they are.
So, just to dealing with active versus retired judges, we make a more humble submission that if you're an active judge and you're appointed to chair a commission of inquiry, one of the purposes of Section 47(1) may be implicated because you are still on the roster to sit in courts. So, and that is the position of Justice Zondo. It is wholly distinguishable from our present case. Our present case is not dealing with an active judge or a retired judge called back to perform judicial functions. Our case deals with a retired judge asked only to chair a commission of inquiry and cited in that capacity nomine officio, meaning not in her personal capacity. Now, that judge, when she gets appointed to be a chair of a commission of inquiry, she is not occupying an office of a judge in that position. She has vacated that office, but she's bringing with her title and the presumption that she is likely to act impartially and she can sift through facts and evidence. All of those things are factors which the court will take into account in assessing the question of bias. But it's wrong to say that when a retired judge, when Justice Khampepe sits as a chair of that commission, she sits in an office of judge. No. And she says so in her own ruling. She doesn't understand herself to be sitting there performing judicial functions. Because if she did, she would completely contradict the argument of our learned friends that, the argument of our learned friends, yes, for the commission, that the ruling does not constitute administrative, that findings of a commission do not constitute administrative action because they don't determine rights. It would sit in contradiction with she doesn't perform judicial functions. So they can only ride one of those two horses. And we submit that Justice Khampepe is correct because when SAFU says you are appointed to provide advice to the executive, you're not doing that in the office of a judge. You're doing that appointed as because you're a judge, true, but that's because of your training and qualities.
Okay, so that is section 77 of the Constitution?
176.
176(2).
Yes.
Okay, can I just ask something else then in the meantime? About the definition of service and the importation of that definition into Section 47 of the Superior Courts Act. And I must say I accept your submission that importation from different statutes in the interpretation needs to be treated with caution. But as I understand the principle, it is not that it is never done. And a related principle is that actually statutes must be interpreted such that there's harmony in the interpretation of statutes that relate to the same content and context. So here, what would you say is the distinctive context that renders the two, that definition, the importation of that definition undesirable, to use, for lack of a better word?
Yes, Justice Tambuza. We would say there are two problems. The first one is a fundamental problem. If you take independent IIE, the one I referred to and read from the paragraph 18 of the judgment, there you had the definition of university in two provisions, and you wanted to decide what the meaning of that word is. One is not defined, the other one is defined. Can you borrow from the other, or does it mean in the provision where it's not defined, it carries its ordinary meaning in context? The first problem is when you read 47.1, there's no reference to service. So what are you importing that definition to interpret in 47.1? Because if you had an undefined concept of service in section 47.1, then I would understand the need to go and borrow a definition from a sister legislation, so to speak, and use that definition here. But you don't have the concept of service in section 47.1, which needs interpretation.
Well, I mean, but section 176 of the Constitution uses the same word, service.
But you're interpreting section 47, Justice Sambula.
Yeah, what I'm saying is, section 47 relates to civil proceedings against judges.
Yes.
And it says no more than that. It does not talk about, it does not say anything about service, right? So, and then the Remuneration of Judges Act talks about, regulates service of judges. Surely, except if you can explain to me what inconsistency, why it is, what conflict is there between the one section 47 and that statute and specifically the definition section thereof, or that particular definition.
So that relates to the second problem I was going to raise, is that the two statutes are not in pari materia. They're not dealing with the same subject matter. What the remuneration of judges deals with, it deals with judges, yes. But it deals with judges' conditions of service, remuneration and benefits. And it says a judge is entitled to be paid if he was performing this function. It statutorily says. Otherwise, if you were performing a commission service, you might, or service through an appointment by a minister, you would need some agreement with the minister about how you were going to be paid. But if I can just complete the thought. What the section makes clear is that judges are entitled to benefits and payments, at least in relation to this service, to the extent that service is defined. It's regulating the entitlements of judges. The Superior Courts Act, in the section that we're dealing with, is concerned with the administration of the courts and the judicial independence and how judges are protected against vexatious litigation relating to their judicial functions. It's got nothing to do with what they're going to be paid. So they're dealing with, so sometimes you can have,
they're
you can
dealing
borrow
with two
from,
different aspects relating to the same persons, the same people of, office bearers. One deals with, one aspect and the other one deals with a different aspect. But Section 176(2) of the Constitution also refers to the to service, and I don't see any inconsistencies there, such that all of these cannot be interpreted harmoniously.
Justice, so Section 1, the section in the Constitution would only have an interpretive value to Section 47. It will guide you on how you interpret Section 47. You can't now say the proceedings against judges are regulated under the Constitution. That's the, what's the word, the principle of, what's the word, you must rely on PAJA and not the Constitution? Subsidiarity. So you look to the section, the bigger provision helps you in interpreting. But one can't say just because the Act deals with judges is in pari materia with any statute that deals with judges. Judges will be mentioned in many statutes, including the JSC Act. Yeah. You can't say then you can take any definition in the JSC Act and superimpose it on the Superior Courts Act because they all deal with judges.
I understand
the subject matter must be what they are regulating.
I understand that. That's why as I asked you to sort of indicate or help me in pointing me to the reasons why they can't be read harmoniously. Yes. But I hear what you say.
It's not reading harmoniously here. We're not concerned with reading harmoniously. We're concerned with the importation of a definition into a statute that deals with a completely different subject matter. Because this importation is not...
Well, reading statutes harmoniously is a principle of our law of interpretation.
Yes.
And if we don't do that, we might end up, causing chaos in how statutes and sections of statutes relate to each other.
Yes.
We are required to do that.
Yes. Justice Zambuza, I embrace and agree fully with the principle that even before you reach the conclusion that statutes are inconsistent, you must try to read them harmoniously. But what you're concerned with here is not a harmonious reading of the Judges Remuneration Act, a simple harmonious reading of that act and the provisions of the Superior Courts Act. What you're involved with here is the importation, holus bolus, of a definition in a separate statute into the statute which doesn't even mention service, without even dealing with why that is permissible in light of this court's judgment in independent schools, that IIE judgment. You will see the majority doesn't even engage with that judgment at all. It assumes that it is permissible to import that definition into Section 47, and they don't engage with what is the concept in 47 which they are defining, which has been mentioned but undefined, which justifies that importation. Justice Dambuza, that's the submission I can make.
I hear you. Thank you. Thanks,
Mr. Manager, can I follow up on a question that was posed to you by Justice Rogers on whether we would still have to reach the other review grounds if the point about the improperly constituted commission is good? On my understanding, if that point is good, to me it would suggest that essentially that body has not made a decision. Would you go along with that, or would that be a mistaken premise?
Justice Nuku, you are 100% correct, and the usual outcome in that case would be to refer the matter back to that body to make a decision because it has failed to make a decision. The argument we make is that remittal in that context would not be in the interest of justice for all the reasons that we've submitted, which we submitted under direct direct access.
You've anticipated me, that is where I was going. But now, would that not constitute something more than substitution? Because essentially, where that body has not made a decision, it should make a decision. Because then what is there to review when there is no decision?
Yes. So TRENCON does grapple with the notion whether when you exercise the power of substitution, you are trenching on separation of powers. Because in this case, what you're positing is that the power is allocated to that body to make the decision. That body hasn't made a decision. Why can we substitute? It says, no, when you exercise the power of substitution, you are really just achieving what...
No, before we get to substitution, sorry to interrupt you. What would we be reviewing? Because we would have said that body has not made a decision. And I think that would be factually correct. If it's made by one of the members without the others, does it not follow that then that body properly constituted should then make the decision?
So what I accept is a proposition that is the usual outcome, where a body hasn't made a decision. But when you review and set aside, you will be reviewing this decision, because this decision must stop to exist because it wasn't made by a body that was properly constituted. The question that arises then, what follows? What is the remedy for having done that? What Justice Nuki is quoting to me is, generally you would refer it back to that body to make a decision afresh. That is correct. That is the default position. But we are asking that there is a case to depart from the default position here for the reasons we've mentioned: delay, fairness, the public interest, the interest of justice. It's a foregone conclusion. All of those you are entitled to substitute under the TRENCON principle, and you're not trenching on separation of powers when you do that. It is perfectly consistent with the Constitution to substitute where there is a case for substitution. And Justice Mudiba's judgment provides you with material on which you will be applying your mind to that, because it's not as if nobody spoke about this in the High Court. Mudiba J grappled with the same issues that we're asking you to grapple with.
Thank you, Mr. Manager.
Thank you, Justice Nuko.
Thank you very much, Advocate Manager.
Thank you, CJ, and the justices.
We've not had time to break properly, so we're going to adjourn for 30 minutes and then come back and hear the respondents.
As the court pleases.
Thank you.
Independence that our Constitution guarantees, and to enable judges to adjudicate fearlessly. For Section 47 to function as this safety valve, as it was intended to, it must be interpreted broadly, we say, not narrowly. Thirdly, justices, we say we must interpret the provision contextually and sensibly, and in a way that, if possible, does not produce irrational or anomalous outcomes. If the Section 47 protections evaporate the moment a judge retires, or if they do not apply where a judge is performing a statutory function, like chairing a judicial commission of inquiry, or simply because the letters NO are cited after a judge's name, we say that this creates immediate anomalies. Let me consider the first illustration, which, as I understand the position, is the position of former President Mbeki. A sitting judge in active service is appointed by the President to chair a highly sensitive multi-year commission of inquiry. As I understand the argument, and certainly the pleaded argument, while that judge is in active service, he is covered by Section 47(1). But imagine that 2 years into the hearings, that judge reaches retirement age and retires, is discharged from active service, but continues to finalize the Commission's work. Does the protective shield of Section 47 evaporate overnight? We say that any interpretation that would allow that to happen should not be preferred. The second is the very example put to my learned friend acting on behalf of former President Zuma, where the question was whether a judge in active service is asked to chair a commission and then goes back into active service. Does Section 45 switch, Section 47(1) switch on and off, depending on whether the judge is at the time that the summons is issued or the notice of motion is served on him or her in the commission or in the High Court? We say that that also creates anomalies, and it doesn't produce sensible outcomes. Thirdly, in response to my learned friend Mr. Manechi's argument for former President Mbeki, if it is so that there has to be a link between the proceedings out of which the notice of motion or the summons arises and the work that the judge is doing, we say that that would too defeat the object of the section, because it would simply allow vexatious claims to be instituted without that link, against a judge without that link. And these potential consequences would hang over the head of a sitting judge, almost like a sword of Damocles. The minute you stop being a judge, you can be sued and the protections will evaporate. And that will undoubtedly, we say, undermine the purpose of Section 47, which is to ensure that judges can adjudicate and fulfill their judicial functions without fear or favor. And I wish to respond briefly directly to the applicant's arguments to this court, where they rely on two primary but respectfully flawed arguments. These are, firstly, the argument that Section 47 does not apply to retired judges, and secondly, that it doesn't apply because Justice Khampepe was cited nomine officio. We say that the distinction between the personal citation of a judge and the nomine officio citation of a judge is a fiction. And that fiction is clearly exposed in this case. When one looks at former President Zuma's founding affidavit in the recusal application, he does not simply attack Justice Khampepe as an administrative decision maker. He launches direct and highly personalized attacks against her conduct, including as a sitting judge of this court. He attacks the judgments that she wrote that led to his committal. He accuses her of a travesty of justice, and he sensationally accuses her of criminal misconduct. Moreover, he seeks personal costs from her, not in any official capacity, but personally, de bonis proprius. And he makes claims of actual bias. This, we say, is precisely the kind of retaliatory litigation that Section 47 was designed to screen. Former President Mbeki, while somewhat more restrained, also bases his case to a large extent on Justice Khampepe's roles in the prosecuting authority and the TRC, and her conduct in the proceedings of the Commission itself. One cannot launch an attack on a judge's judicial record and conduct in proceedings and then hide behind the procedural technicality that she has cited nomine officio. Turning to the retired judge's argument, we point out that the text of Section 47(1) refers to any judge. It does not carve out an exception for retired judges, nor does it distinguish between functions performed as a judge sitting as a judge versus a judge sitting as a commissioner and the chair of a judicial inquiry. The only sensible purpose of interpretation of Section 47 is that a judge is a judge. A judge is appointed for life, and a retired judge remains a judge. When they chair a commission of inquiry appointed by the President, they remain bound by their judicial oath. They remain bound to uphold the honor and the dignity and the ethical constraints of their office, and so too must the protections of that office follow them against unfounded retaliatory attacks. And we commend to this court here the reasoning in Mantashi from paragraphs 18, where the court explained, and we endorse this, that the chairing of a commission of inquiry does fall squarely within what are ordinarily considered judicial functions. We say too that it was perfectly legitimate and indeed correct for the High Court majority, both in these proceedings and in proceedings before it dealing with this section, to take interpretative guidance from the use of the words judicial service in the Judges' Remuneration and Conditions of Employment Act. This is clear from the authority referred to by my learned friend itself, the Institute of Education case. It is no cardinal sin for the High Court to do so, as was suggested. Paragraph 37 of that judgment makes it clear that it is possible and indeed appropriate to refer to other legislation as an interpretative aid. And that is how it was used in this case. So we say respectfully that that ought to be the end of the proceedings. The text is clear, the purpose is clear, and the constitutional requirements of the section are best given effect to in a manner that indicates that consent was required, but it was not obtained. And for all of these reasons, the TRC Commission supports the High Court's majority decision. My next topic concerns why we say this court should decline to hear this review now. The applicants are asking this court to intervene in media res, in the middle of the unconcluded proceedings of the TRC Commission, and to review what is clearly an interlocutory refusal by the chairperson to recuse herself. Our law firmly discourages piecemeal litigation of this nature, and it strongly points against the interests of justice in this court hearing the application. A stay or interruption of incomplete proceedings to permit a review is not available as of right. The established common law rule, referred to as the Valhouse rule, dictates that a court will be exceptionally slow to interfere in the unconcluded proceedings of an inferior forum or tribunal unless a grave injustice or miscarriage of justice would result. And this court's judgments in Sakau and the Supreme Court of Appeals decision in Take and Save Trading make it clear that the principles apply with equal force to civil proceedings and indeed to challenges to recusal decisions. Now, the former presidents in their founding affidavits in the High Court did not plead or even attempt to meet this test, and did not plead any grave injustice or miscarriage of justice that would result. They now, before this court, attempt to bolster their case and argue that they do face a grave injustice. In essence, they say that they will be forced to submit to an allegedly unlawful process, and that this is a peril so great that this court must intervene now to stop it. Justices, the perils that the applicants point to are not exceptional at all. The same exact peril is present in every single case where a litigant contends that the proceedings against them are unlawful, or that the presiding officer is biased against them, or that the tribunal lacks jurisdiction. If the mere threat of having to participate in unlawful proceedings was enough to justify midstream intervention, then the Valhouse rule would cease to exist. Every disgruntled witness or accused person would immediately run to the court, the High Court, and then possibly this court, bringing the underlying inquiry to a halt. But there's a further point. There can be no grave injustice because there is no finality. Unlike a court of law, the Commission of Inquiry will determine no liability and establish no criminal culpability. It will make findings and recommendations, but these are not binding. The President may act on them, or he may not act on them. Because the outcomes carry no direct legal consequences, they cannot cause the applicants any irreversible prejudice. And this too, we say, renders the challenge to the recusal decision premature. Finally, under this heading, I note that the applicants are not left without a remedy, and this distinguishes this case from the Ramakatse case relied on by my learned friend for former President Zuma. The horse will not bolt if this court does not hand down judgment now, as it would have in that case. If the objections are dismissed, the proceedings will continue. The applicants will participate in the proceedings, and then in due course they may institute review proceedings at the conclusion of the Commission's work. They retain their full rights to do so and accept as much. We urge the Court here to heed the oft-quoted warning of Lord Denning in Moran versus Lloyds, where he said, "We often find that a man who fears the worst turns around and accuses those who hold a preliminary inquiry of misconduct or unfairness or bias. He seeks to stop the impending charges against him. It is easy enough for him to make such an accusation. Once made, it has to be answered. And who knows, if he can stop the preliminary inquiry in its tracks, it may never start up again. To my mind, the law should not permit any such tactics." This litigation is, respectfully, precisely the dilatory stratagem Lord Denning warned against, and for these reasons we submit that the review is premature, constitutes an impermissible midstream disruption of what is a vital truth-seeking process, and on this basis alone, the application should be dismissed. Justice, I'm going to turn to the substantive merits now. We say that even if the Court were to look past the insurmountable jurisdictional bar of Section 47, and even if it were to permit a premature midstream review, the applications must nonetheless fail on their merits, because the applicants have failed in their recusal applications to dismiss the formidable presumption of judicial impartiality and have failed to meet the double reasonableness standard. And there's one aspect which I would like to deal with right at the outset of this, and this is a suggestion that it is common cause that Justice Khampepe was involved in all of the institutions that were read out to you, and that there was no substantive answer in relation to the functions that she fulfilled within those institutions. And I would like to point you, Justices, I won't take you there, and this is directly in response to an engagement that Justice Matopo had with my learned friend. If one looks at the answering affidavit in the High Court, from paragraph 78, it appears at case lines 001-1062. Mr. Semenya spends considerable time, more than 20 paragraphs, setting out exactly what the roles were that Justice Khampepe played during the period in question, and what that means for her ability and her objectiveness, the reasonable perception of her objectiveness in the TRC Commission. So that starts from paragraph 78. Then, at paragraph 243 of that same affidavit, case line 001-1100, there is a specific denial on oath that Justice Khampepe had any role in the HRIU, the Human Rights Investigation Unit, which was the unit that dealt with amnesty refusals and recommendations on prosecution. Justice Khampepe filed a confirmatory affidavit before the High Court, which appears at 011-518 of case lines, confirming those submissions to be correct. Then, in the recusal decision itself, Justice Khampepe again dealt with this issue. The allegation that she was called upon to meet there was that she had institutional responsibility, because she was in the NPA, there was institutional responsibility for the creation of prosecution policy. That was the case that she was called upon to meet. And you will see at paragraph 50 of the recusal judgment, 001-964, Justice Khampepe states that she has no knowledge of any prosecution policy that she is alleged to have had input into. She says, too, that the allegations are mere speculation and conjecture. So when one assesses whether a case has been made out to review the recusal decision, we say that these facts are important to bear in mind. We say two further things. First, that the case for recusal that the applicants mount is limited by the case on recusal that they instituted before Justice Khampepe herself. And Justices, you will have seen that the applicants have attempted to bolster their case for recusal by introducing new facts, such as the references to the PEPCO 3 and the Masuku family. These were not facts which served before Justice Khampepe when she considered the recusal application. The second point is that, of course, this is a case which is limited to a review. It is not an appeal against the decision, and we say respectfully that there is a difference. My learned friend said, well, a review on recusal is basically the same as an appeal, and we say no, and that the applicants must be kept strictly within the four corners of a review. I'm going to address now the issue that has been raised by the court about whether the chairperson was correct to take the decision alone, and my learned friend for the Malato group will develop this further. But it's important for the TRC Commission to place this on record. We say that it was entirely correct, both for the application for recusal to be heard by the chairperson together with the other commissioners, and secondly, for the actual recusal decision to be taken by the chairperson alone. And we say that with reference to the SAFU decision specifically. As was pointed out to my learned friend by Justice Majid, the SAFU recusal judgment makes it plain that that was an application against the court, against each judge. And it was the whole court that was implicated. And it was for that reason that the judgment was issued by the court. But what paragraph 31 of SAFU makes clear is the statement that judges have the jurisdiction to determine the applications for their own recusal. In other words, a judge must determine whether there is merit against themselves, a factor which would normally give rise to procedural fairness problems. But what we also know is that where a judge whose impartiality is challenged sits with other judges or other commissioners or other decision makers, those other decision makers also need to satisfy themselves that there was not a ground for recusal. It's not that they need to make the recusal decision. It's that they need to be satisfied that they do not need to remove themselves from the process. And that too comes from the SAFU decision. So we say that when the SAFU decision is properly applied, there is simply no ground of review at all that the chairperson took the decision alone. She was respectfully required to do so. I'm then going to deal with the institutional bias arguments. Both of the former presidents objected to Justice Khampepe chairing the TRC Commission on the basis that she served on the TRC Amnesty Committee from 1996 to 2001, and then she was Deputy Director of Public Prosecutions from September 1998 to December 1999. The applicants say that these roles, occupied nearly 30 years ago, establish sufficient institutional bias. Justices, we say that the recusal application had no merit. This court's judgment in Masuku makes it clear that the law does not suppose the possibility of bias. If it did, imagine the bedlam that would ensue. And the court continued at paragraph 68. What an applicant raising an apprehension of bias must prove is that there is some connection between the views, the opinions, or the experiences of a judicial officer and the subject matter they are to be seized with. So proving that there was a mere that she was merely within the NPA or that she merely served on the TRC Amnesty Committee is not enough. Now, applying these established principles, the chairperson properly exercised the discretion that she had. And she found the following. First, she found that the applicants had ignored the temporal boundary because the Commission's terms of reference explicitly restrict its mandate to investigating whether there were any attempts or efforts made to stop investigations or prosecutions from the year 2003 onwards, 2 years after she had left the TRC committee, and 4 years after her tenure in the NPA had ended. She says she had no role beyond that, and what she did in her prior institutional roles will not be the subject of the work of the Commission. It will not establish whether there was executive interference after 2003. And secondly, on the subject matter boundary, former President Mbeki says the subject matter of the Commission arises from, that is the test he would prefer, from Justice Khampepe's association. But that is not so, because neither the TRC Commission nor the NPA investigated executive and political interference in the work of the NPA. And I have given you the references in the answering affidavit where that is clearly explained and set out. The question whether apartheid era crimes should be prosecuted or whether amnesty is correctly granted or not, now those, I submit, would give rise to the kinds of concerns. But whether there was executive interference many years down the track, we say would not. The next issue around the bias question and whether it was established relates to delay. One of the further factors that caused the chairperson to dismiss the recusal applications was the unreasonable delay in bringing them. And the facts of this delay are common cause. Justice Khampepe's appointment became public knowledge in May 2025. So did the terms of reference, the reference to executive interference. The applicants took no steps from this date. Both applicants received their Rule 3.3 notices in September or early October, but they bided their time. President Zuma, on the 14th of November, sought an extension in order that he could cooperate further with the Commission. And then Presidents Mbeki and Zuma launched their recusal applications in mid-December last year, 87 and 90 days, respectively, after their 3.3 notices were received. Now, I emphasize here that this was a commission that was only established for 12 months. So a delay of 3 months before a recusal application is launched amounts to a quarter of the time period that the commission was given to investigate, hear witnesses, and come to its conclusion. This delay is unreasonable and violates the legal test that was set by this court in Burnett, which dictates that a litigant must raise an apprehension of bias at the earliest possible opportunity to avoid prejudice, and that a litigant cannot wait it out and only cry bias when they perceive an unfriendly decision has taken place. And we see here that the recusal letter was sent on the 3rd of December when the decision on the Semenya recusal application had been issued the day before. It is clear the applicants were biding their time to see whether they would receive a favorable outcome, and when they did not, it was at that stage that the applications to recuse were launched. I will not deal, Justices, unless there are questions, with the allegations of actual bias that are launched by former President Zuma. I will simply note that former President Zuma, although claiming to be in possession of secret communications and evidence, failed to put any of these up either before Justice Khampepe in the recusal application or before the High Court or before this court, and that even the minority judgment there was forced to concede that there was not an iota of evidence. Thank you, Justices.
Thank you, Advocate Purifin-Jones.
Sorry, I just have one question for you. We were debating earlier on whether a decision by the head of court not to consent to the litigation may leave an applicant without a remedy. I wondered if you had a view on that, given that if one had a look at Paja, could it be argued that the decision to refuse would have external effect, and it also doesn't fall into any of the Paja exclusions? Paja excludes the functions of a judicial officer, but when the head of court decides not to grant consent, the head of court is not acting as a judicial officer. And then there would indeed be a remedy, a Paja review. I mean, the consequence is that there would have to be reasons for refusing. And so the party in that position, so that would be an effective mechanism to sift out, a court could sift out whether the head of court properly applied his or her mind to the facts, gave proper reasoned decision. And so a person in that position is not left without a remedy, as it were. Do you have any thoughts
Indeed,
on
Justice Colopin, I would simply suggest that that could indeed be an appropriate. I haven't looked at the definition of Paja, the exclusion of judicial functions, but to the extent that it can be argued that a head of court in those circumstances is not performing a judicial function that's excluded by Paja, then certainly that would be appropriate. But I want to make two further submissions, which is that the position is not nearly as dire as it seems, because what the authorities in Engelbrecht and Soller make clear is that the way the process works is that a letter is first sent to the head of the court. If the head of court is satisfied, then he'll grant the consent and nothing further will happen. If the head of court is not satisfied, what usually happens is that a formal application can be brought for consideration on affidavit and reasons given, as you've suggested, which enables a decision to be assessed as to whether it was a reasonable one or not. And further, this is of course entirely a hypothetical decision, a hypothetical scenario, because in this case there was no application under 47.1 and there was no refusal. So we don't know what the outcome would have been, certainly not in this case.
What do you say about the argument that a recusal application brushes up, as it were, against the right of access to court in the right in Section 34, and that it's distinguishable from other civil proceedings that may seek damages or specific performance or located in contract or in delict. And therefore, the court is enjoined in terms of Section 39(2) to interpret legislation in a manner that is consistent with the values of the Constitution. And to that extent, one cannot simply conflate all civil proceedings under a single heading, but that there's an argument that an interpretation in civil proceedings that brush up, as it were, in the context of fairness. I mean, all proceedings could trigger Section 34, but it would be simplistic to suggest that the constitutional implications are felt equally. It may well be arguable that those that may implicate a fair trial, a fair hearing, may warrant separate treatment. And on that basis, there would be an obligation on the court at least to consider an interpretation of Section 47(1) that lends itself to aligning with those constitutional values, and that there's some merit in the argument that the applicants make, that 47 should be viewed within its proper context. And in that regard, this case would fall outside, as it were, of your general kind of litigation. You would probably say there's no merit to that, but I'd like to know what your reasons for that might be.
Certainly, Justice Colopin. And again, I've got three answers, if you'll bear with me. The first is that this question and the constitutionality of Section 47.1 and whether it was implicated, whether Section 34 implicated its interpretation and its constitutionality was considered in the solid decision. And it was found...
My question is not located on a constitutional misalignment. My question is located in an understanding of 39.2, which presupposes that the section, there's no constitutional attack on the section.
Yes.
But that notwithstanding, there still remains a duty on the court to interpret 39.2 in a manner that is constitutionally compliant.
Yes, yes, Justice Colopin. And in Sola, the conclusion was that it did actually, the very fact that Section 49.2 is in place gives effect to the right of access to court, because the right of access to court is not unfettered. And when a head of court or the Chief Justice considers whether or not Section 47.1 bars or allows whether an application should be barred or allowed under Section 47, the test is good cause. And it is at that stage, I suggest, Justice Colopin, that the right of access to court under Section 34 comes into play. So it is not a question of interpretation such that one must include or exclude certain categories of civil cases. For the reasons that I suggested, I think that would give rise to anomalies, whereas the section is broadly framed. But when a head of court is deciding whether or not to grant the Section 47.1 application, that head of court must take into account the right of access to court and the nature of the case that's being brought. Is it a recusal case or is it a civil case?
And then, following from that, you would say, well, if one would have to look at each case on its merits, we don't get there, because we don't have a 47.1 application.
Indeed, Justice Colopin.
Ms. Puddleton-Jones, the respondents seem to argue that Section 47 serves to safeguard judicial independence and public confidence in the judiciary. But this cuts both ways, doesn't it? While it's important to protect judicial officers from vexatious litigation and undue harassment, it's also important to ensure accountability and that no one is above the law. Would it not undermine public trust in judges and in commissions of inquiry if we were to extend judicial immunity beyond permissible borders or bounds?
Justice Turon, we'd say two things in response. The first is that Section 47.1 and the requirement to obtain consent is not an absolute bar. The test is good cause. And the person that is making the determination about whether good cause exists or not is not a lay person or a low person. It is a head of one of the high courts or one of the appeal or highest courts in South Africa. So there is no absolute bar. So to the extent that there is a limitation, it is a limited limitation, we say. And secondly, we say that we're not asking...
Before you go on to the second part of your answer, where does the good cause test come in Section 47?
Justice Turon, it comes from the authorities, and particularly the Engelbrecht and Sola judgments, which set out the mechanism in which the section operates and the requirement for good cause to be shown. And then we say that it's not an extension of the interpretation that we are asking for. We are asking for an interpretation which is in line with the language of the section and is in line with the overwhelming majority, we say, of prior judgments which have found that it does apply in circumstances such as this.
Does this court, or must this court decide what a judge means in section 47(1? Or must this court, can this court just decide on whether a chairperson of a commission falls within the ambit of section 47(1?
Justice Serrano, it's something I gave consideration to. We for the Commission have run, if I can call it, a stronger case, which is to say a judge is a judge. A former judge who is chairing a commission remains a judge is a judge. The Halata group has run a slightly more nuanced argument, which says that this court doesn't need to get there. And with your permission, Justice Serrano, I will leave that argument to my learned friend, Mr. Budlander, to address as to why he thinks that the nuanced argument is appropriate. But we have certainly run an argument to say that the meaning of the word is clear. A judge is a judge. Everybody knows what a judge means.
Yes, a judge is a judge, but you get a judge who's in active service, and you get a judge who has been discharged from active service. Surely there must be a distinction. What is that distinction? What does it mean to be in active service, and what does it mean to have been discharged from active service?
And then
I think it's a very simplistic way to look at it, to say a judge is a judge is a judge.
I accept that criticism, Justice Turon. In those circumstances, we would say that there are a number of ways that the courts have looked at this and where guidance can be got. And the first relates to, of course, what does service mean? And if we're talking about active service, but then we look at the Remuneration Act for judges and we find that a commission of inquiry, acting as a chairperson of a commission of inquiry, is a form of service. That would mean that even a retired judge is in active service.
Section 47 talk about service.
It doesn't, Justice Turon, but I was answering your question about whether there's a distinction in 47 about a judge in active service or not in active service. Section 47 doesn't deal with service or function. It simply talks about a judge.
Now, Section 7 of the Commissions Act, in terms of that section, a president can appoint a commission for the purpose of investigating a matter of public concern. There is no requirement that that commission must be headed by a judge. If someone is appointed other than a judge to head the commission, Section 47 would not apply to them. So why would a judge then be protected by Section 47 when a judge is appointed to a commission, and let's say an advocate is appointed to commission, they're performing the same function? It seems like an anomaly that one is protected by Section 47 and the other one is not, doing exactly the same function.
The answer here, we say, comes because of the incredibly special and protected role that judges fulfill in our constitutional democracy. They are afforded extra protections beyond.
That is when they are serving as a judge. Here, and I'm sorry to cut you short, I'm very mindful of time as well. Here, they're performing a function that a person who is not a judge could perform. And let's confine ourselves perhaps to a retired, especially a retired judge, which brings out that distinction more. So you get two people performing the same function. Because the one was in active service, they are now entitled to the protection of Section 47(1). But their counterpart, who is performing exactly the same function, is not.
It is because they carry with them their oath of office. They carry with them the honor and the integrity. They are called Justice Khampepe when they are referred to in the commission. And with that honor and with that responsibility, we say under the Constitution, that
doesn't sound right, Ms. Clifton-Jones, because how council choose to refer to the chairperson, that special privileges must attach to them. So because they refer to the chairperson as justice, as opposed to chairperson and Mr. Chairperson or Mrs. Chairperson, as a sign of respect, that certain privileges given by law should attach then to that position.
I apologize if my example seemed overstated, Justice Theron. I was merely illustrating that because that person was appointed a judge, one of the highest honors, they carry their responsibilities and they carry their protections. That is what the wording says. We say that we may not like it. It may come with constitutional problems, as was illustrated earlier, but the section has not been challenged. The section must be faithfully interpreted.
So, if an advocate can perform, or any other person can perform the function as a member of the commission or a chairperson of the commission, then we can't say they're performing a judicial function. Would you agree with that?
Justice Khampepe, I'm just mindful of the Mantashe decision and the reasoning which led to the conclusion that it was a judicial function. It is certainly a function that can be performed by judges, but it is not a function that can only be performed by judges.
So where a non-judge, where advocate performs that function, it would not be a judicial function, would it?
They would not be performing.
So how does a non-judicial function become a judicial function simply because it's performed by a person who was at one stage in active service as a judge? See, this is one of the difficulties I have in this matter.
Justice Khampepe, it is, Justice Theron, I apologize. it is late and it is undoubtedly a...
That's strike two. First one, go.
Yeah. It is undoubtedly a difficult matter, and it is difficult to know where to draw the lines. But we say that the legislature has chosen to draw particular lines, and that this court must interpret it in a way that makes sense and doesn't give rise to various anomalies. And yes, our interpretation would be that because of the status of the commissioner as a judge, they have more protections than an advocate.
So protections that are given in law, if I understand your argument, are conferred upon somebody simply because of their status or because of the way people refer to them in the commission as justice. That can't be right.
Justice Theron, we say that when you become a judge, you get certain privileges, one of which is that you cannot be frivolously sued without good cause. And that is a privilege that, like many of the other privileges of being a judge, extends right through a judge's life by virtue of the status and honor of the office of appointment. That is the case that we've made out, Justice Theron.
Another difficulty I have with the reference to the Superior Courts Act and the remuneration of judges is that a chair of a commission or a member of a commission is appointed in terms of the Commissions Act. They could be what we call creatures of statute. So surely they should derive their powers from the Commissions Act and from their appointment by the President. And that would apply to a judge or former judge who's appointed, and it would apply to a non-judge that's appointed. So this is another anomaly for me, that and let's use the example of an advocate because it springs to mind quicker. So a retired judge who's appointed gets powers from the Superior Courts Act, but an advocate appointed to the very same position does not get those powers.
Yes, Justice Theron, that is the position. And you say, should it all be regulated under the Commissions Act? Should there be equal powers for all? Perhaps so.
Isn't the only thing that's regulated by the Superior Courts Act is how the retired judge will be remunerated for the service that he or she is performing in the commission. Aren't we taking it too far to look for the powers of the judge and the powers they have in the commission by looking at service in the Superior Courts Act?
Just as we say no, because the Judges Remuneration and Service Act does not only deal with remuneration, it also deals with the services that judges perform. That is clear from the Act itself. Remuneration and conditions of employment
Which of the Act do you rely on for that submission? That it's the functions, they also deal with the functions that a judge performs.
Sorry, Justice Theron, I must be clear. It is the Judges Remuneration and Conditions of Employment Act, and it provides for, the short title, the remuneration and conditions of employment of judges of the Constitutional Court, the Supreme Court of Appeal, and the High Courts, and for matters connected therewith. And
So it's matters connected with their employment. It's conditions of service. It's the benefits which they receive. How can that be extended to deal with their powers when they're discharging their functions?
Justice Theron, we don't endorse any attempt to cut and paste one definition from the Act to the other, but what we do say is when one is called upon to interpret what a judge means in Section 47(1), what the High Court did and what the judgments before it have done was to say, well, what is a judge? What does a judge do? What services does a judge perform to society? And when they interpreted that question, they had regard to, they got interpretive assistance or guidance from the Services Act, but the Remuneration Act, but we certainly don't suggest that there is an absolute ability to cut and paste from one to the other.
When I look at Section 47(1), it says, notwithstanding anything to the contrary in law, no summons or subpoena against the Chief Justice or Judge of Appeal or any other judge. Seems to imply on a simple textual reading, proceedings being brought against a judge. What we might be dealing with here is proceedings being brought against a judge arising from proceedings being held before a judge. So, but for that proceedings that was before the judge, there would not be an action. There would not be proceedings. Is that a distinction of note?
Justice Theron, I'm not sure, because I think that one of the reasons that Section 47(1) is in existence is to protect judges from claims arising out of their judgments, to say, because of your judgment, I suffered X amount of damage, those kinds of frivolous and vexatious claims. So the mere fact that the proceedings against the judge arise out of proceedings...
Yes, I'm sorry to interrupt you again. That would not be against the judge NO. That would be against the judge personally for damages. If the claim is because of the behavior of a judge in proceedings, there's a claim for damages or compensation against them personally.
That could be so, Justice Theron. In this case, though, we say that, and I showed in my address, or attempted to do so, that this is clearly a case that traverses any NO boundary in the manner of the claims against Justice Khampepe and what has been pleaded against her regarding misconduct, etc.
My last question, you'll be pleased to know, Ms. Pufferton-Jones. This is something that my colleague Justice Matopo raised with Mr. Manechi, and what happens if this court has to find in favor of the applicants? Is that question before us? Is that question before this court as to what happens to the work the Commission has already done, the work the Commission will do in its remaining term? if this court was to find that the appointment was improper, or what is your submission on that?
Justice Turon, we say that certainly what this court must take into account is that the Commission has a vital truth-seeking function in our democracy. There are victims that have waited decades for answers which this Commission has promised to provide. That is a relevant factor when this court looks at the kind of remedy or relief that might be granted. That is certainly something that should be taken into account.
See, that's my difficulty. I'm not sure the question of remedy and relief beyond a finding that the applicants are asking us to make is before us, and that's what I'm asking you, Ms. Puduvan-Jones. Is that question before us?
To the extent that this court is asked to declare that certain conduct or is unconstitutional under Section 172(1)(a), or frankly even without that declaration, then certainly this court must consider under, or may consider under Section 172(1)(b), the broadest just and equitable relief in the circumstances.
Where is that dealt with in the papers by the parties?
It has not been explicitly.
Then how can the court make a decision on that?
Justice Turon, I accept that the implications of what would happen to the Commission is not on the papers.
Yes, thank you. Thank you, Ms. Puduvan-Jones. Thank you, Deputy Chief Justice.
Ms. Puduvan-Jones, as we stand here today, would it be accurate to say that Justice Khampepe is a just judge of the Constitutional Court?
I beg your pardon, Justice Rogers.
Would it be a correct and accurate statement to say, as we stand here today, Justice Khampepe is a judge of the Constitutional Court?
No, Justice Rogers.
Now, it seems to me there's an aspect of the text of Section 47(1) that hasn't received attention, as far as I can see, in the authorities and in the argument. And that is that the prohibition applies to the institution against any judge of a superior court. Now, if one looks through that phrase of a superior court or of a division, you will see that phrase used throughout the Superior Courts Act, and it is always used with reference to judges in active service. So, because it's partly relevant to Section 47(1), head of court is defined in Section 1 for courts of similar status to a high court, the most senior judge of such court. Now, that can't mean the most senior retired judge. It must mean the most senior active judge. That would be the head of that court. If we go to Section 4(1), this court consists of the Chief Justice, the Deputy Chief Justice, and 9 other judges of the Constitutional Court. That doesn't refer to Justice Khampepe or Justice Jafta. It refers to the in-service judges. If we go to Section 6(4)(c), which relates to divisions with more than one local seat, the judge president of that division may assign all the judges of that division as he deems fit, or she. Section 7(2), circuit courts must be presided over by a judge of that division. Section 9(4)(b), one of the functions of a head of a superior court is to issue directions to the judges of that court. Now, that must mean the active judges. He can't issue directions to the retired judges. And so I haven't gone, you or your co-counsel can do the search of a judge or judge of in the Act, and you'll see it's used throughout with reference to in-service judges. So when that same expression is found, it may not be instituted against any judge of a superior court. Why should it not have the same meaning? Meaning a judge who is currently serving in that court. As you said, Justice Khampepe is not, as we stand here today, and has not for some years been a judge of the Constitutional Court.
Justice Rogers, I can do no better than to to offer to you the findings of Mlambo JP, as he then was, in Motata, who explained that this was new wording that was added, a judge of a superior court, in order to include constitutional judges, judges of this court who had not previously been included. And it was a consolidation exercise, not an attempt to strip judges of their protections.
I confess I would have to go back to that case. Was the significance of this as undertaken with reference to this formula which appears throughout the Act as being with reference to those currently in service at a particular court?
No, Justice Rogers, it certainly wasn't done with that level of granularity that you've given to me now. But my answer to you is that the inclusion of the words of a superior court simply make it clear that it applies not to magistrates, and it does apply to all judges of all superior courts, including the Constitutional Court.
Yes, how the provision would have been interpreted in the context of the old Supreme Court Act, I don't venture an opinion, but we must now take it as we find it. Now, if there is a concern that Section 47(1) impacts on access to court and opposes, I take your submission that it's not an absolute bar, but it's a gateway which may or may not be opened to the litigant. If giving the section the width that the respondents are arguing for raises discomfort, then at least one entirely plausible reading is to say that it is the judge of a court, in other words, a judge currently serving in a court, where the prohibition applies. I accept that there might be certain illogicalities with that, because I know that an active judge could also be seconded to sit in a commission, and then that person would still be a judge of the court where he serves. But at least this interpretation, which seems to me to follow the scheme of the same phraseology throughout the Superior Courts Act, would say that it doesn't apply to retired judges, because none of them could be regarded as, we wouldn't say today that Fritz Brunt is a judge of the Supreme Court of Appeal. He was, and he's no doubt very grateful that the Remuneration Act allows him to be remunerated with reference to the salary of a Supreme Court of Appeal judge, but he isn't now a judge of a superior court. And we would at least then rule out all the retired judges from the protection. Oh, sorry, yes. And that might then tie in with such the purpose that then comes in subsection 2, which is making sure that the judge against whom a consent has been given isn't then called to appear in court in a way that will disrupt the work of the court.
It would give effect to that, Justice Rogers, but it would then undermine the protection that sitting judges have, knowing that they cannot be challenged down the line for the judgments that they've issued while they are active judges, because the retirement then operates as a guillotine.
Yes, but perhaps that is not the primary purpose of Section 47. I don't know if you've read the bit of academic literature which went into the history of Section 47 as it now appears. South Africa and one or two of our southern African neighbours who have borrowed it are the only countries in the world which have this gateway provision. So it hasn't been regarded as necessary throughout the world for this protection to exist in order to secure the independence of the judges. There are other civil law absolute or qualified privileges which protect judges from claims for damages in respect of the work they do. But for the rest, I would very much hope that a judge doesn't need this in order to do his or her job. So the primary purpose may be the more mundane one of making sure that in-service judges are not unnecessarily distracted by frivolous lawsuits which may interfere with their work.
Justice Rogers, I would simply respond to that by saying this is the tool that South Africa has chosen, and we don't have many others to protect judges.
I think we have the normal rules that would apply in the civil law in other countries, that you can't be sued for having given a negligent judgment, you can't be sued for defamation, for things you say in a judgment. Those sorts of protections exist as a matter of common law. I'm just not sure that if there are other statutory protections which you say in other countries serve the purpose which this serves in this country, I would be interested to know. But if, as I suspect, it stands virtually on its own worldwide, it might not be regarded, it might not be in the Act as some fundamental bulwark against diminishing the independence and fearlessness of the judges. Just raise the language of a superior court, because it seemed to me potentially of some significance.
Thank you, Justice Rogers.
Steve?
Ms. Palfin-Jones, when you dealt with the issue of the improperly constituted decision maker relating to the recusal, I heard you say that it is proper for the recusal application to be heard by all 3 members, but to be decided by only one of them who is implicated in the application. And you made reference to the Sarfu judgment. Are you able to provide me the passages that support that proposition?
Certainly, Justice Nuku. I also know that it's an issue that my learned friend is going to deal with
Or you want
in some
to
detail.
leave it to, you
I
can
certainly
leave it
provide
to
you the references, but it's an argument that my learned friend, Mr. Budlander, will
All right.
expand on. So thank you very much, Justice.
Thanks.
Thank you, Advocate Palfin-Jones.
Thank you,
That
Deputy.
seems to be it from a question point of view. Advocate Budlander. I see that a number of curveballs have been thrown your way by your partner in arms. Please go ahead.
Deputy
when
Chief
you're ready.
Justice, members of the court, our individual clients are 25 families who have been trying for more than 20 years to obtain justice for themselves and for their loved ones who died at the hands of the apartheid state and its agents. To do this, they have had to revive and they've had to relive the pain they suffered from those events. They've done so because they need justice, they need accountability, and they need closure. The Rodriguez case in the Supreme Court of Appeal illustrates this. That case dealt with the death of Mr. Ahmed Timel, and he fell to his death from a window on the 10th floor of John Foster Square in an office used by the security police. Justice Kachalia said, quote, "The Timel family have been the victims of this delay. They have waged what can only be described as a heroic struggle with dogged determination to bring the alleged perpetrators of these crimes to trial. The public interest demands that their efforts are not in vain." Close quote. In January 2025, the Kalata Group applied to the Pretoria High Court for an order directing the President to establish a commission into the suppression of the investigation and prosecution of TRC cases. And the President then established this commission and it has been hearing evidence from a number of people. It is now more than halfway through its task because it has less than 6 months to go. If the present applications succeed, they will collapse the Khampepe Commission and they will bring the whole process to a halt and possibly render the whole process a nullity. Mr. Mbeki and Mr. Zuma will not have to file statements explaining their conduct as directed by the Commission, and they will not have to appear before the Commission and account for their conduct. That is in my submissions, I'm going to focus principally on the review issues, the review grounds. I'm going to say something briefly about Section 47, but for the most part, I will be dealing with the review grounds. And in that context, I'd like to go out of sequence immediately to the question of the HRIU, which enjoyed so much attention in the discussion with the members of the bench. Our learned friend for the Commission has drawn attention to some of the facts in this regard. I'll try to repeat those parts only very briefly. But the question is, what are the facts before the court? What facts does this court have before it in relation to the HRIU? Mr. Mbeki says in his answering affidavit, if I can give you the reference, it's paragraph 241.8, and that must be his founding affidavit, I think, and it's case lines 001-217. He says, and I quote, "The precise nature of Justice Khampepe's involvement in the HRIU requires further factual investigation. The uncertainty is material." Trenchant observations. In fact, in the High Court, the Commission denied that Justice Khampepe was part of the HRU, and Justice Khampepe confirmed that denial in a confirmatory affidavit. You've been given the references by a learned friend. The fact is that there is no evidence before the court by anybody with knowledge of the facts. I'm not talking about somebody who speculates about it, but there's no evidence by anyone with knowledge of the facts that Justice Khampepe was part of the HRIU, or, to the extent, if she was, what the function was of that unit. The facts are lacking. There's been a debate on the assumption that she was a member, and B, the function of the HRIU was to look at stopped prosecutions and to consider why they were stopped. But there's no evidence whatsoever of that, and in fact the evidence is to the contrary, because she says she didn't do that. She wasn't there. And I'd like to show the court some further passages which underline this. In her decision on the application for recusal, Justice Khampepe said the following. I can just go there. It's at page 001-962, and she said the following. At paragraph 42, she said, "It is common cause that I sat as a member of the Amnesty Committee of the TRC over the period 1996 to 2001. It's also common cause that I was appointed as a Deputy National Director of Public Prosecutions over the period September 1998 to December 1999. She then says, on page 45, paragraph 45, "Former President Zuma ignores the fact that the issue of efforts or attempts having been made to stop the investigation or prosecution of TRC cases were not matters that were pertinent before the TRC's Amnesty Committee, or indeed at the National Prosecuting Authority during my tenure there." That's what she says. She says this issue was never before them. And then further, if one then turns to what Mr. Saldanha says, Judge Saldanha, he says the following, and you'll find his statement at case lines 001-992. At paragraph 3, he says the following. He says, "I served as the chairperson of the Human Rights Investigative Unit. The unit was charged with the consideration of dockets referred to the NDPP by the Amnesty Committee of the TRC for prosecution. The dockets related to persons who had not applied for amnesty and who were unsuccessful, and also those persons who had not applied for amnesty. The unit reported directly to the NDPP, not to Justice Khampepe, but to the NDPP. And then he goes on, in paragraph 8 on the next page, he says, I recall, though, that during the course of, he's saying that he hasn't got any documents. He then says, I recall, though, that during the course of 1999, an interim report was prepared by the committee, which was submitted to the National Director of Public Prosecutions with regard to the matters that we were at that stage considering. And what were they considering? They were considering the dockets. And so the suggestion that the HRIU was investigating the matters now being investigated by the Commission was simply not only not supported by any evidence, it's contradicted by the direct evidence. And so we submit that no evidence at all, no reliance at all can be placed on the allegation, unsupported by evidence, that Justice Khampepe was a member of the HRIU. It's denied under oath by those who know, or that in that capacity the HRIU was investigating interference with the NPA. That's also denied on the record. And so this whole construct of Justice Khampepe sitting in one place, deciding one thing, and then sitting in another place and deciding the same thing and giving rise and implementing the decisions she'd made previously is simply false. It's not supported by the evidence, and in fact it's contradicted by the evidence. That then brings me to why we say that this application should be dismissed. I'm not going to repeat what our learned friend for the Commission has said. We say that make the following submissions. First, that the applications were not urgent when the whole matter was started. And we say that if there was any urgency, it was a classic case of self-created urgency. Because the Commission was established on the 29th of May 2025, the President announced who would be the chairperson, and he announced what the Commission would investigate. Mr. Zuma and Mr. Mbeki don't say that they weren't aware of any of this. They don't say they didn't realize that this was going to affect them. In fact, they don't say that at all. They simply did nothing. They were content for the Commission to proceed with its work. Mr. Mbeki clearly knew what the Commission was going to do because he brought an application to intervene in the litigation about the establishment of the Commission. And so he knew all about it. He made an affidavit dealing with that. Notwithstanding that delay, there was then a further delay. In October, beginning of October 2025, Mr. Zuma learnt that a Rule 3.3 notice had been issued against him. He did nothing he didn't take any step to challenge it. For 2 months, he didn't raise any objection at all to it. He just continued. And he's never given any explanation of it. By then, Mr. Zuma must have known, certainly from the notice, what they were investigating, and he knew who was investigating it. He did nothing to challenge that. Mr. Mbeki is in a worse position. He says that he received the notice on the 25th of September. He raised no objection to Justice Khampepe for nearly 3 months. On 19 December 2025, he launched his application for Justice Khampepe's refusal. And he, as I say, knew exactly what it was all about, better than anyone else. And so we say that the appellants have delayed considerably. Everything is put on this court now that this court must decide the matter urgently because of the time. But what's it caused by? It's caused by the fact that there was no objection raised at the time that the Commission was established. Excuse me. And there was no objection raised at the time when they were issued with the Rule 3.3 notices. Nothing. So now it's all very urgent, and you're told, oh, you must deal with this now, because otherwise we'll be denied substantial relief. We say this. We say the applicants will suffer no irreparable harm if the Commission is now allowed to complete its work. Its findings will bind no one, and if they disagree with the findings, they can vindicate their name in the media. These are two people who have ample access to the media. They've got more access than anyone else. And if the Commission errs, they can bring review proceedings. And so we say that there is no irreparable harm that will be suffered that requires an urgent relief. Then secondly, we say there are no exceptional circumstances which justify a direct appeal or direct access. We submit that it is overwhelmingly in the public interest and the interests of justice that the Commission be allowed to complete its work. And we say there are no exceptional circumstances that justify this court now rushing in and deciding this issue. A learned friend for the first applicant referred to the Ramakatsa case. Ramakatsa case was entirely different. In the Ramakatsa case, what would have happened if this court hadn't intervened is that elections which had taken place and which were allegedly irregular would stand, and the court said, for 4 years, the province will be under the administration of people who were irregularly elected. And the court said, we can't stand for that. The court said that the allegations go to the core of the propriety of the election in the Free State province. And so the court intervened. This is not a case of that kind. Further, we submit that there is no prospect of success in the appeals. I'm not going to deal with the Section 47 issue, which seems to have been done to the death to our, I think, the mounting confusion on the part of all of us. I will say this. Firstly, that the debate today illustrates that there is good reason for this court to await a decision of the SCA before finally committing itself. There would have to be a very good reason for this court to rush in and make this decision without the benefit of the SCA, given the doubt about it. Secondly, we submit that whatever Section 47 means, it must surely apply, given what its purpose is, given that its purpose is to protect the judges in the performance of their duties, and given that under our law, a judge is a judge for life, as Justice Sutherland held in the Sariti case, we say it must surely apply to a judge who is performing judicial service, which includes sitting on a commission, whether or not retired. Secondly, it must apply to an application which attacks the judge's performance of her functions as a justice of this court, which is what is before you today. Thirdly, we say it must surely apply to a case in which there is a personal attack on a judge, who is the only person who can answer it. For example, the allegations of actual bias and as well as institutional bias. And we submit that it's not necessary and not desirable for the purposes of this case to decide whether the Section 47 only applies to proceedings against a judge for the performance of their duties, performance of their service as a judge. It's enough to say that it certainly applies to a case such as this and leave over, including to the SCA, whether it applies to retired judges in other circumstances, whether it applies to judges who are not performing judicial work at all, and so on. So we therefore make the submission that the Section 47 appeal on these facts doesn't succeed. Whatever the meaning of Section 47 mean, it shouldn't succeed on these facts. Finally, in this regard, I need to point out that what Justice Malambo said in the Matata case, in his judgment, he explicitly included in the term judge, judges who have been appointed to perform the functions set out in the Remuneration Act. Then a further reason for dismissing the appeals we submit is that there's no prospect of success in the reviews. We deal with this in our heads of argument from paragraph 79 to 113. We say first, the test for bias in a case such as this is not the same as the test that applies to a court. Someone sitting in a commission of inquiry which has no power to decide rights and obligations and has no power to bind anybody is not subject to the same restraints as someone sitting in a court who's making determinations of rights and obligations. And that's what the Canadian Supreme Court has said. The Canadian Supreme Court in the Baker case, which we quote in our heads in paragraph 86, said, "It has been held that the standards for reasonable apprehension of bias may vary, like other aspects of procedural fairness, depending on the context and the type of function performed by the administrative decision maker concerned." Here, the type of function is not a function of judicial decision making. It is a function of giving advice, looking for the facts and giving advice. One can think of many examples of this. Think, for example, of members of a parliamentary committee who are called upon to decide matters. They come to that committee with predispositions. with political opinions, with political allegiances to their party. They can't be disqualified on the grounds that they're politicians who have political opinions. That's who they are. And the test for bias against politicians on a parliamentary committee would be different from the test again, in respect of a judge sitting in a trial. Similarly, in a commission. We make the observation or submission that in fact there can be given the nature of what a commission does, given that it's there to provide advice, not just to find facts and figures, that there can be a positive benefit if one of the commissioners has some background knowledge of the matter, some institutional knowledge. It's not a disqualifying factor. It can be a positive advantage, as long, of course, as the judge or the commissioner keeps an open mind. That's the test. So we then submit that, I hope it's now self-evident, that Justice Khampepe's role in the Amnesty Committee that has no bearing on what the Commission has to decide. We've hardly heard about the Amnesty Committee today, and for good reason, because the Amnesty Committee had to decide whether particular people should be given amnesty. The Commission has to consider whether there was pressure on the SAPS and the NPA to stop investigating or prosecuting cases. The two are entirely different. A decision that X or Y should or shouldn't be given amnesty has nothing to do with whether members of the SAPS or the NPA were pressured to stop or not to investigate or prosecute a TRC matter. So those are the core submissions on the, oh yes. So then can I move to the SAFU case, which is whether the Commission erred, or whether Justice Khampepe erred in deciding the matter on her own. The SAFU case has been repeatedly referred to, but has not been quoted. I want to read, if I may, to the court what the Constitutional Court said in SAFU. Paragraph 31. Judges have jurisdiction to determine applications for their own recusal. That's the starting point. Then paragraph 32. If one judge, in the opinion of the other members of the court, incorrectly refuses to recuse herself or himself, that decision could fatally contaminate the ultimate decision of the court, and the other members may well have a duty to refuse to sit with that judge. So what is happening, the court says, is that the person impugned makes a decision whether or not to recuse himself or herself. And the other members then say, well, in the light of that, can I continue to sit with you? That's how it works. That's what the Constitutional Court said. And they referred to the Pinochet case in that regard, and they say it follows that if a judge incorrectly refuses to recuse herself or himself, the remaining members of the panel should not sit with that judge, as the proceeding would be irregular. So they don't vote and say, we vote by 5 votes to 1, or by 10 votes to 1, or by 2 votes to 1, that you must recuse yourself. That's not how it works. How it works, is that the person who's impugned decides whether to recuse themselves, and the other members may then say, well, we don't agree with that, we can't sit with you under those circumstances. That's what the judgment of the Constitutional Court says. In the order made by the court, paragraph 2 says, the applicant has failed to establish that, objectively regarded, there are grounds for any of the 4 judges to recuse themselves. That's a finding by the court. But then the critical part, paragraph 3, each of the 4 judges concerned agrees with this conclusion insofar as it applies to himself and declines to recuse himself. So it was the individual judges who decided whether they were going to recuse themselves. It wasn't the court which decided whether they had to recuse themselves. They made the decision and they decided not to recuse themselves. And so the authorities with regard, or the key authorities with the right, is absolutely clear that when a challenge is made to a member of a panel, that member decides whether to recuse themselves, and the other members of the panel then choose their own course of action in the light of the decision made by that member. So there's nothing wrong with Justice Khampepe. Whether by accident or with knowledge of this, she made the right decision. She would have made the wrong decision if she said the decision is going to be made by the 3, because what the law requires is that she must make her own decision, and that's what she did. Then I need to say something very briefly about the complaint about counsel for the Galata group being allowed to lead their witnesses, that this is one of the grounds on which Justice Khampepe should have recused herself, we say that with due respect, it's frankly absurd, because the facts are the following. Firstly, when the applicants objected to this arrangement, the chairperson had a hearing on whether this should be done. The undisputed evidence of Mr. Tlalata in his answering affidavit is that this is what is done generally by commissions of inquiry. If I can give a bit of evidence, I know of that. Thirdly, the undisputed evidence of Mr. Tlalata in his answering affidavit is that the same arrangement has been made with all of the parties who are introducing witnesses to the commission. So there can be no suggestion that this decision shows any bias in favor of the Tlalata group or against the applicants. This is what has been done with all of the parties which have said to the commission, we have a witness and we'd like to introduce this witness as evidence to you. So the raising of this point is, with due respect, a mark of the applicant's desperation to avoid having to provide explanations of their conduct and having to give evidence. It is a complaint which has been raised again and again and again, and it's simply without any substance. In conclusion on this point, I make the following submissions. Firstly, in Rodriguez, the full court of the Pretoria High Court made the findings through Justice Collopin, or Judge Collopin as he then was. They're in our heads at page 006, paragraphs 2 to 4, they are trenchant. There was deliberate obstruction of the National Prosecuting Authority by the police. And the National Prosecuting Authority was interference by the executive at a senior level with the National Prosecuting Authority, and that is why the National Prosecuting Authority didn't prosecute these cases. That's a finding made in the Rodriguez case by the full court in the Pretoria High Court. That's what actually happened, and that's what has given rise to this situation. What the Commission now is to find out is who gave those instructions and why. We submit that it will be a travesty if the Khampepe Commission, now more than halfway through its work, with less than 6 months to go, is now collapsed by the intervention of former President Mbeki and former President Zuma, two of the people who have most need to explain what happened after 2003 and what their role was in it. If it will be a travesty of justice, if the Khampepe Commission is now collapsed, all of the work it's done is rendered a nullity, and who knows what, if ever, will happen to deal with this blot on our history and on our present. We make the submission that it's a trite saying that justice delayed is justice denied. And in this matter, justice has been denied for more than 20 years. As a result of the persistence of our clients, we are finally on the threshold of accountability for what happened. Key players have already given evidence, and others are to follow, including the two applicants in this case. We make the submission that there is no substance in the complaints of bias. The institutional bias was 30 years ago, and it was, for the reasons I've explained, there's no problem in principle with a member of a commission coming to the commission with some knowledge of the context. We've made a submission that's 30 years ago, the institutional bias. The bias based on the alleged participation in the HRIU is meaningless because there's no evidence to support that, and neither does the evidence, and the evidence shows, A, that Justice Khampepe didn't participate, and B, that unit anyway didn't investigate anything related to what the Commission is investigating. It was looking at dockets to get them ready for prosecution, a rather different task. And so, thirdly, the bias relating to the calling of witnesses is, with due respect, utterly without foundation. And fourthly, the complaint that the Commission, or that Justice Khampepe made the decision herself when she shouldn't have, is simply wrong in law. So for all of these reasons, whatever you do about the Section 47 issue, and we submit that the court should do as little as is necessary, as is essential with the Section 47 issue, we submit that there is no basis whatsoever for the bias complaint. There's no evidence to show that Justice Khampepe is institutionally biased, personally biased, or biased in any other manner. And so we respectfully submit that it cannot conceivably, in the interests of justice, for justice to be further delayed and denied. We submit that the Commission should be allowed to continue with its work. If the Commission ultimately gets it wrong, Mr. Zuma and Mr. Mbeki have their remedies. They have their remedies in the court of public opinion. They have their remedies in their ability to go to court and ask a court to say that what the Commission found wasn't justified. There's no need for the whole process to be collapsed now simply because they are concerned about having to give evidence. And particularly we submit in circumstances where they delayed at the lowest 75 and 90 days, actually for 6 months before they took any steps to challenge the appointment of Justice Khampepe to the Commission. They can't do that and then come and try to press gang this court into doing something urgent because they're in trouble. They're not in trouble, they're able to look after themselves, the law will enable them to look after themselves, and the one thing they can do is look after themselves. Those are our opening submissions, Chief Justice.
Thank you, Advocate Butlander. Just assist me, I need to understand your submission about how to deal with the recusal application and how it was handled. Am I correct that that recusal application was brought to the Commission?
Yes.
Which is Justice Khampepe and 2 others. That's the Commission. And is it correct that she's the one who decided it, or is it the Commission that decided it?
I think the evidence shows that she decided.
She decided it. You made some submission about why that was so.
It shows that the evidence that she decided is that she herself signed the decision. There was nothing saying that the other members concurred. She said, I've decided this, I that, and I the other. And in the pleadings, in this case, she doesn't suggest that the decision was the decision of the 3 of them.
Could it be the reason that the whole purpose and activity around that application was against her?
It was indeed.
Right.
It was a classic recusal application saying, here's a 3-member panel, one of these members should be recused, should recuse herself.
So the ruling then, is it the Commission's ruling or is it her ruling?
It's with respect to her ruling. It's her decision. It's not even really a ruling. It's not a ruling of the Commission at all. It's a decision of Justice Khampepe not to recuse herself. Just as it was the decision of the 4 justices of the Constitutional Court not to recuse themselves in the Safu case.
Thank you, Advocate Butlander.
Butlander, just one aspect. I heard you saying that this arrangement with witnesses that have already testified and those still to come is an arrangement with all the parties who intend calling witnesses.
That's the evidence of Mr. Thalata, yes. It's not disputed by anyone.
2 questions. Does this also relate to evidence or witnesses that may be led by the present applicants or not?
Well, one would have to do it to see what happens, but it would be very surprising and would require special justification if the Commission, having said to everybody else, you can lead your own witnesses, we're now to say to the 2 former presidents, but you may not do so. One must assume that the same rule will be applied to all. So there are really 2 sorts of witnesses in a commission such as this. There are witnesses who are contacted, organized, consulted with, and prepared by the Commission's evidence leaders. And the Commission's evidence leaders typically lead them. But there are always, or very often, outside parties who've got witnesses they want to bring. Very often they consult, they prepare statements, they give them to the Commission, to the evidence leaders, and they say, we would like to lead these witnesses ourselves. And the evidence of Mr. Thalata is that in all such cases so far, this has been accepted.
Thank you.
Mr. Butland, I'd just like to clarify one aspect of your address, is that you contend that it would be a travesty of justice if all the work that has happened would come to naught and the clock would have to be turned back. But I understand you premise that on the facts of this particular case. You would accept that if there was a proper case to interpret 47 in the manner in which the applicants want us to, and if that gets us to the merits of the review and we find there's merit in the review, then that is a consequence that must follow.
Well,
But I understood you saying that we shouldn't dismiss it simply because that's the consequences. We should dismiss it because that would be the travesty would be that you would dismiss it in the face
of these facts,
of the absence of a cogent case for, well, either interpreting 47(1) in the way in which the applicants want, and then finding in their favor in terms of the review grounds they advance.
yes, of course, if this court decides that the Section 47 is to be interpreted as the applicants would have it, then the review application should not have been dismissed on that ground. That then leaves standing the question of bias, the other review ground, bias and sitting alone. And that would have to then either be sent back to a court, maybe not that court because one of the members is already committed, but or it would have to be decided by this court on the basis that Justice Rogers has decided. But I need to emphasize that if the Section 47 point is decided in favor of the applicants, that doesn't bring an end to the work of the Commission. The question for the work of the Commission is whether grounds have been shown that Justice Khampepe ought to have recused herself. They say, agter ons kom ook in die kraal.
Mr. Budlander, the test for bias would be reasonable, or is it apprehension of bias by a reasonable person? How would you define it?
Well,
Is
the
that right?
test for judicial officers is reasonable apprehension of bias that would be held by a reasonable, what was held, and was held by a reasonable, or would be held by a reasonable person.
Yes.
It's that double reasonableness test, yes.
Yes. Now, we know this is the opinion of the President, but what weight should we give to, that's the current President I'm referring to, President Ramaphosa. What weight should we give to his affidavit in the High Court where he says, had he been aware of Justice Khampepe's previous involvement with the TRC and the NPA, he would not have appointed her?
We submit that.
Is he a reasonable person who's apprehending bias?
Well, Justice Theron, we don't know what the President knows. We don't know what he's been told. He's probably been told a story about the HRIU, which is without any factual foundation. He's possibly been told a story about the Amnesty Committee, which is without factual foundation. And so the fact that he holds this opinion tells us really with respect nothing unless one knows on what basis he reached that conclusion. And so it is interesting, it is a curious quirk.
Let's interrupt you. Let's look at what he says. He says if he had known about Justice Khampepe's involvement with the TRC
yes.
and with the NPA,
yes.
if
well,
he had known about that involvement,
yes.
he would not have appointed
Well, it
her.
sounds like he was misinformed about her involvement. It sounds like he was misinformed about her involvement with the Amnesty Committee. He wasn't informed that it had nothing to do with the obstruction. And it sounds like he was misinformed about the HRIU, that he was informed that she was a member of that unit when it appears that she was not on the facts before this court.
Let's assume that he wasn't informed of all the details, but he was informed, and this is what he says, of her involvement with the TRC and the NPA at that level. If he says that he had not been, if he had been aware of that involvement, let's assume he means at any level, he would not have appointed her.
Well, if his view is, his position is that if he'd been aware that Justice Khampepe ever had any involvement with the TRC and the Amnesty Committee and with the NPA, he wouldn't have appointed her. One will say, well, that's very interesting, we respect your decision, you would have been entitled to make that decision, but that doesn't provide a ground for accusal. That doesn't justify a conclusion that there was bias. He may, for example, have said to himself, well, we don't know what he said. And I don't want to speculate as to what he said, but what we do know is that it seems he thinks that she was involved with the HRIU, which she wasn't. His opinion, therefore, was based on a factual misunderstanding, and at least one factual misunderstanding. And I'm sure he made the statement in good faith, with the best of intentions, but with due respect, it doesn't assist this court in deciding whether there is a ground for disqualification on the grounds of bias.
The fact that the date period for the terms of reference of the Commission is after Justice Khampepe's involvement with the TRC and with the NPA. Is it possible that information obtained or connections made prior to 2003 could impact on the investigations conducted from 2003 onwards?
I have no instructions on this, but as a matter of logic, it is conceivable that events in 2000, 1999, 1998, impacted on the decisions, on the actions of people who, after 2003, who obstructed prosecutions. It's completely conceivable. Whether the facts demonstrate that, of course, we'll have to see. But I accept that there can't be an iron curtain which slams down on the 1st of January 2003 and says everything before that you can't consider. It may, depending on what it is, be relevant.
Doesn't that impose a potential harm on the part of Justice Khampepe and her prior involvement?
Well, if she had been involved in decisions, or party to decisions prior to 2003, that prosecution should be stopped. Let's say, for example, there was evidence produced of a letter written by Justice Khampepe in 1999 to somebody else in the NPA saying, look, it's time to stop all these prosecutions. They are going to cause political difficulty, they're going to cost us, and lots of people on both sides are going to be prosecuted, and I think we should have no more TRC prosecutions. If there were evidence of that, that would be very material to what happened after 2003, when the prosecutions were in fact stopped. But of course there's no evidence of that kind whatsoever.
Now, I know I might be asking you to speculate in the next question, Mr. Butler. If for some reason Mr. Bulelani Ngcuka was not available to testify at the Commission, and if Justice Khampepe was not the chairperson, what's the likelihood of his deputy being called as a witness before the Commission?
Well, it is highly speculative, Justice Turan, but I think the short answer is from what she said in her ruling, where she said, if I can just lay my hands on it. She says in paragraph 45, President Zuma ignores the fact that the issue of efforts or attempts having been made to stop the investigation or prosecution of TRC cases were not matters that were pertinent before the TRC's Amnesty Committee or indeed at the National Prosecuting Authority during my tenure there. So if somebody else were chairing the Commission and she were called as a witness, she would presumably say, I don't know about this because I didn't see any of this when I was there. She was only there for a year, remember. But she says that certainly had nothing to do with the Amnesty Committee or at the NPA. If called as a witness, she would have to say on the basis of what she said, I know nothing about that. I can't help you, sorry, find somebody else.
Do the respondents say that the applicants have gone far enough to establish Justice Khampepe's links or ties or involvement with the HRI unit?
Justice Turan, may I recount a story? I was once in court where Judge Dennis Davis was sitting, and one of counsel said, "My lord, I can't take the point any further." And Dennis Davis said, "No, you haven't taken it anywhere yet." And that's the situation here. They haven't taken it anywhere yet. It's not that they haven't taken it far enough. They've got nowhere.
That appears to be it, Mr. Butlander. But just before you sit, I think in your main submissions, you said there's no evidence that suggests that Justice Khampepe was involved in that HERU unit. And none of the two applicants tells us anything substantive in that regard. That's what you said.
Yes. Well, the way it happened, the way it arose, Justice Malambo, is that there was an objection raised by Mr. Mbeki and Mr. Zuma to Justice Khampepe's participation. And the attorneys for the Talata group then wrote complaining about this and saying, you can't just raise these things after the event out of the blue. We're just going to tell you that if you're going to object to anybody else, this is the time to do it. And they said, and one of the things they said, I can just read their letter so that I don't misquote it. But they said, it seems that Justice Khampepe had some involvement with the HRIU or something of that sort. I just need to find the letter. You got it? And that triggered, here we go. It's a letter of the 11th of November 2025. And second page, it's at page 001897. And she says, they say, we're concerned that down the road some parties may be preparing further applications that may also disrupt proceedings. In order to avoid more time being wasted, we wish to bring to the notice of the Commission and the parties the earlier roles played by members or staff of the Commission in TRC-related work or matters that might be connected to the mandate. They say we don't think any of them should be disqualified. They then go through them and then they say 12.2, in 1995, Chairperson Khampepe was appointed by former President Mandela as a TRC Commissioner, and in the following year she was appointed as a member of the TRC's Amnesty Committee. But 12.3, between September 1998 and December 1999, Chairperson Khampepe was a Deputy National Director of Public Prosecutions. During this period, she apparently played a role on the Human Rights Investigation Unit, established by then DPP Bulelani Nguka, to advise him on how to handle the cases referred by the NPA to the TRC. It should say by the TRC to the NPA. And that's what sparked off this frenzy of excitement. But that's the closest there is to any evidence that the attorney said she apparently played a role. There's no evidence that she ever played any role, and she denies it.
The apprehension of bias by the applicants, it's not against the Commission, it's against her.
Yes.
Okay, thank you, Mr. Butlander.
Thank you, Deputy Chief Justice.
Could we adjourn convenience break for about 10 minutes before we come back for the rest of the hearing? Thanks.
They were so good.
Yes. Yeah, I can end some freedom. How long do they give you? I think they give 10 minutes. So that to your comrade. Do you remember that day when you were speed reading to them in the parliamentary stuff? Yes. You have to speed read. If they stop you, that's it. Yes, exactly.
What do you mean again? What do you mean? Everyone knows my case. My case is the most simple.
So you're replying?
Yeah, no, she's going, I think.
Oh, you're still going, yes.
15 minutes.
No, 10. Look, 10
minutes. That one you brought it to yourself.
Yeah, but...
Good evening, everyone. Please switch your phones off. Court is about to sit.
Deputy Chief Justice, may I just draw the court's attention to an error in our heads of argument? I wouldn't like it to stand. There's an error in the last sentence of paragraph 93, and the correct position is stated at paragraph 95.4. So the last sentence of paragraph 93 is not correct, and the correct position is stated in paragraph 95.4. Thank you, Chief Justice.
Paragraph 95 is the correct one.
95.4 is the correct one.
Thank you.
Thank you, Deputy Chief Justice.
We will not hear sixth respondent because your issue has not been raised in oral argument. Six.
Seven.
Is it seven?
It's the seventh
Oh yeah,
respondent.
seven. Sorry. You forgive me. Yeah, we will deal with that issue on the papers because there are affidavits filed, isn't it?
As the court pleases.
Your issue.
Okay, if I may just inquire from the court, which of the two issues, because there are two issues that the seventh respondent brings before the court. One is the condonation application.
The condonation.
And then the second, of course, is the explanatory affidavit where we seek particular answers when that issue has, I think, has been canvassed quite a bit.
The condonation. Yeah. This is the condonation.
It's the condonation.
You have nothing else to say?
Well, Deputy Chief Justice, our condonation was also premised on our explanatory affidavit, on why that explanatory affidavit should be accepted by the court itself. So, in fact, what we're asking for was two relief. The first being to condone the late filing of that explanatory affidavit, and then the second is the acceptance of that explanatory affidavit and the contents thereof.
Okay. So you want us to look at both, but on the papers?
I am happy for the court to do that, but if I may just be allowed then to just state what then the conclusion that the NPA would have made on either of the two without taking much time, I could do that in a minute or two.
Okay. No, thank you. Thank you very much. And I think, counsel, for the president, you are just here you've got a watching brief, basically. Thank you. Advocate Mpofu.
Deputy Chief Justice, sorry, if I just asked for that 2 minutes to just give the conclusion of both of what we've asked.
To do what?
To give a conclusion of what the NPA really asked of this court and why it is
But it's in the papers. Is it not in your papers?
There's also the issues that are raised by the Galata group in their papers in the answer that are not in any of the papers because there isn't a right to reply in this court.
Yes.
And it is for that very reason that we would just want to deal with that. So just to deal with two issues on the objection itself, and I accept we have filed heads and we stand by those heads. The first objection that they make is that our affidavit does not assist the court at all because the court is seized with only the Section 47. Well, the NPA says after the debates that you've had and equally after all the papers that were filed, I don't think they would still hold to that objection at all. Then the second and most important of the objections is that the Galata group indicates that there has been a denial of what the NPA has been asking in the explanatory affidavit, which simply put is this. Did Justice Khampepe, at any point in time in deciding the NPA application for the recusal of Advocate Semenya, coach Advocate Semenya, because that has a direct bearing on what the NPA then can do, because Deputy Chief Justice, as you know, the NPA has decided to abide. But unlike the president, they have said, well, our decision to abide is based on the fact that the people who have direct knowledge of the allegations are deciding to keep silent. And they continue to keep silent, even before this court. And it is for those very reasons, then the NPA says, when you then consider our explanatory affidavit and when you consider the case as a whole, think of also the parties whose rights actually will be impacted by that silence. In actual fact, one of the things that we equally say, that silence has a direct bearing, in fact, on the report that will eventually be done by the very person that is deciding to keep silent. If there's ever been any time, just to conclude, if there's ever been any time where the Galata group and the NPA actually should agree on something, it is on this duty of candor, because the commission is there to be a truth-finding function, but in that very breath has refused to, in fact, deal with direct questions. So the NPA hasn't done what other parties have done because it doesn't have the facts. It has asked, are these allegations true? And it does that, question by question. In the High Court, I think Justice Tehran asked my learned friend for the Galata group, what should this court make of the affidavit by the president? Then if that question is true for the NPA, it would be that this court needs to accept that affidavit and also accept that there is absolutely no answer to that affidavit. In instances where both Justice Khampepe and Advocate Semenya have filed in relation to everything else that was before the High Court, except that particular affidavit. So that would be the conclusion to our submissions.
Thank you, Ms. Ntloko.
Thank you, Deputy Chief Justice.
Deputy Chief Justice, I'm sorry to interrupt. This is simply a misrepresentation of the facts, and I need an opportunity to answer.
Advocate Badlander, let's just deal with this. What, do you want to respond?
I want to respond, or perhaps I can draw the court's attention to the paragraphs in our affidavit which address this, where there is the specific denial of coaching is quoted. It's a paragraph.
You're dealing with the silence submission.
The silence submission, yes. It's at page 004-31, which quotes Mr. Macha saying the allegations remain unresolved and unanswered. And we point out paragraph 13.1 in response to the specific allegations of coaching.
Just hold on, Advocate Badlander.
I'm sorry.
Do you mind just taking a seat? Ms. Ntloko, please come back. Looks like you asked for questions. You're going to get them.
Deputy Chief Justice, I'm not sure I did.
Yeah.
I was quite happy to be silent until the Galactic group brought us
Justice
to say
Matopo
something.
has...
I'm not sure what you did and what was the purpose of what you were doing. And because it has left me with many questions, that's why Advocate Badlander stood up to try and clarify what needed to be clarified. What is it that the NPA wants to do?
Thank you, Justice Matopo.
Because unless you express it, I would not know. Perhaps you may have to deal with
what
the
he's
anticipated objection.
Thank you. Well, what the NPA seeks to do is to ask this court to have regard to its rights as well, considering the silence in relation to the allegations that have been made against the chairperson and the chief and business leader. As you will recall, Justice Matopo, the allegations relate to the NPA's application for the recusal of the chief evidence leader. However, the NPA says to this court, I don't have the full facts before you in order to, in fact, either be a party in full force and ask for the recusal or do anything because there's allegations and those allegations are not really met.
But when those allegations dealt with by Advocate Semenya SC?
No, Justice Matopo, they were not. In fact, if I can then take the court to particular portions of what is asked at particular times.
But I recall reading the papers that allegations were made that Advocate Semenya SC was at some point involved with the NPA in some capacity of some sort, advisory role or whatever.
Oh, no, Justice Matopo, I think there needs to be an explanation of this. I think we are actually speaking
I'm
across
confused.
each other, yes. That is not what the NPA is saying there's been silence on. What the NPA is saying there has been silence on is whether or not, when the recusal application against Semenya SC was brought by the NPA, for whatever reasons that recusal was being brought, did the chairperson coach Advocate Semenya? In that, did the chairperson provide Advocate Semenya with cases to utilize in order to answer that application? And secondly, as what is alleged, did the chairperson communicate via WhatsApp to Advocate Semenya on how to attend to particular allegations?
But where would you expect to find that if it's not in the papers?
But these are the questions the NPA was asking directly because the allegation is made, Justice Matopo, by
Well, I
the president.
understand. The allegations were made. And
Yes.
The allegations were made. And at what place or forum would those questions have been answered or would have been answered?
They were raised in the High Court for starters, Justice Matopo, and they elected to not answer them.
But if you recall, it was common cause, or it has been common cause, that the evidence leader and the chairperson would from time to time interact, speak about the conduct of the case, right?
Yes.
And if you would recall, an allegation was made that by one of the applicants that the chairperson coached Advocates B.
Yes.
And I pertinently asked the question, does it appear in the papers in what respects those allegations were supported? I don't seem to have any response, except that the counsel for the applicant said allegations were made, there was a denial, and on the basis of Plascon Evans and White for Construction, we should accept the version of the applicant.
Justice Matopo, I'm not sure there's a complete denial, if we're being honest here.
No, it's not whether you accept whether there is or not. It's whether the principles relating to motion proceedings, what do they tell us? And we would have, at the end of the day, when you consider all the papers, decide whether indeed there was or there wasn't. Allegations were put forward, and what was the response? And on the application of Plascon Evans rules, what is the conclusion that you must arrive at?
Justice Matopo, I think I need to take the court to the particular allegations that are made by President Zuma and then the responses that you get from the Commission, which is what necessitated the NPA saying, well, you have a duty of candor. You need to answer these directly. Did it happen or did it not happen? It's a simple yes or no answer. And this is where this is basically what the NPA says.
I don't understand the role of the NPA in these proceedings.
Well, that might be...
Are you saying what the first applicant is saying about the duty of candor? If what you are saying is what has been said by the applicant, shouldn't we follow the submission by the applicant to say whether what has been put forward before us to make a determination, we should make a determination in line with that submission? Or is your submission different from them?
Thank you, Justice Matopo. It's not entirely different. In fact, the submission in relation to candor has always been the submission of the NPA. That's the starting point. That's common cause. It has always been the NPA that says there is a duty of candor that arises in these particular allegations. The position of the NPA in this court is that it has decided to abide. But in making that decision, it's asking the court that when you make the decision, also have regard to the rights of the parties that are not party to this fight between the applicants and the Commission. More so in relation to what it would mean if the allegations that are alleged against the chairperson and the chief evidence leader are true. That's all the NPA, in fact, is saying. And then saying, because of that, because of the lack of candor, there are issues that the NPA cannot even deal with.
So,
and therefore,
so what instruments would assist us in answering that question? I mean, in terms of the pleadings now, what would assist us in answering that question?
Unfortunately, the long and short answer, Justice Matopo, would be a full Rule 54 record, which is what a full Rule 54 record, which 53, sorry, it's been a long day. It's a full Rule 53 record, which is what we even before the court. In fact, the first applicant, Mr. Zuma, President Zuma, indicates that we, in fact, even at the High Court, the NPA, when I say we, indicated why it was prejudicial not to have the full record, because the full record would then have determined what our rights and obligations are. If it turns out that there's no truth to this allegations, the NPA is not a party, it just backs off. But if it does, then let's play this out. If you file the full Rule 53 record, and the Rule 53 record shows that these emails and these alleged, let me use alleged, these alleged emails and SMSs exist, you can then accept that they directly affect the NPA's rights, because the NPA was the party that had brought that application.
Can I please interrupt you?
Yes, Justice Matopo.
For the purpose of this hearing,
yes,
if we were to be attracted to the proposition that you are advancing, what would you want or prefer our order to include? Because you're talking about the Rule 53 records, but I just want to know, at the end of the day, if you are the NPA, what would you want the order to include?
This is the beauty of where we sit. We haven't asked for particular relief. We've just asked that the court have regard to the fact that if the Rule 53, let's now deal with the different scenarios, Justice Matopo. They say this court decides for the applicants on the section 47. And as I said, we make no comments on that. And then you get to the review itself. When you get to the review itself, one of the things that this court would have to actually then, in fact, make a finding on is whether or not that record is complete. And as things currently stand, the NPA does not know.
Are you saying if there is no Rule 53 record that has been produced, we would not be in a position to make any ruling on the review itself?
If there was no record before you whatsoever?
Yeah, we would not be in a position to make a ruling on the review.
No, that's not what we're saying. I think it's more nuanced than that.
Maybe I should stop.
Well, I think let me just then finish the more nuanced than that. You have a Rule 53 record before you. It's just not complete. My client is abiding because they don't know the full facts. Those would have been facts that they would have known if the record was complete. On the other hand, I cannot speak on what the applicants would want you to do. On the applicant's version, they might well say, and we take no side to it, they might well say, you have enough before you on the record that it stands in order to make a particular decision. What the NPA is saying is that it would have been beneficial for all parties, including the other parties that have decided not to participate here, to have the full record so that we can all then determine how we exercise our Section 34 rights in this particular proceedings. That's all the NPA is saying.
Thank you very much.
Thank you. And I'm not sure, Justice Matopo, if you want the particular references that my learned friend for the Alada group. Then that's perfect. One would hope. And then that would be our submissions.
Thank you, Ms. Ntloko. Thank you. Do you still insist, Advocate Bartlander?
DCJ, can I just give the reference to the record? It's page 004-31.
Do you think we could impose ourselves on you to ask your junior to send us that short little thing that tells us those references?
You mean on the screen?
Yeah.
Yes.
On the screen or in writing? I think in writing.
Well, can we just submit, send after the hearing?
It's not an invitation for further submissions.
No submissions.
It's just those
We'll just
references.
send that one page.
That's fine.
Thank you, Deputy Chief Justice.
Thank you.
Deputy Chief Justice, can we equally then be given that opportunity to just send its references? We will not say absolutely anything. We'll just send you the reference of this is the allegation, this is where it's answered, this is the allegation, this is where it's answered. We are not going to make any submissions whatsoever, and I think that should also be fair for our learned friends, because what they're saying is that we were not they're saying we misled the court because that the references say something else.
That's fine.
Thank you.
No submissions, just references.
Just references for both parties.
Thank you. Advocate Mpofu.
Justices, let me just do this really. Hopefully, in reply, I just want to deal with what our case is.
It's 10 minutes.
Yes, thanks.
Yeah.
On the Section 47 issue, because from what I was listening to, it looks like our case, there are certain parts that are not clear. If you go to our heads of argument 006, 1.1.9, and I'm addressing now Justice Rogers' points, one of which he said was not raised. It's raised here. But secondly, I agree, just in case I forget, I agree with Justice Rogers' approach on the question of direct appeal. And that is vindicated by, if you look at page 1 of all these big documents, the very first page, you'll see that there is our notice of application for leave to come here. It says exactly, it deals with what Justice Rogers was talking about, which is, firstly, it says notice of urgent application for direct leave to appeal in terms of Rule 19. So that's what it is. And then it says read with Rules 12 and or 18. In other words, the question of direct access may just be surplusage. But if you go to page 2, you'll see the reply covers what Justice Rogers was talking about, where one of the prayers we want to say, granting us leave to appeal for upholding the appeal itself and granting the relief sought. So that covers, we agree that it may not be necessary to even deal with Rule 18 per se. But the issue that is raised by Justice Rogers about the expression, one of the honorable justices, I can't remember, I think it was Justice Dambuza, and I made this note, thank God Justice Rogers then came to the rescue. Because what was being said is that the section talks about any judge, and therefore it's wide. But that's, the point is made very clear. The expression we talk about is not any judge. It says, this court, this is what I'm reading now, paragraph 15 of our heads. This court is called to answer the following crucial and separate interpretational questions. 1, first, does the expression any judge of a superior court, as it is, as used in the section, include retired judges? And that's Justice Rogers' point. I don't need to develop it. So is the expression any judge of a superior court? Because any judge could mean any judge, but I don't need to repeat what was said. So that's the first one. The second one, we say, in the case of retired judges, does the court accord interpretation of the phrase, the head of that court? Because those two goes together. Any judge of a superior court and the head of that court both fit in snugly with what Justice Rogers was, the point he was making. And then we say third, does the section apply when a judge, whether active or retired, is specifically cited nomine officio, which is a separate point. And let me just pause here. One of the reasons, and I can't remember which justice, I'm just rushing for time, about not having to go to the SCA is exactly this point, that the Mantashe case, we've made this point, we can't just go and join that case, because that case deals with a narrower issue. It doesn't deal with all the issues that are raised in this matter, which are retirement, citation, this issue of a superior court, the civil proceedings, and so on. So even if you join that court, we would just be cutting ourselves in the foot, because it's them who should be joining this case and deal with their portion, not the other way around. And then fourth, we say, is it contextually permissible to interpret section 47 by transplanting the definition, that's the cut and paste point that's been made, and I think considered somehow, but just now by Mr. Badlander, that the issue of service is no longer pursuing. And then the fifth, we say the fifth, was it the effect of decision, what is the effect of decisions such as NP versus LP, Corruption Watch, Zuma versus Secretary for State Capture, and so on. I've made those points. That's the points about Mlambo JP, because if you're Mlambo JP and Menenge JP, if you are saying, as one of the defenses that has been offered here, a judge is a judge, then you are saying both Mlambo JP and Menenge JP are wrong, because both of those judges have said explicitly that the section applies to retired judges only when they are recalled to perform judicial functions. But a judge is a judge means even if they're just sitting somewhere there, it covers them. Nobody can argue that seriously. And then we say, Justice Tabuza, I think, made this point. The distinction in 1762 cannot be wished away. Because if you say a judge is a judge, it means you're saying that distinction means nothing between active service and the holding of office until the end of that. And then we then deal with the thing about civil proceedings by way of notice of motion. We've dealt with that. And then the eighth, we say, finally, Section 47, truly a jurisdictional provision. The importance of that is that, remember, the alleged mootness of our Rule 53(1)B application, which Ms. Nkoko is correct about, has never been answered, never been answered. Talk about candor and every scrap of paper. The mootness, the alleged mootness, is because of the mistake that takes Section 47 as a jurisdictional point. Because it says, well, if you don't have jurisdiction, we don't even have to give you anything, candor or no candor. But that's incorrect. The next point is, okay, the most important point is Justice Rogers' point about what he called the more mundane purpose. We had said earlier, I think, something the less loftier purpose. But that's the point, because the confusion here seems to be made between this section being this bulwark and protector of judicial independence and what have you, whereas the section is simply to do what the judge president said it was to do, which is to regulate the courts. Well, justice delayed is justice denied is the other defense. Well, we say justice cuts both ways, I'm afraid. So which justice, what justice can emanate from a commission that is tainted by bias in all the various ways that I have? What justice for the victims? What justice for our clients? Zero, as we said. So whether it's delayed or whatever, the only thing that can happen is to put good money after bad money and spend more millions on something that, as we said, is doomed to fail. Very quickly, Justice Matopo, on the issue of Ramakatsa. We say not Ramakatsa, the Zuma case. This court had said that that case was urgent and required direct access. That I'm talking about the Zuma case. And on the basis, one of the reasons cited was that a former president of all people is of all the things that were said there. Now we say here the jeopardy is double of that, because there are two former presidents who are in danger of being forced into an illegal gathering. Now, then there's the issue about, I think it was Justice Theron, or it was raised by one of my learned friends as well, that where the Justice Khampepe says that I'm not performing a judicial function, that it was her opinion. But that's the point we're making. It was her opinion that she's not performing a judicial function, but her opinion today is that she is. That's what's wrong with this picture. And then the issue about temporary boundary, Justice Matopo, 100% correct. The 2003 thing is a red herring. 2003 is the point at which it is alleged the interference bore fruit, if you know what I mean. Remember the terms of reference say commission into investigating into the stopping of the prosecutions. So the stopping of the prosecutions may have stopped in 2003, but the interference obviously preceded that. Then, if I may just make these 2 points, Justice. One is there's a case called Dupree versus TRC. I'm not sure if it's on our list. That case is a 1997 AD case, made it plain that the rules of natural justice apply in the TRC. which is a commission of inquiry. Then this is the point that I really want to make. There's a lot of
No, you said that what's the other point?
Okay.
The last one.
Yes.
Yes, what is it?
There's this thing about HRIU that was raised here. It's another red herring argument. Remember, Justice Theron pointed to the President's affidavit. That paragraph, that affidavit, because I don't have time, I won't go to it, has a paragraph 9. Paragraph 9 has 9.1, 9.2, 9.3, 9.4. Those are the things that the President says, if he had known those things, he would not have appointed. Only one of those things, actually half of them, is the HRIU, because the other one is that she worked at the Amnesty Commission. But on top of that, we've given a list in our affidavit of other TRC commissioners who, like Ms. Suka and Advocate Ntsabeza and so on, who are called as witnesses. So let's say for a minute, and Mr. Manesha will address
that's the point, isn't it? That's the point. You've made the point.
Well, I haven't made the point.
No, you've made it. You want to go further than you were asked to do.
Yes. Okay. The other point about Justice Nuku's issue about what should happen, assuming what we are only dealing with is the failure. Well, Section 6.2G of PAJA covers that, because it says what is reviewable is not only the administrative action that's positive. The failure to take action is also on its own right reviewable.
Thank you, Advocate. Thank you very much. Thank you.
Please give me half a minute.
Thank you very much.
I promise, half a minute. And the point is this, and this deals with also Justice Dambuza's point, I'm sorry, that, and someone else said this, the protection of judges against vexatious litigation outside of this scope is the same as all of us. We're all protected against vexatious litigation by the Vexatious Litigation Act, abuse of court, and so on. So there's nothing that should be extra protection outside, as Justice Theron puts it.
Thank you.
Beyond the ambit of this section. Thank you. I'm indebted to the point.
Thank you very much, Advocate Mpofu.
Thank you,
Just go ahead when you're ready, Advocate Manager.
Yes. The first point I want to deal with is and I have great respect for my learned friend, Mr. Badlender, and I believe he didn't deliberately misconstrue our case, but he misconstrued our case in relation to the role of the chairperson in the NPA. And in the arguments he presented, as well as the argument our learned friend, Ms. Sarah Pudifin-Jones presented, it underscores the error that the justice made in deciding the recusal application. They both argue that this court must look for an overlap in the questions that the commission must investigate and the questions that the chairperson dealt with when she was in the TRC and the NPA. That is the wrong test. Of course, if there was a complete overlap, she would be disqualified. But that's not the end of the inquiry, and that is what Safu and Bennett emphasizes. You look at whether the subject matter before the commission arises from her prior roles. And I want to show the court what was pleaded on her prior role in the NPA. It is at 011-893-894. Sorry, 001-893 to 894. And that is, you will see there that the allegations about the role in the NPA is dealt with from paragraph 23 to paragraph 34. And there it's set out at paragraph 23, and I'm going to read quickly. Justice Khampepe served as Deputy National Director of Public Prosecutions under Advocate Bulelani Ngcuka from September 98 to December 99. This period coincides with the establishment and operationalization of the human rights of the HI unit. The HI unit's mandate was to review TRC amnesty records, investigate apartheid-era human rights violations, and make recommendations on the prosecution of TRC cases. As appears from the Webber-Wenzel letter, Justice Khampepe played a role in the HIU, including providing advice to the National Director of Public Prosecutions on the approach to TRC matters, and so it goes, and the court will read all of it. That's what it said, is she provided advice. It's not you were a member of the HI unit, full stop. And what is the answer by the Commission? You will find the answer at 011-1215. 011-1215, at paragraph 35 specifically, you will see that that allegation is recounted, is never denied, never ever denied, that she advised the National Director when she was, of course, in the office of the National Director under Section 5 of the NPA Act. In paragraph 20 of her own ruling, the chairperson, at 001-269, she says the evidence regarding her prior roles is common cause. So it's common cause what we say there. There's no denial. And in that context, then you look at what Judge Saldanha and Advocate Bulelani Ngcuka have been asked to testify on. The request to Justice Saldanha, the court will find at 011-619. I'm just trying to find, you will see that what he's asked to do at 011-336 is paragraph 3. In your capacity as a commanding officer of your particular unit, you have had access to information concerning decisions, discussions, or policies affecting the investigation and prosecution of TRC-related cases. The Commission therefore requests your assistance with furnishing any material in your possession on to which you had access to during your tenure that may be relevant to its inquiry. 5, in addition to providing such relevant material, the Commission requests in the form of an affidavit your own account of any discussions, decisions, or considerations during your tenure that may bear on the matters set out in the above-mentioned paragraphs of the terms of reference. Such a statement will assist in the Commission in understanding the context within which decisions relating to TRC cases were taken. Just Advocate Ngcuka's statement, they didn't include the letter. We've got the letter, but it's not in the record. It's similar to that letter that I just read. But you will see that he recounts what he's asked to do at 011-619. He says, 13, a year later, I was appointed as NDPP 1 August with effect from 1 August 1998. 14, on its 11 October letter, the Commission requests my assistance by furnishing any material in my possession to which I had access during my tenure and request my account of any discussions, decisions, or considerations relevant to the Commission's terms of reference. This is what they're asked to do. These people were serving with Justice Khampepe in the NPA at the same time with the NDPP in his office because Section 5 says she is. She doesn't dispute. In the High Court, there is a belated denial. At paragraph it's paragraph 243 in the High Court application, 001-493, simply saying, I deny that I was a member of the is you advised, you played a role in relation to TRC cases, which was never disputed and is never disputed. This is a belated denial, which is itself unhelpful. In regard to TRC cases that Justice Khampepe decided where amnesty was denied, the extracts from the archives are included in the affidavits. You will find them at 001-327 in relation to the AC 37, 001-336 in relation to the Mutasi family, is part of the Kalata group, 001-339 in relation to the PEPCO 3, is part of the Kalata group. On delay, The question on how you decide delay is set out in paragraph 74 of Bennett, is a question of interest of justice. A party, after full disclosure, is not allowed to wait until an adverse decision to raise recusal, because it would mean if the decision was favorable, there will be no ground for an apprehension. Here, there was no decision adverse to our clients before they brought the application for recusal. They were not participant in the recusal of Advocate Semenya SC, so there was no adverse decision at all, which was the suggestion. In addition, the delay is of 3 months, under 3 months, because in May, there were not interested parties to the commission. You will see the terms of reference identifies the interested parties. The only time they had an obligation to assist the commission and to appear before the commission, in the case of Mr. Mbeki, was when he received the notice 3.3 in September of 2025. So the delay is under 3 months. In Salfu, the delay after full disclosure was over 3 months. You will see that at paragraph 7 of Salfu. In Bennett, after full disclosure, there was a delay until an adverse decision was taken by the SCA. In both of those cases, those judges made full disclosure in order to allay the fears of any bias. In our case, even this court is in the dark about what role did Justice Khampepe play in the NPA in relation to TRC cases. You've been referred to paragraph 78 of the answering affidavit of the commission in the High Court, in the review. You will read those paragraphs. They're all argument. There's no disclosure of facts. It's just argument about why this does not make out a case for review. On the standards of bias as between commissions and the like, my learned friend referred to Dupree, but our learned friend, Mr. Badlender, so rightly, with the respect that we hold him in, that you still have to approach it with an open mind. And complaint about an apprehension of bias goes directly to an absence of an open mind. So we agree with him. On Rodriguez, yes, Rodriguez has made scathing findings against the executive without hearing them. That is why you have a commission of inquiry. If Rodriguez was binding about the executive interference, you would not have a commission of inquiry. That would be carried quaestio, if that is the correct expression. Then there is a suggestion that the arrangement about the hearing of evidence was all dealt with and it covered all parties. You will read the account properly in the affidavits. The secret arrangement between the Kalata Group's counsel and the chief evidence leader was only disclosed at a pre-hearing meeting. All the parties objected. It resulted in written submissions, argument. All the chairperson did was to endorse that arrangement. And in the meantime, Advocate Semenya was told not to interview NPA witnesses. He did. And she didn't reprimand him when endorsing all of that and finding that his recusal must fail. So we submit with respect. And on the section 47, and that's my last point, there is no answer to the contextual reading of the section which the bench has put up, especially Justice Rogers and the other justices of the court. And we are really indebted to that insight which we may not have picked up to assist the court in making a proper determination on section 47. We submit on all the circumstances that this appeal should succeed in all respects and the review should be determined in our client's favor. We ask costs, but that's in the court's discretion. Those are our submissions, and are truly, truly indebted to the court to have extended its time until this time of the day, as the court pleases.
Thank you very much, Advocate Manager.
Deputy Chief Justice, I'll say nothing about the NPA or anything about this case at all, I promise. We've been informed that this is the last matter in which Justice Majid will be sitting as a member of this court. And I've been authorized by my senior, sitting over there, to make some remarks about it. He says I may not be senior, but I'm older. That's what he says. It's going to be a great loss, not just to the court, but to all of us, Justice Majid, when you leave. I think we've all appreciated your sharp insights. We've appreciated your passion for justice, and particularly your passion for those who sometimes can't speak for themselves. And we've appreciated your passion for the transformative goals and transformative ideals of the Constitution. We know you've written judgments about that. We know you've spoken about it extracurrially. And we all greatly have valued and appreciated that. I think we all have also greatly valued and appreciated the way you have managed us in court. You've done so always with courtesy and firmness, and often with a spark of wit, which has greatly solved some difficult situations. So I'm sure I speak on behalf of all of us when I say that we thank you for your service to the court and to the country, and we wish you a very lengthy and very happy and very fruitful retirement. Thank you.
Thank you very much, Advocate Bartlander, for those sentiments expressed about our brother. As he says, the proper time when all that we want to say will come at the end of the year. But thank you very much for recognizing that. We recognize it. We will also miss him. We tried our best to twist his arm not to go, but he's going. That said, this brings us to the end of today's proceedings, and the court adjourns. Judgment is reserved.